31st, 2020 to stop using your perk machine.
네, 첫 번째로 법률 1421에 의거해서 작년 12월 31일 20년까지 펄크의 사용을 금지해야 되는 게 법률이었는데요. 그거에 대해서 위반이 됐다는 것을 먼저 인정을 하고 그 다음에 진행을 하도록 하겠습니다.
The second finding is an important one for this matter, and that is we need to find that your non-compliance today is due to conditions that were beyond your reasonable control.
네, 두 번째는 중요한 문제가 되겠는데요. 선생님이 그렇다면 왜 그 법률을 따를 수 없는 어쩔 수 없는 상황은 어떤 것이었는지, 어떤 상황으로 인해서 그 법률을 따르지 못했는지에 대해서 말씀해 주셔야 됩니다.
And unfortunately, your petition is blank for a lot of the relevant information that we need, and so you'll have to provide it today. And in particular, when we are looking at beyond reasonable control, we have to look at three different factors. Number one, what did you do in order to come into compliance since the rule was adopted? And that was 18 years ago in 2002.
네, 첫 번째로 선생님이 보내주신 그 신청서를 보면 많은 공간이 비어 있는데요. 그래서 저희가 질문을 하면 그걸 답해 주셔야 되고요. 가장 중요한 것은 이 법률 1421이 2002년도에 제정됐는데 그 이후로 선생님이 법률을 따르기 위해서 어떤 행동을 하셨는지, 어떤 노력을 하셨는지를 저에게 알려주셔야 됩니다.
But also because you are a small business, we look at two additional factors. Number one being any reasons why you may not have known about Rule 1421 and when you did become aware of it.
네, 그리고 선생님이 두 번째로 소규모 자영업자이기 때문에 선생님이 만약에 이 법률 1421에 대해서 모르셨다면 왜 모르셨고 그 다음에 언제 이거에 대해서 알게 되셨는지도 말씀해 주셔야 됩니다.
Also, we look at your financial and other capabilities to comply with the rule.
네, 그리고 선생님이 지금 현재 이 법령을 따르지 못하는 경제적인 이유가 어떤 건지, 어떤 상황에 처해지셨는지를 잘 설명해 주셔야 됩니다.
We're going to look at what is the harm to your business if you do not receive a variance today.
네, 만약에 연장 허가가 되지 않는다면 선생님의 비즈니스에 어떤 타격이 입을지 선생님이 또 설명해 주셔야 되고요.
And then we have to weigh it against the harm to yourself, your employees, and the community at large from using a toxic air contaminant perk.
그리고 그것의 무게를 선생님과 선생님의 직원들, 그다음에 지역 사회에 안 좋은 영향을 펄크 사용으로 인해서 안 좋은 영향을 미치게 될 결과에 대해서 어떤 것이 더 중요한가 그 무게를 저희가 달아보아야만 합니다.
We look at your ability to curtail your operations, meaning can you send your cleaning to a compliant facility? Do you have another compliant facility? And what you're willing to do to reduce excess emissions of PERC to the greatest amount possible.
그리고 펄크의 사용을 줄이기 위해서 선생님이 어떻게 노력하실 수 있는지, 예를 들어서 선생님이 가지고 들어오는 세탁물들을 그 펄크 기계가 아닌 법에 허용된 기계를 사용하는 세탁소로 보내서 처리할 수 있는지, 어떻게 하면 그 펄크의 사용량을 계속해서 줄여가실지 또 설명해 주셔야 됩니다.
And I'm going to stop my share of my screen. And then finally, we're looking in all of these cases for a path forward to compliance. So what are your plans to come into compliance with the rule?
네, 결과적으로 가장 중요한 것은 선생님이 지금 이 법률을 따르기 위해서 어떤 노력을 하고 계신지, 앞으로 어떻게 노력을 해서 이 법률을 따르려고 하실 것인지에 대한 자세한 설명을 해주시는 것이 좋습니다.
And with that, Mr. Sun, if you'd like to give us a brief summary and opening statement of your position, you can do that now. Oh, I didn't swear him in. Thank you. Is that what you're going to say, Mr. Balagopalan?
네, 선생님.
Yes. Let me swear him in. If Mr. Sun, if you could raise your right hand.
오른손 들어주시겠습니까? 선서하겠습니다.
Do you swear or affirm under penalty of perjury? Thank you, and all other witnesses as well who may testify today. Do you swear or affirm under penalty of perjury that you will tell the truth, the whole truth, and nothing but the truth?
네, 위증의 죄를 포함해서 선생님이 오늘 하실 증언이 온전한 진실이고 완전한 진실이고 오직 진실만을 말할 것을 선서하십니까?
네, 예.
Okay, thank you. Now, Mr. Sun, if you'd like to give a brief summary and opening statement.
네, 선생님, 지금 선생님이 이 허가 요청을 하는 입장이 무엇인지 간단히 좀 말씀해 주시겠습니까?
팬데믹으로 인해서 은행에 론 받기가 힘들어졌어요.
네.
그래서 좀 연장해 주시면은 그렇게 하고, 또 하나는 저희 교회 한 멤버인데 그분이 12월 달에 이제 문 닫고 이제 가게가 정리가 되니까 그 기계를 픽업에다가 쓰면은 좋겠다고 그래서 타업이 이루어졌기 때문에 1년 연장을 부득불 했습니다. 그거 이유입니다. 다른 거 없어요.
First of all,
Please let Mr. Sun know he can lower his hand.
선생님 손 내리셔도 됩니다.
네,
Thank you. Go ahead.
처음에서 모릅니다.
예. First of all, it was really hard for me to get a loan from the bank due to the pandemic. And one of my church member owns a cleaner, and he's planning to close down his business in November. And he has a machine that complies to the rule. So I was looking forward to acquire the machine when he closes down. So that's why I asked for a 1-year variance.
Thank you, Mr. Sun. I'm going to turn to Ms. Pruitt to hear the opening position and statement of the district.
Thank you.
감사합니다.
Good morning, Chair Prusik and members of the board. Good morning, Mr. Sun and Mr. Lee. Mr. Lee, if sometimes I get on a roll, if I begin to go too quickly, could you just flag me by raising your hand or something and I will slow down?
Sure, I will. Thank you.
Thank you very much. Good morning. Before you this morning is a petition for a regular variance seeking relief from Rule 1421, specifically the provisions that prohibit use of a PERC dry cleaning system after December 31st, 2020.
네, 아까 말씀드린 것처럼 법률 142일에 의거해서 작년 12월 31일 2020까지 펄크 사용을 금지해야 되는 것에 관해서 오늘 이야기하는 히어링이 되겠습니다.
감사합니다.
Thank you. This petition is one of several requests seeking similar relief, as stated in earlier hearings by my colleagues.
네, 선생님과 비슷한 처지에 처한 분들이 이런 공청회 신청을 하고 있는데 그 중에 선생님도 하나가 되겠습니다.
Thank you. And the district is reviewing these petitions on a case-by-case basis. And after evaluation of this particular petition, the district is unable to make a recommendation at this time as it was deficient in much information that we would need.
네, 디스트릭이 항상 이 평가에 대해 선생님 보내신 신청에 대해서 평가를 하고 있는데 지금 선생님이 보내주신 평가에 대해서는 정보가 많이 부족하기 때문에 현재 이 디스트릭 쪽의 입장은 선생님의 신청 허가를 반대하는 입장에 있습니다.
First, the petitioner, as far as I've been able to see, has not sufficiently shown his burden that non-compliance with Rule 1421 was beyond his reasonable control.
네, 일단 선생님이 어쩔 수 없는 상황이었다는 걸 잘 증명하셔야 되는데 보내신 서류에 의하면 선생님이 얼마큼 노력을 하셨고 그 보내신 자료에 의거해서는 충분하지 못하다고 판단되기 때문에 반대를 하고 있는 입장입니다.
And at this point, I have no evidence that he would have been able to comply with the December 31st deadline, but for some financial loss that happened in 2020.
네, 지금 보내주신 자료에 의거해서 보면 선생님이 2020년에 이 기계를 왜 구입하지 못했는지 어떤 경제적인 어려움이 있었는지를 잘 설명하지 못하고 있습니다.
And it's my understanding that the petitioner's PERC machine was manufactured in 1997, making it approximately 24 years old.
네, 제가 알기로는 선생님이 사용하고 계시는 펄크 머신 기계가 1997년에 제작된 기계이기 때문에 24년이 지난 기계로 알고 있습니다.
And absent any other evidence, I believe that he has had, many years or decades to replace the machine to be in compliance.
네, 그래서 보내주신 자료에 의거해서 보면 선생님이 24년이라는 기간이 있었기 때문에 그 안에 충분히 팬데믹이 터지기 전에도 충분히 이것을 구입하고 이 법률을 따르실 수 있는 기회가 있었다고 보여지는데 이 자료로만은 어려움이 충분히 보여지지 않고 있습니다.
And lastly, the petitioner has requested a year variance. And as of this point, I am not clear on his path to compliance.
네, 그리고 마지막으로 선생님이 1년 연장 신청을 하셨는데요. 그 1년 동안 선생님이 어떻게 해서 이 법률을 따를 것인지, 어떤 노력을 하실 것인지에 자세한 설명이 없어 보입니다.
Thank you. And at this point, the district will await any testimony speaking to the issues to see that he can make the findings, and we will reserve a recommendation until that point. Thank you.
그리고 이 이후에 증인들이나 증거들이 제시해서 나오는 이야기들을 한번 확인해 보고 저희 입장을 마지막까지 보류했다가 결정을 내리도록 하겠습니다.
Thank you. I want to mark, we did receive, should we get to that stage, proposed regular variance conditions. And I want to ask Mr. Sun if he received these conditions and was able to understand them.
네, 선생님 여기서 보내주신 지금 조금 전에 그 자료가 선생님이 그 허가 신청을 하셨던 자료인데 그걸 받으셨었나요?
허가 신청서 뽑아가지고 컴퓨터에서 뽑아가지고 신청을 했습니다. 보내준 거는 못 받았고요. 그래서 그거 신청하다 보니까 지금 설명해 주신 것처럼 한국말로 그 번역이 되어 있었으면은 저희가 이해가 잘 돼서 그렇게 마음에 들도록 해드릴 건데 영어 실력이 짧은 데다가 이해가 안 되고 그래서 심지어는 그 뽑은 그 서류 신청서를 가지고 변호사에까지 갔는데 변호사도 모른답니다. 이게 처음 해본 서류인데 이해가 안 된다고. 그래서 그냥 아는 데까지 적어서 보낸 거이 사실입니다. 그래서 아마 많이 부족할 거예요. 법대로 처리를 바랍니다.
I don't think I received the document that you just showed. When I apply for the when I fill out the application for the hearing, I download it from the computer. But then I'm not good at English. I'm not fluent in English, so I have very limited understanding of the petition form. So that's why a lot of questions were left blank. So I seek help from one of the attorney that I knew, and I showed him the application form for the hearing, and even he didn't understand how to fill that out. So it's you. Please forgive me if a lot of the questions are left blank because I couldn't understand the question, so I couldn't adequately answer the questions on the application.
That's fine, Mr. Sun, and we will ask you those questions today if you don't supply that information.
네, 괜찮습니다. 선생님 모르실 수 있고요. 거기서 빈자리로 남겨졌던 질문들은 오늘 할 테니까 그거를 설명하시면 제가 통역해 드리도록 하겠습니다.
And I'm going to mark the exhibit, the proposed conditions as Exhibit A, and we will go over those both in questions and should we grant a variance, we will go over them in Korean for you.
네, 방금 보여드린 proposed condition이라는 그 폼이 있는데요. 그걸 증거물 1호로 채택하고 그 다음에 선생님이 이따가 거기에 대한 질문을 하시면 답변을 해주시면 되겠습니다.
예.
Okay, so at this time, Mr. Sun, if he would like to give us more information, anything he wants us to hear, for example, about how long he's had his dry cleaner, what, if anything, he had done in prior years before the pandemic to try to come into compliance with 1421, and what has happened to him since the pandemic, and what his plans are for compliance. and anything else he'd like to tell us, but if he can add those things in as well.
네, 선생님 질문을 해드릴 텐데 몇 가지 일단 선생님이 몇 년 이 비즈니스를 하셨고 그다음에 팬데믹이 일어나기 전에 어떻게 이 새로운 기계를 구입하려고 노력을 하셨으며 그다음에 선생님의 비즈니스가 이 팬데믹 이전과 이후로 어떻게 바뀌어서 선생님이 어떤 어려움을 겪고 계신지를 좀 설명해 주셨으면 좋겠습니다.
그러니까 저희가 사갈 때는 12,000불 매상이라고 그래서 사갔는데 하다 보니까는 12,000불도 안 되고 그러면서
언제 제일 처음에 비즈니스를 매입하셨죠?
그 포문하러 이사 간 지는 1996년 9월 달에 갔을 겁니다.
예.
그래서 이 지금 퍽 기계는
네.
언제 샀냐면은 1월 25일 날 1998년에 샀습니다. 지금 쓰는 기계.
예. 그 다음에 어떤 어려움이 있었는지도 같이 말해주세요. 그 전에
예.
어떻게 됐고, 그 다음에
예. 매상이 전혀 처음 매상 12,000불 정도 된다 그랬는데 12,000불도 안 되고 그래서 제가 열심히 기술을 배웠습니다. 그러면서 1년 지나고 그러면서 직원들을 다른 데로 보내주고 그래서 직원 한 사람만 데리고 이제 일을 하다 보니까 일이 그래도 좀 되어가고 그래서 괜찮아다 했는데 매상이 한 8,000불로 내려앉으니까는 점점 한 사람 기계 월급 주고 그렇게 하니까는 기계 살 여분이 안 생기더라고요. 가게세 내고 뭐 세금이 없는 것 같았는데 세금 이런 것 저런 거 내불면은 그거가 한 3,000불 돈 나가고 그렇게 저렇게 하니까는 지금까지 오다 보니까는 기회가 안 됐고 팬데믹이 온 데는 또 지금은 3,000불, 4,000불밖에 안 됩니다. 금년 아마 세탁물 빠는 거가 한 거반 절반으로 줄었다고 보시면 됩니다. 그래서 그런 어려움이 있습니다.
네, 알겠습니다. So first of all, when I bought the Pomona business in Pomona, this location, it's in 1996, September of 1996. And then I acquired the perk machine that I'm using right now in January 25th of 1997. When I first bought the business, the person who sold me the business said that the sales would be exceeding 12,000 a month, but then it wasn't as described. So it was way lower than that. So I had to learn all these different skills to operate the business, and the business picked up a little bit after that. And I had a one employee I was working with, and after business picked up, I was doing okay. But then after pandemic hit, my income dropped more than 50%. So I would estimate around 3,000 to 4,000 a month currently, and including all the expenses and rent in Texas, I couldn't afford to buy a new machine.
Would Mr. Sun like to say anything else, or should I pass it on for questions?
더 하실 말 있으십니까? 아니면 다음 질문으로 넘어갈까요?
다음 질문해 주십시오. 할 말이 없습니다.
You could proceed to the next question.
Madam Chair,
Yes, Dr. Bernstein.
I just wanted to note that if I go off camera, I'm still in attendance of the meeting. Thank you.
Thank you. We will take notice of that in the public hearing. Okay, I'm going to turn to Ms. Pruitt, who's going to ask you some questions, Mr. Sun. You are muted, Ms. Pruitt.
I apologize. The telepathy wasn't working today, right? Mr. Sun, you took the oath today, correct?
선생님 오늘 선서를 하셨죠?
예.
Yes.
Thank you. And could you tell me, how long have you been in the dry cleaning business?
그럼 드라이 클리닝 비즈니스를 하신 지는 몇 년이나 되셨나요?
처음부터 시작하면은 한 30년 했죠.
From the beginning, I would say about 30 years.
Okay. And you've been operating Doak's Cleaner since roughly September 1996?
네, 그렇다면 독스 클리너를 1996년부터 운영하셨던 거죠.
98년에 다른 데서 하다가 포모나로 왔습니다. 그러니까는 포모나에 오기 와서 한 2년 후에 기계를 샀을 거니까는 예, 96년도에 와서 아마
96년에 하신 거예요? 98년에 오신 거예요?
기계는 98년에 샀고 96년에 포모나로 왔습니다. 다른 데서 하다가.
아까는 기계를 97년에 사셨다면서요?
97년 얘기는 안 했습니다.
Okay.
1월 25일 날 98년에 샀습니다. 기계를.
I acquired the business, the Doak's Cleaner, in 1996, and let me make a revision on the date for the machine that he bought it. He said it's 1998, January 25th, instead of 1997.
So his machine is roughly 23 years old.
선생님, 그러면 그 기계가 한 23년 된 거죠? 98년에 사셨으니까?
예.
You're correct.
Thank you. And again, your business is located in Pomona?
선생님 비즈니스가 지금 포모나에 있는 거 맞으시죠?
예, 예.
Yes.
Are you in a commercial or residential area primarily?
선생님이 지금 상업 지역에 있으세요? 아니면 주택가 지역에 있으신가요?
그거가 상업 지역인지 주택 지역인지 모르겠는데 계리 선상에 있습니다. 판단하십시오. 계리 선상에 내려가면은 이제 경찰서도 나오고 이제 그런 말하자면은 포모나 입구에 있는데 계리 선상이라는 게 포모나를 미션으로 지나갑니다. 그러면은 미션하고 포모나 그 시리홀이 있고 경찰서가 있고 소방관이 있고 그런데
네, 됐습니다. 네.
예, 그러니까 계리 선상에 있어요. 포모나 입구 쪽에 포모나를 들어가는 입구라고 생각하시면 되겠습니다.
Well, I cannot clearly say it's on the commercial area or residential area. It's on the Gary, and right on the Gary, there's a police station, there's a city hall. So I cannot clearly say that I'm on the residential or commercial area.
Okay, let me try to make the questions more direct. Let me narrow them. How close are you to the nearest school?
선생님이 운영하시는 그 클리너에서 가장 가까운 학교가 어느 정도 위치에 있나요? 얼마나 거리가 되나요?
신호등 2개 지나면은 학교가 있던데요.
There's a school if you pass 2 signals from my business. So 2 blocks away, I would say.
Thank you. And how close are you to the nearest home?
가장 가까운 주택가는 얼마나 가까이 있나요?
주택가는 거기서 그 빌딩 뒤로는 이제 작은 골목이니까 주택가가 된대요.
There's a big building behind my business and there's a small alley in it. And starting from that point, I would say it's a residential area.
So would you say less than a mile away?
1마일은 안 되는 거죠, 그러면?
1마일이요?
네, 주택가가 선생님 비즈니스 1마일은 안 되나요?
아니요. 그냥 그 빌딩 지나면은 골목이면서 이제 우리 빌딩 다음으로 이제 주택가들로 되어 있죠.
1마일이 안 되는 거죠?
예, 1마일은 안 됩니다.
It's less than
1마일이 뭡니까?
so there's a big building right behind my business and there's a small alley behind that building. So starting from that point, I would say it's a residential area. So definitely it's way less than a mile.
Thank you. Now, do you have more than one perk machine on your facility?
선생님 지금 클리너에 퍼크 머신이 한 대 있나요? 아니면 한 대 이상 있나요?
프로모션 한 대 있죠.
There's only one perk machine in the business.
Okay. And do you have any other dry cleaning equipment on site?
다른 드라이 클리닝 기계가 또 있나요?
다른 건 없고 와시머신 2개가 있습니다.
I don't have any other dry cleaning machine, but I do have a 2 wet washing machine.
Thank you. Do you know how many gallons of perk you're permitted to use each year?
선생님, 1년에 퍼크 사용량이 얼마만큼 허가가 되는지 혹시 알고 계세요? 얼마만큼 사용할 제한이?
10갈런 아닙니까?
Isn't it 10 gallon a year?
Well, does 29 gallons a year sound familiar to you?
29갤론이라면 어떻게 생각하세요? 그렇게 들어보신 적 있으신 것 같으세요?
뭐요?
29갤론이라고 들어보셨어요?
못 들어봤습니다. 지금 들어본 얘기입니다.
I'm not familiar with 29 gallons.
Okay. Do you know what your perk emissions per day level is?
하루에 퍼크 배출량이 얼마나 되는지 알고 계세요? 선생님 비즈니스에서?
저희는 드라이 클리너를 하루에 한 번, 두 번, 세 번 그런 정도 빱니다. 그래서 배출량이 얼마인지 모르겠습니다.
I don't know the exact amount of the perk emission, but I run the perk machine about 3 times a day.
그 전에요, 그 AQMD 직원들이 나와서 펄크 조사를 1년이면 꼭 나와서 체크했습니다. 그런데 위반된 사실이 없었습니다.
Every year, the staff from the AQMD comes out and does the inspection for the perk emission, but I was never violated. I was never cited for the violation.
Thank you. Do you know the current mileage of your machine, or in other words, how many items or pounds of clothes your machine can process per 1 gallon of perk?
선생님, 지금 사용하시는 기계로
예,
1갤론 퍼크를 사용하면은 얼마만큼의 옷을 드라이 클리닝 할 수 있는지 아세요?
저희가 2,420파운드를 빨았습니다. 그래서 거기에 준하는 거는 마일리지가 484입니다.
So in a calculation, we ran the machine for 2,420 pounds for the whole year.
1 month.
Equivalent to 484 pounds a gallon, I would say.
I'm sorry, can you say that again? 484 pounds. What did you say at the end there?
Per gallon.
Per gallon.
아니 선생님,
예.
제가 지금 그 마일리지를 물어보니까 이 얘기를 한대요.
네.
이게 지금 팬데믹이 온 1년 동안에
네.
빠는 양이 2,420파운드를 빨았습니다.
네.
그래가지고 이제 5갤런 퍽을 썼으니까는 그것으로 나누니까는 484마일 되었다고 설명드립니다.
Okay, you asked me about the mileage, so just to clarify, during the pandemic, we washed about 2,420 pounds of clothes and used 5 gallons. So that equivalent to 484 pounds roughly per gallon of perk.
저희는 물로 빠는 세탁이 거의입니다.
And my business, mostly the cleanings are done through the wet machine.
그래서 세탁기 빠는 기계가 2개가 있는 것입니다.
That's why I have 2 wet washing machines in my cleaner.
Okay.
저희 집 같으면은 아마 퍽 기계 있다 하더라도 그렇게 공해가 위반된다. 뭐
So,
그렇게는 전혀 생각 안 하고 있습니다. 저 건강한 거 보세요.
I don't think we're violating the amount of the perk emission, and we were never been cited for the violation. And I'm a proof of the emission. I'm healthy, so I would think that I'm not violating any laws or polluting the air by using my perk machine.
yeah, no, tell him I'm just trying to gather facts right now.
네, 선생님 지금 어떤 사실인지 사실 여부에 관해서 이걸 찾아보는 거기 때문에요. 그렇게 알고
이제
계십니다.
No accusation of anything.
Understood.
Thank you. So just so you can relay that to him, that there's no accusation of anything, so he'll know that. Thank you.
선생님, 지금 이거는 뭐 선생님을 어떻게 뭐 이렇게 했다 그렇게 말씀드리는 게 아니라 지금 아까 사실을 하는 거기 때문에 선생님 어떤 잘못을 하셨다는 걸 얘기하는 게 아니라 사실 여부를 판단하는 겁니다.
예.
Can you give me an estimate of how many gallons of perk your business uses per month?
그럼 선생님 한 달에 퍼크 사용량이 얼마나 되세요? 몇 갤론이나 되요? 한 달에?
몇 갤런 정도가 아니에요. 안 들어요. 그거 펄맥 머신 독일제 그거는 퍽이 그렇게 뭐 소모된 거가 아닙니다. 저희 같은 경우는 뭐 5가렌이면 1년 넉넉한 있었죠.
So I would say I don't have exact numbers, but like I said, during the pandemic, the whole year we used 5 gallons of perk. So if you divided that into 12 months, that would be the number for the month of usage.
So from January to January, or from March to January, you used 5 gallons.
네, 선생님 5갤런을 사용하셨다고 했는데 팬데믹 상황에서 작년 1월부터 작년 12월까지인가요? 아니면 작년 3월부터 올해 12월까지인가요?
아니에요. 작년에 퍽 샀습니다. 작년에 퍽을 사가지고 지금까지 썼으니까요.
그러니까 총 사용량이 아까 말씀하신 것이 5갤론이 작년 1월부터 작년 12월까지 1년 내내 사용하신 양인가요?
2월 11일 날 5갤런 산 것입니다.
I bought the perk last year,
19.
February 11th. So starting from the February till the end of the year, I used 5 gallons.
Thank you.
저희는 명칭만 드라이클리너 이렇게 간판만 가지고 있지 실상은 뭐 사업을 다 구체적으로 얘기할 수는 없지만은 아웃드라이만 얘기한다면 와시로 전부 다 해결하고 나갑니다.
It is a dry cleaner by the name, but then, like I said, our business mainly depends on the washing clothes. So that's why we have 2 washing machines.
Okay, thank you. Well, You last purchased perk in February of 2020. Is that correct?
네, 선생님 마지막으로 펄크를 구입하신 게 아까 말씀하신 것처럼 2020년 2월에 사신 게 맞으시죠?
이제 그것 맞고요. 그러고 이제 퍽 기계를 없애면 사람들이 퍽을 뭐 5개론 주고 그래서 그거 사용하려고 갖다 놓고 있습니다.
Yes, you're right. The last time I purchased the perk was in February, and people that I know who are closing down their business, they have some leftover perk. They gave it to me, so but I haven't used it yet.
Okay, so how many gallons did you purchase last February?
그럼 작년 2월에 몇 갤런을 구입하셨나요?
5갤런 구입했는데요.
5 gallons last year in February.
And he used all of that. Is that correct? By
그러면
December?
5갤런 구입하신 걸 이제 다 쓰신 거네요?
다 쓰지 않고 그 지금도 그 전에 이제 잔고가 있었을 거 아닙니까? 그러고 사는 건 5갤런이고 그러니까는 그거 그런 데다가 부득불하고 조금 뭐 흰색이라든가 줄어든 거라든가 그런 것만 넥타이하고 3가지 종류만 빠니까는 퍽이 지금 있죠. 있는데 이제 또 퍽기계 없애는 사람이 5 갤런을 주면서 쓰라고 그래서 지금 갖다 놓고 모자라면 이제 그거 또 부어서 쓰려고 준비 중에 있습니다.
I didn't use all 5 gallon that I bought last year because there's some leftover in the machine before I bought the 5 gallon. So I haven't used all of it. And like I said, one of the people that I knew, my acquaintance who closed down their business, gave me the 5 gallon of perk they left behind. So I haven't used that yet. I'm planning to use that if I had to use it.
Okay. Can you give me a number of how much perk you have left right now?
지금 가지고 계신 perk가 얼마나 남아있나요? 다 합쳐서.
지금 다 합친다 해도 그 포간에 미신 그거가 한 20갤런 될 거래요.
다 합쳐서 기계 안에 있는 걸 다 합쳐서요?
예. 기계 안에 지금 이게 지금 법적으로 이렇게 되기 전에 기계 안에 이제 하나 채워졌을 거 아닙니까? 그러다가 이제 쓰다가 보니까는 또 법이 바뀌고 해갖고 이거 10년 전에 뭐 5년 전에 이렇게 뭐 10갈런만 써라 뭐 어떠라 그래서 이제 그 사는 건데 이제 작년에는 퍽을 좀 채야 되겠다 해가지고 5갈렌 사서 부었고요. 그러고 지금 이제 공으로 준 거 5갈렌 있어서 또 이제 그거 부어서 금년까지 쓰고 이제 남으면은 다시 폐기물로 담아서 처리하려고 준비 중에 있습니다.
So I would say I would estimate close to 20 gallons plus that's including the what I have left in the machine and then what I got from my friend. So everything included. So before the pandemic, there was some leftover in the machine and I bought another 5 gallon in February and there's still leftover and another 5 gallon from my friend who closed down the business.
Okay, 20 gallons left. Thank you. How much of your business relies on the use of your perk machines? I understand you have 2 washers, but what percentage is from your dry cleaning?
네, 선생님 그렇다면은 드라이 클리닝을 통해서 펄크 기계를 사용해서 창출되는 매출이 총 매출의 몇 % 정도를 차지합니까?
매출에서 드라이클리너 머신은 아마 3분의 1 정도 차지할 거예요.
3분의 1이요?
네, 매출의 3분의 1 정도.
네, I would estimate about 1/3 of the sales that comes through the direct cleaning, so roughly 33%.
And can you just briefly explain what the pandemic has done to your numbers specifically. Where were you prior to the pandemic and where are you now financially due
네,
to the
선생님.
pandemic?
선생님, 간단하게 선생님이 팬데믹 이전에 매출이 정확하게 얼마였고 현재는 어느 정도까지 떨어졌는지 좀 말씀해 주시겠습니까?
팬데믹 전에는 7,500불 정도 됐어요. 7,500불에서 6,000불.
네.
그러고 지금은 4,000불, 4,500불, 3,000불도 되는 때가 있었고,
그럼 3,000에서 4,500 사이라고 말씀하시면 되겠습니다.
네, 4,000에서 4,500 사이,
3,000이세요? 4,000이세요?
4,500.
So prior to the pandemic, the number was, I would say sales number would be around 7,500 a month. But after the pandemic, we're looking at 4,000 to 4,500.
Thank you. And are you current on all of your permit fees?
지금 펄밋 비용은 다 잘 지불하셨나요?
한 번도 실수한 일 없습니다.
I was never late on the fees before, so I'm current on all the fees.
Thank you.
상 주셔야 됩니다.
I should get rewarded.
I'm sorry, I couldn't hear you.
I should get rewarded, he said, for paying all the fees on
Oh,
time.
congratulations. Thank you. Yeah, are you a part of any dry cleaner association or organization?
네, 선생님, 어디 드라이클리닝 협회 같은 데 소속돼 계십니까?
예.
어디에 속해 계시죠?
한인협회라고 있습니다. 세탁협회.
Yes, I'm a member of a Korean dry cleaning association.
And how long have you been a member of that organization?
거기에 얼마나 멤버로 오래 계셨죠? 몇 년이나 계셨어요?
한 20년, 30년 될 겁니다.
More than 20 years, I would say.
Thank you. 20 plus. And are you familiar with Rule 1421?
그렇다면 법률 1421에 대해서 알고 계십니까?
모릅니다. 141이 뭐인지 모릅니다.
I don't know about the rule.
Are you aware that there was a rule stating that you could no longer use PERC after December 31st of 2020?
네, 2020년 12월 31일 이후로 펄크를 사용하지 못하게 하는 법인데 그거에 대해서 들어보셨나요?
예, 그거는 들어봤습니다. 퍽 사용하면 안 된다고 그랬습니다.
Yes, I know about that, but I didn't know it was a rule 1421.
Okay, thank you. And do you recall just having a discussion with an inspector from AQMD about the Rule 1421 or those terms?
네, 그렇다면 AQMD 직원이 선생님의 그 검사차 방문했을 때 비즈니스를 그 법률에 대해서 이야기한 걸 기억하십니까? 펄크 사용하지 못하게 하는 법이요?
그분은 나와서 기계 체크하고 퍽이 센지 안 센지 그렇게 체크만 하고 가셨지 그 말씀은 안 해주셨고요. 그 한 10 몇 년 전에 그 미팅 한참 AQMD에서 했을 때 그거 한 번도 안 결석 안 하고 모이는 날에 미팅 날에 참석해서 이 얘기를 충분히 들었기 때문에 알았습니다.
I didn't hear about the PERC rule, which is Rule 1421, from the staff of the AQMD. And every time the staff from the AQMD come out for the inspection, they did an inspection only. But then I knew about the rule because I attended all the meetings from the AQMD in past 10 years. So that's how I knew about the rule.
Okay, so can I ask you, how long have you known about the rule then?
그럼 이 법률에 대해서 얼마나 오래 전에 알고 계셨습니까?
그러니까 오래됐죠. 그 연수를 짚으라고 그러면 모르겠습니다만은 뭐 10년, 15년, 한 20년 그렇게 되지 않았을까 생각됩니다.
Yeah, it's been a long time. I would say more than 10 years ago, I knew about it. I don't know the exact date, but then I knew about it more than 10 years ago.
I'm sorry, I was frozen, so I couldn't
Okay,
hear.
let me repeat that. I cannot pinpoint the exact date when I knew about the rule, but I would say it's more than 10 years.
Okay, thank you. And what, if any, steps have you taken to prepare yourself to become compliant with the rule?
그렇다면 선생님이 법률을 따르기 위해서 그 전부터 어떤 노력을 해오셨나요?
기계를 바꿔야 된다 생각하고 준비를 쭉 해왔습니다. 그런데 제 매상도 뭐 줄어들어 불고 그렇게 하니까는 이제 그렇게 여가가 없었는데 늘 준비해오던 중에 이제 교회 장로님께서 자기는 은퇴하니까는 연장을 받아서 신청하면 연장이 될 거니까 연장을 받아서 자기가 문 닫는 동시에 11월 달에 2021년에 기계 갖다가 쓰라고 그래서 지금 그것만 기다리고 있습니다.
I was planning to replace the machine before the pandemic, but then after pandemic hit, my financial situation got very difficult. And like I said briefly before, one of my church member, and he's retiring from the dry cleaning business, and he has a machine that complies to the Rule 1421. And he told me just file for a variance, and when he closed down his business in 2021, he could take over the machine and use it.
And that's not until November of 2021?
그게 2021년 11월이라는 말씀이시죠? 그 비즈니스 닫아 선생님이 그 기계를 가져오실 수 있는 시간이.
예, 그거 이제 클로스 하신답니다.
Yes, you're right. In November of 2021.
And does he ever use an outside cleaners to do any of his dry cleaning?
선생님, 이전에 선생님의 들어온 세탁물을 바깥 세탁소로 보내서 클리닝 해오신 적이 있으십니까?
바깥에서 해온 일 없습니다. 저거 라운드리 와이사스 라운드리면 라운드리 컴퍼니로 보냈습니다. 드라이클리닝 보낸 적이 없습니다.
I never outsourced the clothes that come in for the dry cleaning, but I did send out some the dress shirts for the cleaning to the laundry.
만약에 연장 안 내주신다 그러면은 AQMD가 허가 준 달수까지 쓰도록 해주시면은 감사하고요. 그렇지 않는다 그러면 에이전시 그 라운드리 집에서 해주기로 타업은 봐놓고 있습니다.
And if the variance is granted today, it would be very grateful. But if not, I already spoke to the one of the dry cleaners that I could send my clothes to.
Okay. And when was the last time that you used your perk equipment?
선생님 파크 기계를 마지막으로 사용하신 날이 언제세요?
오늘도 썼습니다.
Today.
Okay. And if the variance is not granted today, what is your plan exactly going forward? Did you say you're going to use the equipment of a friend that is compliant? Is my understanding correct?
선생님, 오늘 만약에 허가가 안 떨어진다면 들어오는 드라이 클리닝을 어떻게 처리하신다는 거죠? 다른 그 말씀하신 라운드리로 보내서 거기서 처리하신다는 건가요?
예. 그러고 이제 저희가 많이 물로 빠니까요. 많은 소화를 시킵니다.
그 라운드리로 보내는 게 선생님 친구분 라운드리세요?
예. 아닙니다. 친구가 아니고 그 라운드리 전문으로 하는 회사입니다.
You're
그래서
partially right. If the variance is not granted today, I'm planning to send all the dry cleaning clothes that come into my business to a specialty laundry that could do the dry cleaning for me, but he's not my friend though.
Okay. Well, and one last question. How much perk have you used since January 1 of this year until now?
그렇다면 선생님, 올해 1월 1일부터 현재까지 퍼크를 얼마나 사용하셨나요? 퍼크 사용량이 얼마나 되나요?
그걸 글쎄 어떻게 합니까? 사용량은?
I don't know how I could estimate that.
Okay. All right, thank you.
모르고 말할 수 없잖아요. 어떻게 그거 계산법이 나옵니까?
But I don't know the exact calculation of the emission that I used for perk for this year from the January 1st, so I cannot say exact numbers how much I used.
Well, can I ask you this? How many pounds of clothes have you processed in the calendar year 2021?
네, 그렇다면 이렇게 여쭤보겠습니다. 1월 1일부터 현재까지 펄크 기계를 사용해서 빨래를 하신 그 옷감의 무게가 얼마나 되나요, 혹시?
In your dry cleaning machine.
네,
Yes,
선생님,
thank you.
1월 달에 370파운드 정도 됩니다.
I would estimate about 370 pounds of clothes was processed through the perk machine in my business.
Since January 1 of this year.
네, 1월 1일부터 370파운드라 말씀이시죠?
예.
You're right.
Thank you very much. Nothing further at this time.
네, 감사합니다.
Thank you. Board members, anyone wish to begin questions? Mr. Sun. Mr. Balagopalan.
Yes, thank you. Mr. Sun, do you know when your permit will expire?
선생님 퍼밋이 언제 expire 되는지 알고 계시나요?
예, 알고 있습니다.
언제죠?
10월 1일입니다.
10월 1일 올해요? 21년이요?
예, 21년 10월 1일.
It will expire in October 1st, 2021.
October, okay, thank you. Now, prior to the pandemic, were you looking, Mr. Sun, at buying a new hydrocarbon machine?
그러면 팬데믹이 터지기 전에 선생님이
예.
하이드로카본 머신을 구입하려고 계획을 하셨었나요?
그렇죠. 유니온에다가 유니온 회사 거 살라고 예 계획 절충 중에 있었습니다.
Yes, you're right. I was planning to buy a machine from the union company.
Did you get a quote from them?
가격 같은 거를 한번 알아보셨나요? 거기서 콧을 받으셨나요?
예, 65,000불에 완전히 셋업 해준다고 그랬습니다.
Yes, I did get the quote, and they said, including the installment and everything, it would cost about $65,000.
Now, your plan moving forward is to buy your friend's machine and install it, correct?
네, 선생님 지금 계획은 그러면 아까 그 비즈니스를 닫는다는 장로님 기계를 가져다가 선생님이 구입하셔서 설치하실 계획인 거죠?
예,
You're right. I would probably purchase the machine from the friend who closed down their business and then install it in my business.
Now, have you discussed getting it sooner than November?
혹시 11월 이전에 어떻게 가져오실 방법이 없는지 한번 이야기해 보셨습니까?
그 집에서 그 계약 날짜 끝나는 날이 12월인데 그래도 제 어려운 사정 알고 11월 달에 가져가고 한 달은 그냥 정리 상태로 가게 치우면서 정리하고 한 달 보낸다 그래서 11월 달에 그래도 주겠다고 하는 것입니다. 그리고
I spoke to him about it, and he said his lease ends in December of 2021, but then he knew about my situation and he was willing to let go his machine on November instead of the lease ends on December.
그리고요. 그리고 기계가 어저께 웨스트 캔박 사장한테 알아보니까 가격이 65,000불인데 45,000불에 셋업해 줄 거니까 기계 놓으라고 또 그렇게도 얘기하고요. 지금은 기계가 많이 20,000불짜리도 있고 25,000불짜리도 있고 그래서 아마 팬데믹 지나가면은 싼 기계들이 많이 있을 걸로 생각들어서 저는 다행이다 생각하고 있습니다.
And one of my acquaintances let me know that he could set up the whole machine at the cost of in range between 40,000 to 45,000. And some of the machine that I know is cost less than 25,000. So after this pandemic is over, I would expect I could acquire some cheaper machine to install my business to comply the rule.
Okay. However, if the board does not grant the variance today, did I hear that he's going to become an agency cleaner?
네, 만약 그래도 오늘 허가가 나지 않는다면 선생님 말씀하신 것처럼 아까 그 세탁물들을 그런 그 전문 업체에 보내실 거죠?
네, 그렇게
Yeah,
해야죠.
I would have to send my the clothing to the agency.
Okay. Thank you, Mr. Sun.
감사합니다.
감사합니다.
Mr. Sun, you mentioned that you're looking at this machine of your friends for November, but that you might be able to find a less expensive one. What steps have you taken to look for additional used machines that might be available?
네, 그렇다면 선생님 아까 그렇게 싼 기계들도 이제는 나와 있다고 하셨는데 그러면은 중고 기계 같은 거를 알아보시거나 알아보려고 어떤 노력을 하셨나요?
그리고 지금 중고 가격을 얘기한 겁니다.
예, 그래서 그걸 매입하시려고 어떤 노력을 하셨어요? 여기저기 알아보셨나요?
예. 기계상들한테 알아봤죠. LA 기계상, 또 오렌지 카운티 기계상, 또 저희 기계 고쳐주는 그 펄맥 놔준 분, 그분한테도 알아보고 그렇습니다. 준비는 단단히 하고 있습니다.
I was asking around and getting the code for the used machine in LA County and Orange County, and also who the engineer who comes in to install my the machine. And I was asking around to get the code to found out to find some cheaper used machine to install in my business.
If you found one at a good price, would you be in a position to purchase it?
만약에 적절한 가격에 싼 중고 기계를 찾으신다면은 매입하실 의향이나 지금 상황이 되시나요?
예. 매입하려고 계획 단단히 하고
If
있습니다.
it's in my price range, I would definitely purchase it.
Is his price range currently a price range for which he has seen the average price of? Does he have enough money for the average price of a used machine? I just
그렇다면
understand his abilities currently.
선생님이 지금 보셨던 그 중고 기계의 평균 가격을 보셨을 때 선생님이 지금 매입할 수 있는 상황이 되십니까?
아니요, 지금 중고 가격 아니 그렇게 그런 금액에 살 수 있는 물품을 찾아주라고 그랬지. 지금 그 가게 가서 본 일은 없습니다. 그런데 웨스트민트에서는 그 65,000불짜리인데 40,000불, 45,000불짜리 그것은 와서 보라고 그랬었습니다.
I haven't actually went out and then took a look at the used machine just yet, but I asked everybody to find me a machine in my price range. So if it was found, then I would have to go take a look at it and see if it falls in within my price range.
And when did Mr. Sun stated that he received a quote from the union company for $65,000. Approximately when was that?
선생님 아까 유니언 컴퍼니에서 65,000불 정도 가격을 받으셨다고 했는데 그렇게 알아보신 게 언제쯤이었나요?
그거 오래되었습니다. 작년 재작년서부터 알아봤는데 그거 가격은 인하가 안 되더라고요.
It's been more than 2 years, And I was trying to look if the price drops, but then the price just remained the same for the union company.
And back then, or at least right before the pandemic, was Doak's Cleaners in the position to purchase a machine from the union company?
그렇다면은 팬데믹이 터지기 이전에 선생님 비즈니스에서 그 유니언 컴퍼니의 기계를 매입하실 영향이 안 되셨나요?
예, 그렇게까지 쉽지는 않았습니다. 그래서 왔죠, 지금까지.
Yes, I was planning to get the machine, but the price was too high for me even before the pandemic. So I was thinking about it, and then after the pandemic hit, and my financial situation got even worse.
Okay. Going to the specialty laundry that Mr. Sun said he would send cleaning to if denied a variance. What is the cost? Is there a cost associated with that, and how far away is that cleaner?
네, 선생님이 만약에 오늘 허가 신청을 못 받으시면은 다른 클리너로 보내신다고 세탁물을 말하셨는데 그 보내시는 클리너가 선생님의 지금 비즈니스에서 얼마나 멀리 있고 가격은 어느 정도 됩니까? 피스당.
피스에 2불 30전을 줘야 됩니다. 그리고 그거 가는 시간은 한 10분이면 갑니다.
Yeah, I don't know exact distance, but it takes about 10 minutes from my business. And they said they gave me a code. It's going to cost about $2.30 per piece.
Okay. Does Mr. Sun aware that if a variance is granted, Mr. Sun or the cleaners would have to pay $40 every day that that his machine is run as excess emission fees?
네, 선생님, 오늘 이 연장 신청이 허가가 되더라도 선생님이 허크를 사용하시는 날마다 40불씩 내야 된다는 걸 알고 계십니까?
그거 처음 듣는 얘기입니다. 내야죠.
I didn't know about this, but if that's the case, then I'm willing to pay it.
Okay. And before, earlier, Mr. Sun mentioned that he runs his machine 3 times a day. Is that how often he's running it currently, or is that pre-pandemic?
네, 선생님 아까 기계를 보통 하루에 3번 정도 돌린다고 하셨는데 그게 보통 평균인가 아니면 팬데믹 이전에도 그 정도였나요?
아니에요. 팬데믹이 와서 그렇게 되었습니다. 팬데믹 이전에는 훨씬 더 빨랐죠.
So 3 times a day is after the pandemic, and I would estimate it's more than 3 times a day prior to the pandemic.
So Doak's Cleaners is running the Perk dry cleaning machine every day.
그러면 매일 퍼크 머신을 사용하시고 계시나요?
And how many days a week?
일주일에
아니,
몇 번?
그러니까 이틀에 한 번씩이나 이렇게 모읍니다. 옷이 작으니까 드라이클리너 할 것은 작으니까 급한 거는 하루에 있으면은 빠지만은 대체적으로 옷을 모읍니다. 그래서 한 이틀분을 이제 빨고 또 이틀분을 빨고 그러죠. 그러고 토요일 날은 일을 또 안 하고 그러니까는 몇 번 안 빨고 지나가죠.
So there's not much dry cleaning that's coming in right now. So I would have to collect those and then run the machine every other day instead of every day. And we don't open our business on Saturday. We don't use that machine on Saturday. So.
Oh, I just want to understand. So before the last question, Mr. Sun said he's running his machine every day. Is that 6 days a week? And is that correct?
Prior to the pandemic?
I thought the answer that I received was that now he's running it about 3 times every day. So I wanted to understand, is he actually using the machine right now or in January every single day, 6 days a week? I want to understand that.
그럼 현재 다시 한번 확실하게 하기 위해서 현재 선생님이 매일 사용하시는 게 아니라 이틀에 한 번씩 사용하신다는 거예요? 이틀에 한 번씩 하루에 3번 정도로 사용하신다는 건가요?
아니 그러니까 빨래를 모아놨다가 이틀에도 빨고 또 급한 거 있으면 그날도 빨고 그거 대중이 없습니다. 일괄적이 아니에요.
It's hard to average.
날마다 빨 수도 있고 어떤 주에는 일이 안 들어오니까 그냥 오늘 것은 내일로 모아놨다가 이제 뭐 위켄드 온다 손님이 그러면은 월요일 것을 작으니까 안 빨고 또 토요일 날 일이 많이 들면은 월요일도 빨고 들쑥날쑥이지 어떤 규칙이 없습니다. 그러니까 그냥 정리를 하시기 위해서는 하루에 한 번이라도 20파운드, 20파운드라도 한 번 내지 두 번도 빨 수도 있고 또 그거의 옷 모아갖고 하루날은 안 빨고 건너뛰어서 수요일 날도 빨고 그런데 다음 주에는 또 어떻게 상황이 바뀔지 모르니까 제 말씀은 작은 빨래라도 어쨌든 기계는 돌려야 되니까 한 번 빨지 두 번 빨지 안 빨지 그거를 확실하게 말씀은 못 드리겠습니다. 그러나 손님이 또 형편상 빨리 해주라고 하는 옷이 있으면 빨 수도 있기 때문에 하루에 한두 번은 빤다고 이렇게 정리를 해주시면 좋겠습니다.
Yes, it's kind of hard to say the exact numbers. I would say it's kind of on and off. If there's more dry cleaning clothes coming in, I would have to do it every day. But then now I would say every other day. But then case changes every week. So if there's more dry cleaning comes in, then I have to probably use the machine every day. And sometimes there's not much dry cleaning coming in, so I have to collect those and then do it every other day. So if you want me to average it out, I would say I'm running the machine once a day for the 20 pounds if I have to average that out. But then it's kind of on and up. Sometimes some week it's every day and some week it's every other day.
And that's 6 days a week?
6일 동안 오픈하시고 6일 동안 사용하시는 거죠?
5일만 사용합니다.
5 days a week.
So not open 2 days, open 5 days?
그럼 토요일 날은 오픈 안 하시는 거예요?
아니 가게 오픈하지만 기계는 안 돌린다는 얘기를 하고 있는 것입니다.
We open on Saturday, but we don't use the machine on Saturday.
Okay, thank you. I thought I had one other question. Oh, my final question. Do you own any other dry cleaners?
네, 다른 드라이 클리닝 비즈니스를 또 소유하고 계신 게 있으십니까? 이 비즈니스
뭐요?
말고 선생님이 지금 가지고 계신 이 독스 클리너 말고 다른 드라이 클리닝 비즈니스를 또 가지고 계신 게 있으세요?
아니요, 없습니다.
This is the only one.
Thank you. Board members, additional questions for Mr. Sun, Ms. Verdugo Peralta.
Thank you, Madam Chair. Good morning, Mr. Sun. I'm wanting to ask you, we've been working with the dry cleaners since November, December, and we've been talking about limiting about 800 pounds during the time of the variance, if we grant a variance. My question to you would be, would you be willing to accept that limit?
네, 선생님, 저희가 이런
네.
케이스를 많이 계속 그 팬데믹 때문에 얘기를 하고 있는데요. 허가가 된다고 하더라도 그 펄크 기계를 이용해서 허용 기간이 끝날 때까지 사용할 수 있는 양이 옷 800파운드만 그 클린하는 걸로 결정이 되는데 그 정도도 괜찮으시겠어요?
100파운드요?
800파운드요. 그러니까 허용 기간이 끝날
와.
때 800파운드.
800파운드가 무엇입니까? 800파운드 못 빨죠. 한 200파운드, 400파운드 정도
아니요.
팬데믹이
한 달이 아니라 아까 1년을 허용하셨잖아요. 1년 안에 800파운드를 말씀하신 겁니다.
아, 예. 1년 안에
네.
1년 안에 800파운드 그거 안 됩니다. 800파운드 1년에 800파운드 80파운드 한 달에 80파운드인데 한 달에 80파운드 800파운드 물로 좀 많이 빨면은 그렇게 될 것 같습니다. 800파운드 물로 많이 빨면은 더 물로 빨아야 돼야지.
It's way less than I expected, but if the variance is granted, I would have to divert to the washing machine more, and I would probably could manage it.
Okay, and you do understand that if you were to use your perk machine during that period of time, that you are going to have to pay the $40 per day. You understand that, right?
네, 아까 이해하신 것처럼 다시 말씀드리지만 펄크를 사용하실 때마다 허가가 되더라도 사용하는 날마다 40불을 내셔야 되는 걸 이해하셨죠?
그러면은 제가 거짓말 안 하고 양심적으로 기계를 안 돌리는 날은 안 돌렸다고 보고를 하면 거기서 인정을 해 주십니까?
So if
제가 선서를 한 사람입니다. 이 자리에서.
I'm under
제가
oath,
양심적으로.
I'm under oath, so I don't want to. I don't want to lie. So if I said I would have to report the day of the usage. So if I say I didn't use the machine, would you take that as a credible answer?
Repeat that again, please.
If so, I'm under oath. I don't want to lie. So if I said I only use certain days of the week, if I use the machine only certain days a week, would that take it as a credible answer, or do we have to someone come out and inspect it every day that if I use it or not?
Well, there's a report that you would have to be sending to the AQMD that's telling us what you are using. So you would have to be reporting that on a weekly basis.
네, 선생님, 매주마다 허가가 된다면은 AQMD로 보내야 되는 리포트가 있으십니다. 그래서 거기에 내가 며칠 사용했다고 적으셔야 되기 때문에 그것을 거짓말하시면 안 됩니다.
예, 예. 거짓말 안 하고 정직하게 합니다. 선서를 한 사람입니다.
I just wanted to try to point out that I'm under oath and I'm a very honest person, so I would report very honestly.
Okay. Now, you said that you purchased several gallons of perk from associates of yours. If it comes out to the fact that you do not use all of it, based on the fact that you would be limited to so many pounds, what are you going to do with that extra perk?
네, 선생님이 지금 가지고 계신 펄크가 있지 않을까?
예, 있어요.
받으신 것도 있고, 그렇지만 이 허가 기간이 끝나기 전까지 다 사용하지 않으신다면 그 남은 펄크를 어떻게 하실 겁니까?
저거 그 비올라로 보낼 겁니다. 쓰레기통에 부어가지고 비올라로 보낼 겁니다.
I will send it to Viola. I don't know what Viola is, but
그 쓰레기 가져가는 회사입니다. 비올라가.
that's the name of the company that collects the waste.
Okay. Let me see. I had another question for you. And of course, I forgot what it was. In reference to the, I know what it was. In reference to the health effects, you had stated earlier that you're a healthy person and that you have not seen any physical effects from you being in the industry for 40 years. However, have you read, because I know that the Korean Dry Cleaners Association did send out to all of their members, and I attended their annual meeting when they also did it at the meeting, all of the health effects, toxic health effects from perk, that it was a carcinogen and caused many, many health effects to people.
네,
Were you
선생님,
aware of
아까
that?
선생님 건강하다고 말씀하셨는데 이렇게
네.
오래 클리닝 비즈니스에 계셔도 건강하지만 제가 알기로는 벌디거 퍼럴타 씨가 그 코리안 어소시에이션에 참가하셨을 때 연회 총회마다 참가하셨을 때 거기서 한국어로 된 책자를 통해서 이 퍼크가 얼마나 위험하고 어떤 발암 물질인지 이 유해성에 대해서 알려주는 책자를 보낸 걸로 알고 있는데 그 유해성에 대해서는 잘 알고 계시죠?
예, 유해성에서 알고 있습니다.
I'm well aware of the negative effects, and I know it's a carcinogen, so I know about the effect.
Okay, thank you.
Thank you. Board members, any additional questions for Mr. Sun? Dr. Bernstein.
Yes, thank you. Good morning, Mr. Sun and Mr. Lee.
Thank you.
Your friend who has a compliant hydrocarbon machine, how close is his facility to yours?
네, 선생님 아까 장로님이 주신다는 그 하이드로카본 머신이 있는 그분의 비즈니스는 선생님 비즈니스 얼마나 멀리 떨어져 있습니까?
멀리 떨어져 있죠.
거리가 얼마나 되나요? 그분 비즈니스 있는 곳이 선생님 비즈니스에서.
치노일까지 고속고까지가
대충만 생각하시면 됩니다. 대충만.
예, 한 7, 8마일은 될 것 같은데요.
His business is located in Chino Hills, so I don't have exact numbers, but I would estimate about 7 to 8 miles from my business.
7 to 8 miles.
네.
아니요, 세븐테 아니요, 7, 8마일.
예,
7마일이나 8마일 정도 되겠다 그 말이에요.
예, 그렇게 말씀드렸습니다. Yes, again, it's 7 to 8 miles. He thought I said 17 miles, but I said 7 to 8.
7, 8마일.
to 8. Got it. Have you ever had any discussions with him regarding outsourcing your dry cleaning to his compliant machine?
그렇다면 그분한테 선생님이 들어오는 그 일감들을 그분한테 보내서 처리하는 거에 대해서는 얘기 안 해보셨습니까?
그런 얘기는 안 했습니다. 라운드리 집에서 해준다고 가까운데 5분 거리에 10분 거리에 있으니까 라운드리 집에서 그거는 갔다 할 것입니다.
We didn't talk about that because the agency that I was going to send out to was way closer from my business from his business. It's only like 10 minutes from my business, so I haven't spoke to him about outsourcing my clothing to his business.
Okay, well, it seems to be a possible option for you as well. I just need to clarify one last time. We've had a bunch of answers for the same question. So this past month, or your current usage of your perk machine, could you please tell me what that is exactly? How many days you're using it during the week, and how many pounds per week are being processed through it?
네, 아까 계속해서 말씀드린 거지만은 정확치 않은 것 같아서 다시 한번 여쭤보는데요. 그럼 일단 올해 들어서 선생님이 그 매주마다 사용하는 퍼크 양이나 퍼크 양을 모으신다면은 빨래를 하는 양 그리고 퍼크
예.
일주일에 얼마나 사용하시는지 다시 한 번만 말씀해 주시겠습니까?
그러니까 그 통에 있었는 한 20개를 있는 데다가 5가렌을 작년에 사서 부었고 그래서 그것을 사용하고 있는데 또 이제 펑 미신 이게 없어진다니까 기계 처리하면서 퍽을 또 5가렌 아는 사람이 줘서 그거는 지금
선생님이
가지고
일주일에
있고
몇 번 사용하시는 퍼크 기계를 일주일에 몇 번 사용하고 올해 들어서
퍼크 어쩔 때는 3번도 빨고 2번도 빨고 그냥 그렇습니다.
네, 일주일에 몇 파운드 정도 빨래를 하시는지 모르세요?
일주일에 아마 그러니까요. 일주일에 빠는 거 양이 가게에는 적어놨었는데 제가 적어놓은 거 없어서 정확한 데이터를 말씀 못 드리겠습니다. 이렇습니다. 하루날에 빠는 양이 15파운드도 빨고 가령 어떤 날은 또 20파운드도 빨고 10파운드도 빨고 이렇게 들쑥날쑥 하니까는 제가 지금 정리를 못해서 그럽니다. 그렇다고 그러면은
So I don't have
예쁘한테 심지어.
again, I said, I don't have exact data in front of me, so it's kind of hard to say, but it's kind of on and off. I would say 2 to 3 times a week sometimes, and sometimes every day. But then per load, I would probably use about 20 pounds, washing about 20 pounds of clothing per use. So I would roughly say, if you average it out, 3 times a week, but I don't have an exact number of the pound of clothing that I'm washing or drying, cleaning.
물로 빠는 것이 많아서 분명하니 말씀드리지만은 퍽 기계는 그렇게 많이 안 씁니다.
Again, I want to clarify my businesses, 2/3 of my businesses depend on like washing machines. So I don't depend that much on the per machine. So I would probably estimate the emission is pretty low.
Okay, I still don't have my question answered then. So we're talking about either every day or every other day. We're talking about 20 pounds per load.
그렇다면 선생님 말씀하신 것처럼
I mean,
go ahead, doctor.
this is very important to try to clarify in my mind, given that you're utilizing a perk machine that is non-compliant. So for the month of January, how many days did you utilize that machine in a week as an average?
이게 상당히 중요한 질문이라서 계속 질문을 드리는 겁니다. 그렇다면 1월 달만 봤을 때 1월 달에 선생님이 평균적으로 퍼크 기계를 몇 번을 사용하셨는지, 일주일에 몇 번 사용하셨는지, 그리고 한 달 동안 몇 파운드의 빨래를 하셨는지를 좀 말씀해 주시겠습니까?
일주일에 한 4번은 기계 4일간 일주일 중에 4일간은 기계를 돌릴 날도 있고 그래서 드라이클리너 한 거는 어쩐 날은 10파운드도 빨았다가 15파운드 빨았다가 어떤 날은 또 한 7파운드 빤 날도 있고 그랬어요. 그거 왜 그러냐? 3번을 빨았지만은 양은 그렇게 없는데 부득불한 3번 돌릴 때가 있고 그러면 이제 또 모아가지고 빤 날은 그 양이 또 배로 되니까 한 번에 모아갖고 하루 날석 빠지고 그래서 아마 일주일에 4번만 빤 것 같아요. 그렇게 모아갖고 한 번은 세이브 되어갖고 하루 날은 안 빨고 그래서 한 4일은 확실한 기계 돌렸다고 얘기할 수 있습니다.
Again,
그거가 한 25파운드 하루 날에 빤 거가 그렇게 될 거예요. 30파운드.
Dr. Bernstein, again, he's repeating the same answers, but he doesn't have the exact number. Now he's saying that you could average about 4 times a week if you come to think about it. And he says sometimes 20 pounds a load, sometimes 15 pounds a load, sometimes 7 pounds a load. So it depends on the clothing coming in, it changes. So I asked him again, so if you average it out every week, how many times did you use your machine per week? And he said, you could say 4 times a week. But he doesn't have an exact number for the pound of clothes he washed.
Okay, thank you very much.
감사합니다.
Let's, board members, let's take just a little bit shy of a 10-minute break. We haven't had a morning break. Let's come back at 10:45. And Mr. Lee, if you can let Mr. Sun know that, but also not to leave the Zoom meeting and to mute his microphone.
네, 선생님. 지금
네.
잠깐 10분 쉬고 10시 45분에 다시 돌아올 텐데요. 미팅 나가지 마시고요. 음소거만 해주세요. 음소거만 해주시면 됩니다.
예,
예, 45분에 뵐게요.
예, 감사합니다.
Okay, we're back at 10:40. We're off the record.
Sure.
Okay, it's about 10:45. I want to make sure everyone is back before we get started back on the record. Dr. Bernstein, Ms. Verdugo Peralta, are you present? And also Mr. Lee. Oh, Mr. Lee is present. I think we're just, there we go. Okay. All right, we are back on the record. And board members, any other questions for Mr. Sun? Okay, no other additional questions? Senator, questions for Mr. Sun?
I'm going to avoid asking questions that have been asked and answered over again. So, Mr. Sun, I'm going to go to the petition. And a good cause, item number 4. You state that you have not received any prior notice regarding the chemical perk usage. Is that still true?
You're kind of breaking up, Senator Holden. Could you repeat the question one more time?
It said, under good cause, it says, I have not received any prior notice regarding the chemical perk usage. And you could go on to say, I have mailed to you, asking you to allow me to use the dry cleaning machine for 1 more year. That's on 22 if you have it in front of you.
네, 선생님 지금 이쪽에서 보내드린 서류를 가지고 계신가요? 지금 펄크 사용량에 대해서 받으셨던 서류를 받고 계세요?
안 받았습니다.
I didn't receive any notices.
I think, Senator, I think you can ask, but I think Mr. Sun was confused by the number 4, which states, explain why your petition was not filed in sufficient time to issue the required public notice. This is not an interim or an emergency, and so that would be not applicable, and I think that Mr. Sun did not understand it.
Right, at the beginning, he said his lawyer didn't understand, he didn't understand. I just figured I'd just ask the question again, not to repeat the questions that have been asked and answered. So I have no further questions.
네, 선생님이 아까 하셨던 질문에 대해서 선생님이 한국말 때문에 영어 때문에 어려워서 이해를 못 하셨던 부분인 것 같아서 그것은 적용되지 않는 것이라서 넘어가도록 하겠습니다.
예. 감사합니다.
Okay, any other questions before we move forward to Ms. Pruitt? Okay, thank you so much, Mr. Sun, for your testimony.
네, 감사합니다, 선생님. 오늘 증언해 주셔서 감사합니다. 마지막으로 질문 읽도록 하겠습니다.
예.
Ms. Pruitt, you are not planning to introduce any witnesses today?
Not unless, no, that was not my plan to introduce any affirmative witnesses.
Okay, let me ask you the following 2 questions. If you were to call Ms. Lee, I see is present today, but if you were to call Ms. Lee, would she testify to your knowledge of anything different than that the use of a perk machine would be approximately 0.22 pounds per day excess, excuse me, excess emissions of perk?
That is what she would, yes, that is what she would reply.
Okay, thank you. And would she, if called to testify to your knowledge, testifies to anything different than what we have heard in other cases, that the use of a similar perk machine would have an incremental cancer risk of 0.1 in a million for the period of time of 1 year with the use of 10 gallons of perk?
Yes, she would have the same answer, the same risk.
Thank you very much. Board members, would anyone need to hear from, oh, and sorry, Mr. Lee, if you could translate that.
네, 선생님 일단 지금 프루이 씨가 AQMD를 대표해서 나오셨고요. 다른 증인은 오늘 더 이상 부르지 않도록 하겠습니다. 그래서 원래 다른 증인이 나오기로 했었는데 그분도 나와도 똑같은 답변을 해주실 거고요. 지금 아까 말씀하신 퍼크 사용량이 계속 증가함에 따라서 발암 물질이 올라갈 수 있다는 것들도 이 사람들이 똑같이 알고 있고 선생님이 증언해 준 게 다 알고 있기 때문에 다른
예,
증인 부르지 않고 결정을 내리도록 하겠습니다.
감사합니다. 감사합니다.
Board members, anyone wish to hear from any member of district staff? Okay, thank you very much. I'm going to look then at this time. I'm going to see if there's any member of the public who might be present at the hearing who might wish to be heard, and I'm going to give a few moments. And if you are present and you wish to be heard, you can use the virtual raise hand function that you'll see at the bottom of your screen. And I'll give a couple of moments for that. And I don't see anyone who wishes to be heard. So I'm going to go to Mr. Sun and ask Mr. Sun if he would like to make any closing statement before the board deliberates. Mr. Lee, if you can ask him.
네, 오늘 선생님 여기 이사회들한테 들으신 거에 기반으로 해서 결정을 내리도록 하고 여기서 결정하는 것들을 오늘 말씀드리도록 하겠습니다.
예, 감사합니다.
Would you like to?
더 이상 하실 말씀 없으세요?
할 말 없습니다. 기계를 정부 차원에서 사용하지 말라고 그랬는데 부득불 많은 돈을 주고 살 수 없는 형편이 돼가지고는 부득불하고 11월 달까지 12월까지 이렇게 1년 연장을 해서 대단히 송구하게 생각합니다. 어쨌든 배려해 주신 것에 감사하고요. 절대로 법에 어긋난 일은 하지 않습니다. 맹세합니다. 감사합니다. 도와주셔서.
Yeah, first of all, I'm really thankful that you, all the board members and Madam Chair, hear about my case. And I always try to comply the rule. And due to the unprecedented this pandemic condition, I couldn't comply with the rule. But I'll put all my effort to compile the rule if the variance is allowed. And if not, and I have another plan for either way, I'm very thankful for everybody hearing my case. And I'm always a person that abide by the rules, so I would try to do that.
Thank you, Mr. Sun.
감사합니다.
Ms. Pruitt, closing for the district, please.
Thank you. And thank you, Madam Chair and members of the board, Mr. Sun and Mr. Lee. And thank you, Mr. Sun, for coming before the board today. And I do understand that many businesses like yours have suffered an extreme financial hardship as a result of the pandemic. And for the purposes of today's petition, I'm not quite sure if I heard a path to compliance with particularity. You know, I think that I've heard that he intends to make some steps in the future to buy equipment, or that he has the opportunity to go elsewhere to use the equipment so that he would not be in violation. You know, unfortunately, you know, it appears that Mr. Sun has known about the requirements of 1421 for roughly 10 years. And I'm not quite sure that I've heard enough or understood enough to know that he was making any actionable plan to be compliant by January 1 of 2021. So, you know, I'm going to, in this particular case, you know, defer to the hearing board, because, you know, there are a lot of areas that I am unclear, and I do, you know, understand that there is a problem in communicating all of the facts, but for the district, we have not heard enough to support the variance. So again, I would defer to the understanding of the hearing board in this case. Thank you.
네, 선생님, 지금 스테이시 프루시는 선생님이 어떤 노력을 하셨는지에 대해서 증언한 것도 정확하게 이야기를 할 수 없어서 결정을 내리기가 애매모호하기 때문에 지금 이사회에게 결정권을 넘기도록 하겠습니다.
예.
Okay. Oh, thank you very much. So that it seemed like there was a lot more said, but okay. Board members, we're now close the hearing and enter in deliberations. And unless someone else would like to begin, I can.
And excuse me, just housekeeping matter. I'd like to move the exhibit into evidence.
Exhibit A into evidence.
Yes, thank you.
Okay. I'm not sure we are relying on it in any way.
Okay, but you're not, okay, that's fine then.
I think it's okay. Thank you for that. But I don't know that Mr. Sun would know whether to object to that or not. So
Oh,
I just don't
okay,
think we need to. If that's okay, Ms. Pruitt.
that's fine. Withdrawn.
Thank you.
Mhm.
I see Ms. Verdugo Peralta, you raised your hand. You'd like to begin.
Thank you, Madam Chair. I appreciate the candidness that Mr. Sun gave to us as far as his answers. And I too don't see that there's a definite path to compliance. He's talking about it. He's thinking about contacting the people to get a cheaper perk machine versus the one that's $40,000 to $45,000. But I don't see anything definite, nor is there a purchase order, nor is there an agreement between he and another entity to do so. I definitely would not go beyond what we have offered to other dry cleaners as far as the 800-pound limit. I would definitely, I'm real concerned that he has extra perk there. That's my other concern. And the fact that he could go beyond that 800 very easily if he so chose to do so. And he claims that he would be willing to pay that $40 a day, but I don't think I'm willing to allow that to go beyond that limit. That's way too much perk in the environment. And well, I see that he wants a year. That also, to me, is way too long. It's unfortunate that other gentleman is not, it's terrible to say, but is not going to go out of business any sooner than that, or let's say retire any sooner, because that would be ideal if his friend was going to retire any sooner. And whether he's made any type of a cash offer to him, we don't see that in writing either, which would have been nice.
Should Mr. Lee, do you need, or should Ms. Verdugo Peralta finish?
I'm so sorry. I forgot. I'm so
You can
sorry.
finish on Ms. Peralta, and I'll summarize it and let them know.
Go ahead. I didn't mean to stop you, Cynthia. Go ahead.
Do you want me to go ahead?
Yes.
Oh,
Yes,
okay.
ma'am.
So right now, I don't see that that we can grant this variance without something much more definite, like documentation for the purchase, whether it be the cheaper one at the $20,000 range or the $40,000 range, or whatever he was going to pay his church friend. I don't see anything there. So right now, I can't support a variance that long at all. And I would only be willing to limit it to the 800-pound limit. And I'd like to hear from my other board members as well.
네, 선생님, 일단은 선생님이 정직하게 말씀해 주신 거에 상당히 감사를 드립니다. 그렇지만 지금 보여진 바로 안에서는 선생님이 지금 이 룰을 따라가기 위해서 어떤 노력을 하시고 계신지 정확한 정보가 나와 있지 않기 때문에 결정을 내리기가 어렵고요. 일단 아까 말씀하신 것처럼 교회 장로님이 그 기계를 좀 빨리 전해주셔서 하실 수 있다면 더 좋겠지만 그렇지 못한 상황이고 1년 동안 허가를 연장하는 기간은 너무 길고 그런 경우가 거의 없기 때문에, 그리고 아까 말씀드린 것처럼 연장을 하더라도 하루에 40불을 내시고 800파운드의 리미트가 있는데 800파운드를 넘어갈지도 모르고 가지고 계신 그 펄크 양이 너무 많기 때문에 현재로선 결정을 허가 신청을 내려드리기가 좀 어렵습니다. 일단 다른 이사회 멤버들의 결정이 어떻게 되는지 저 들어보도록 하겠습니다.
Thank you.
I had one more, just one more comment. It also dismays me that he's known for this many years. He said he's known for 10 years, and he's been part of the Korean Dry Cleaners Association. When we were first putting this rule together and we met with the Dry Cleaners Association, it was with the clear understanding that everybody was going to do the best that they could to do it within a much shorter amount of time than the 18 years that they did have. And since he's known about it that long, the fact that he waited such a long time last minute to do this is very dismaying to me. I understand the fact that everybody has been suffering through this pandemic, and businesses, certain industries have been hit harder than others, but I would have thought he would have been better prepared. Thank you.
네, 그리고 팬데믹 때문에 모든 사람들이 지금 자영업자들이 어려움을 겪고 있다는 걸 잘 알고 있습니다. 그렇지만 선생님이 이 펄크 사용을 제한하는 법률에 대해서 이미 10년 전 이상이 알고 계셨고 그 기간 동안 많은 노력을 하지 못한 점이 좀 안타깝고 지금 이미 그 옛날에 그 코리안 어소시에이션을 통해서 알고 계셨다면은 이 법률을 따라서 조금 더 노력하셨으면 좋았지 않았을까 하는 생각을 갖고 있습니다.
제가
Mr. Please let Mr. Sun know we closed the hearing.
선생님 더 이상 발언권이 없으시니까 그거에 대해서는 얘기를 못 하십니다.
Mr. Lee, you don't have to translate this, but I'm seeing that our next matter that the parties are assembling, just to let you all know, we are right now finishing up the first matter we had on calendar. We are in deliberation. I would assume maybe another 15 minutes or so for deliberation and a decision. And then we will likely we took a break recently, so we will take another 5-minute break. So no sooner than 11:20. So I'm assuming sometime between 11:20 and 11:30. So just hang on. Okay, I wanted to weigh in on this matter, and now Mr. Lee, you can interpret. I wanted to first start off by agreeing with, I want to agree completely with Ms. Verdugo-Peralta, but I want to agree first that I thank Mr. Sun. I think Mr. Sun is very credible and honest with us today. But I don't know, I get the feeling that Mr. Sun was not aware before today what was the standard that we needed to look at and what were the findings that we needed to make. And it's those findings that I am unable to make today.
네, 의장님은 방금 전에 말씀하신 버디고 퍼랄타 씨가 하는 이야기에 전적으로 동의를 하고요. 선생님이 영어 때문에 어려움이 있으셔서 다 이해를 못 하셨다는 것도 잘 알고 있습니다. 선생님이 오늘 정직하고 솔직하게 말해 주셔서 너무 감사하지만 지금 저희가 가지고 있는 자료를 봤었을 때는 선생님이 이 법률을 따라가기 위해서 어떤 노력을 하셨고 그렇게 할 수 있을지가 의문이 드는 바입니다.
There are a number of factors that I would look at that lead me in this case, as opposed to perhaps others, to not be able to make the findings. Number one, and these are not in any particular order, but I just jotted them down. Mr. Sun stated that he did know at least 10 years about the rule. And unlike other matters that we've heard, his machine is quite old. And so we heard from other petitioners that perhaps they purchased much more recently and were simply waiting as long as possible to turn over the machine. But that's not the case here.
네, 일단 선생님이 제가 찾고 있던 요소들이 있었는데 거기 일단 선생님 10년 전에 이 법률에 대해서 알았지만 그렇게 지키지 못한 점 그리고 그 기계가 너무 오래됐다는 점이 저희의 걱정을 사게 했습니다.
On top of that, Mr. Sun said that he had received a quote about 2 years ago with regard to a new machine, but was unable to purchase that machine. And so I don't think even going into the pandemic that there was a plan and a path forward to compliance.
네, 그리고 선생님이 이미 재작년에 유니온사를 통해서 기계에 대한 가격을 알아보셨다고 했는데 2년 전임에도 불구하고 그렇게 하실 수 없었기 때문에 팬데믹이 터지고 이 이유가 나아진다고 하더라도 그 기계를 어떻게 매입해서 이 법률을 따를 수 있을지 아니면 다른 기계를 매입할 수 있을지 걱정이 됩니다.
Mr. Sun also was very honest and said that his business depends more on his washing machines than on his perk machines. Only a third of the business on perk, and he does have currently 2 other options to send his cleaning out in terms of 2 compliant machines.
네, 그리고 선생님이 솔직하게 말해주신 점에 대해서 감사드리고요. 일단 드라이 클리닝이 선생님의 총 매출의 3분의 1밖에 차지하지 않는다는 점, 그리고 만약에 허가가 되지 않는다, 연장 허가가 되지 않는다도 선생님이 이 물건을 다른 데로 보내실 계획을 갖고 있다는 점에 대해서는 상당히 좋게 생각합니다.
And for those reasons, I'm having a very difficult time finding beyond reasonable control. And also moving forward, I don't see at all a path to compliance. Mr. Sun has stated he has already used almost half of the 800-pound limitation that we would give if we could make the findings. And he also stated, I believe, that his friend's machine with installation would be about $45,000 and that's not something he currently could afford anyway. So I'm not sure that that is a path forward anyway.
네, 그리고 허가가 난다고 하더라도 800파운드의 리밋이 있기 때문에 선생님이 아까 이미 그거의 절반이 가량 되는 것들을 이미 오래 사용하셨기 때문에 나머지 400파운드로 1년을 사용한다는 건 거의 불가능하다고 생각이 되고 선생님 친구분에게 그 기계를 당장 매입한다 하더라도 4만 불, 4만 5천 불이 드는 상황이기 때문에 그것을 따라서 법률을 지키기는 어렵다고 판단이 됩니다.
So in sum, what I got from the testimony today was that while Mr. Sun would like to have the variance, he will continue, the cleaners will continue regardless of whether there's a variance. And so I don't think for all those reasons that I would be able to make the findings for a variance today.
그래서 종합적으로 봤을 때 선생님의 비즈니스는 워싱머신에 더 의존해 있고 그 다음에 그렇지 허가가 나지 않더라도 선생님이 다른 계획을 갖고 있으시기 때문에 모든 것을 종합적으로 봤을 때 이 연장 허가 신청을 해드리기는 어렵다고 판단이 됩니다.
Board members, additional thoughts? Mr. Balagopalan.
Yes, I too unfortunately cannot see a path to grant a variance using Ms. Pruitt's term actionable plan. We didn't see any actionable plan provided by Mr. Sun.
네, 선생님이 정확한 계획을 아직 기계 매입에 대한 정확한 계획을 가지고 있지 않기 때문에 볼라거폴란 씨도 선생님의 입장에 동의를 해드리기가 좀 어렵다고 말씀하십니다.
We don't have a recent code for a new or a used machine provided to consider. I was pausing so you can translate, Mr. Lee.
지금 사용하시는 새로운 기계를 구입하신다 하더라도 가격이 꽤 나가고 선생님 지금 구입하시기는 어려워 보이는 걸로 보입니다.
And also trouble that he has continued to operate in violation of the rule since the beginning of this year.
그리고 올해부터 원래는 사용하시면 안 되는 거기 때문에 이미 지금 그것을 위반하고 계시는 상황입니다.
And the other aspect is he has also purchased, or I don't know why, or people knew to give him their unused perk to continue to use. So I'm a little troubled by that he has acquired more perk from those cleaners that were going out of business.
네, 그리고 이미 선생님이 가지고 계신 퍼크에 포함해서 친구분한테 그 퍼크를 또 받아오셨다는 것도 사용을 줄여야 되는 마당에 위험 요소가 된다고 생각합니다.
On the other hand, I'm glad to hear that he has 2 washing machines and most of his income is currently from those 2 machines. And he's willing to convert to an agency shop if he doesn't get the variance. So he can still continue as a viable business until he comes into compliance.
그렇지만 다행이라고 생각되는 것은 선생님의 비즈니스가 그래 대부분 워싱머신을 기반으로 하고 있고 만약에 오늘 허가 신청이 되지 않더라도 선생님이 계획을 가지고 다른 데 보내실 계획을 갖고 있기 때문에 그것은 다행이라고 생각됩니다.
So I'm going to oppose granting the variance.
그렇기 때문에 지금 연장 허가에 대해서는 전 반대 입장을 표명하도록 하겠습니다.
Thank you. Board members, any other thoughts on the findings? Dr. Bernstein.
Thank you, Madam Chair. Once again, we are charged with the responsibility of determining the factors for and the findings for a variance. And as my colleagues have stated, it is my opinion that we cannot make those findings today as well. We have a business that was established in 1996. Mr. Sun has stated that he has been aware of Rule 1421 for a decade at least, and continues to utilize his perk machine out of compliance, having stated that he was aware of the rule. Being a member of the Korean Dry Cleaning Association, I'm quite sure that they implemented a campaign so that their members would be fully aware of exactly what was coming and what the consequences were. We have a machine that is outlived its life cycle as well, and a vague path to compliance that really does not fit the bill as far as I'm concerned. And therefore, for those reasons, I am unable to make the findings to support a regular variance today.
네,
Thank you.
선생님 말씀하신 것처럼 1996년에 선생님이 비즈니스를 시작한 이후부터 10년이 넘는 기간 동안 이 법률에 대해서 알고 계셨는데 지키지 못한 것이 상당히 안타깝고요. 그 다음에 코리안 드라이 클리너 어소시에이션에서 선생님에게 충분히 이 법률에 대해서 얘기를 했을 텐데 그게 지켜지지 못한 부분이 상당히 안타깝습니다. 그리고 현재 사용하시는 펄크 기계가 24년이 넘었기 때문에 너무 오래된 기계이기 때문에 현재 이 법률을 지키기 너무 어려운 상황이고 선생님에게 지금 연장 허가 신청을 해드리기가 어려운 입장을 표명합니다.
Thank you. Anyone else wish to have any thoughts? Senator.
Mr. Sun, I clearly understand your situation today, which you face. Number one is that at the time this rule was adopted, no one anticipated that there would be a pandemic. Number one. And number two, you, as most business people, were maximizing the use of their equipment as the deadline approached, not knowing there would be a problem also. Go ahead.
첫 번째로 선생님이 팬데믹은 아무도 예측하지 못했기 때문에 의사들도 예측하지 못했고 너무나 안타까운 상황이라고 생각합니다. 그렇지만 이 펄크를 사용할 수 있는 마지막 날짜가 다가옴에도 계속 불구하고 선생님이 펄크를 계속 사용하셨다는 거에 대해서 좀 위험 요소가 있지 않나 그렇게 생각됩니다.
You stated repeatedly that you're under oath and you would share nothing but the truth with this board, which is good to hear. Then you went on to say that if required, you would contract your cleaning out services out to another cleaners. Go ahead.
네, 선생님이 아까 말씀하셨던 것처럼 오늘 그 선서를 하셨고 정직한 답변을 해주셨기 때문에 그리고 오늘 만약에 허가가 나지 않더라도 다른 에이전시에 이 다른 클리너의 세탁물을 보내서 이 일을 처리할 거라고 말씀하셨습니다.
It was my understanding that if the pandemic was not upon us, that you would have sufficient funds to purchase use or new machine. That's my understanding. Karen asking.
네, 제 생각에는 만약에 팬데믹이 없었다면 선생님이 새로운 기계를 어떻게든 매입하셔서 사용하셨을 거라고 계획을 하고 계셨다는데 맞습니까?
At the very beginning of the hearing, it's been repeated that each cleaning business will be considered on a case-by-case basis. That means that one size or one set of conditions don't fit all.
네, 그렇지만 말씀하신 것처럼 어떤 것들마다 케이스마다 다르기 때문에 선생님 케이스는 또 다를 수 있고 다른 클리너의 케이스는 또 다르기 때문에 여러 가지 다른 입장이 있습니다.
However, when decisions are made previously, they were made based on each being imposed a set of conditions which are equal. The same set of conditions that were imposed on every single cleaning business.
네, 그렇지만 이런 공청회가 이전에 있었을 때 결정을 내릴 때도 모두 다 동일한 어떤 법률을 적용받았고 동일한 상황을 적용됐기 때문에 그것을 잘 아셔야 될 것입니다.
Which is a deviation or non-compliance with the so-called case-by-case decision for conditions.
네, 아까 말씀드렸던 것처럼 이 법률에서 벗어나긴 하지만 그 개인의 상황에 따라, 케이스에 따라 다른 거기 때문에 그 점을 잘 이해하셔야 됩니다.
I know that a good chance to confuse you as much as it does me when it's not reviewed or considered on a case-by-case basis.
네, 그래서 선생님이 왜 어떤 데는 허가가 되고 어떤 데는 되지 않느냐 이렇게 말하실 수도 있지만 저에게도 그렇게 결정하는 어려움이 있고 그것은 케이스마다 여기 있는 이사 분들이 이야기를 듣고 결정을 하시는 거기 때문에 이해해 주시기 바랍니다.
Going forward, it's based on my understanding. There's a possibility for you to comply with 1421 by contracting your cleaning out and waiting until the pandemic clear, where your funds will be, your income will be sufficient to buy a used machine or new machine.
네, 그래서 현재는 어쩔 수 없이 허가 신청이 되지 않으면 바깥으로 그 아웃소싱을 해서 그 일감을 보내시고 팬데믹이 끝나면 그 이후에는 선생님이 어떻게 해서라도 새로운 기계를 구입하시거나 중고 기계를 구입하셔서 설치할 거라고 생각이 되고 있습니다.
Conditions imposed on you would be separate and different from the conditions imposed on other cleaning businesses, which is mean to say that one size don't fit all.
네, 선생님한테 다시 말씀드리지만 선생님의 비즈니스와 또 다른 비즈니스는 다른 입장을 갖고 있기 때문에 다른게 적용될 수 있다는 것을 알려드리고 그렇기 때문에 지금 현재 상황에서는 개개인마다 다 다른 상황에 처해 있기 때문에 어떤 한 사람을 특정해서 똑같은 법률을 적용할 수는 없습니다.
I wish you a favorable outcome. 감사합니다.
네, 일단 감사합니다.
감사합니다. 제가 바라기는 펄밋 기간만이라도 허용해 주시면 좋겠습니다. 감사합니다.
I would explain them that his chance to speak was closed.
Thank you. Thank you, Senator. Okay, if there's no other thoughts, I'm going to offer a motion. And again, I just want to be clear on the record that this motion, as all others, are based on the specific facts and how we tie those specific facts and evidence to the 6 findings as was articulated by each board member in turn today.
네, 결정에 있어서 오늘 세부 사항들이 어떤 사실을 기반으로 해서 만들어졌고 모든 결정들은 그 사실을 기반으로 해서 결정된다는 것을 말씀드리고 싶습니다.
With regard to this specific matter.
네, 이 케이스에 적합한 그 사실들을 기반으로 하겠습니다.
And it speaks for itself. Okay, in the matter of Doak's Cleaners, case number 6200-1, I move that we deny the regular variance as requested for a failure of the board to make the 6 findings and in particular beyond reasonable control.
네, 독스 클리너와 관련된 6200-1 허가 연장 신청은 이사회들의 결정에 의해 그리고 6개의 저희가 필요로 하는 요소들을 충족시키지 못하기 때문에 허가에 반대하는 것으로 결정하도록 하겠습니다.
Is there a second?
I'll second it.
Mr. Balagopalan seconds that motion. Is there any discussion on the motion? Okay, seeing no discussion. Dr. Bernstein, how do you vote?
Aye.
Ms. Verdugo-Peralta, how do you vote?
Aye.
Senator Holden, how do you vote?
No.
Mr. Balagopalan, how do you vote?
Yes.
I vote yes. Motion passes 4-1. And Mr. Lee, if you can explain again to Mr. Sun that we do very much appreciate his candor, his time today. We wish him good luck, and that our decision to deny the variance was simply based on our inability to make the findings we're required to make by law.
네, 선생님, 안타깝게도 허가 신청은 4대1로 반대가 되었습니다. 그 기본적인 그 이유는 선생님이 제출하신 선생님 증언과 서류에 대한 정보에서 의한 것이지만 선생님의 비즈니스가 더 잘 될 수 있도록 마음으로 바라고 있고 지금 이렇게 반대의 결과가 나온 것은 그런 것을 기반으로 했다는 것을 말씀드리고 싶습니다.
And thank you, Mr. Lee, very much for your service today. Ms. Pruitt?
Thank you. And in that the variance was denied, I would ask that you please remind the petitioner that it would be required that either he remove the machine or in this case, disconnect the perk machine from the utilities and drain the remaining perk from the machine.
네, 선생님, 지금 허가 신청 연장이 지금 반대로 허가가 안 났기 때문에 이 이후로는 더 이상 퍼크 기계를 사용하지 못하고 기계를 빼내거나 아니면 기계에 연결된 호스들을 빼서 그 안에 있는 퍼크를 모두 다 빼내셔야 됩니다. 아시겠습니까?
예.
Understood.
Thank you.
Thank you so much. We're going to end that hearing. So Mr. Lee, Mr. Sun, Ms. Pruitt, we're going to end that hearing. So you may leave the Zoom hearing if you wish.
Thank you, Madam Chair and members of the board.
Thank you again.
선생님, 이제 나가셔도 됩니다.
Okay, board members, we have one other matter on the calendar that was calendared for 11 o'clock, but I would like to take a little more than a 5-minute break so that we can put away these papers, focus ourselves, and then pick back up on our second matter, which is a continuation of our hearing in Booster Fuels with regard to the subpoena for documents, the subpoena request for documents.
Madam Chair?
Oh, yes.
I just wanted to let the board members know that some documents were sent this morning, probably about a half hour or so ago, regarding the upcoming case. So they will want to make sure that they receive those documents or check for them. They came by email.
Okay, thank you so much, Madam Clerk. Okay, so let's look for those and reset ourselves in terms of our papers and mindset, and we'll be back on the record at 11:30. We are off the record. Okay, it's 11:30, and so I'm going to call for everyone to reassemble as soon as we can. Ms. Verdugo Peralta, if you're available. Wonderful. Okay. I think we have everyone present, and so I'm going to, so many things open on my, okay, on my desktop. Let's see. Okay, I want to call the next matter, which is Booster Fuels, Inc., case number 6171-3. It is an appeal from permit conditions. However, today we have on the agenda only to hear the continuation of our hearing from January 27th, which with regard to the issuance or the request for the issuance of a subpoena for documents. Board members will remember and parties will remember that we ended last time during the direct testimony of Mr. Okpaku. And so we will pick up there in a moment. There was an estimation of time. It will take several hours for us to be able to complete this hearing today. So I'm glad we're pretty much on time for when we had estimated it, and let's see how quickly we can get through it. Let me just begin by asking who is present today representing Booster Fuels.
Madam Chair, I just wanted to interrupt for just a moment and remind everybody that today is the day I have to go get my COVID vaccination, and I will probably be leaving between 2 and 2:30, but I will be on my laptop.
Okay, and you can be on the laptop till 4?
I think so.
Okay.
I hope so.
Okay, great. Okay, who is representing Booster Fuels today?
Good morning, Chair Prusek. This is Ryan Height on behalf of Booster.
Barry Groveman on behalf of Booster.
Okay, and who is representing the executive officer today?
Good morning, this is Erica Chavez on behalf of the executive officer, and I'm joined by my colleague.
Mary Reichert, also on behalf of the executive officer.
Okay, thank you and good morning all. This morning while we were in our other hearing, we did receive 2 documents that were filed or given to the clerk from Ms. Chavez. I assume that these were also sent to Booster Fuels, is that correct?
Yes, they were.
Okay, I would like to mark them. We have 2 letters, both on South Coast AQMD letterhead. Both are 2-page letters. The first one is dated January 24th, 2020, and it is to Mr. Taylor Henderson. And I'm going to mark that as Exhibit A, as an apple, for the district. And also we received a second letter September 10th, 2020 to Scott Weaver and Yi Tian of Ramble. And that will be marked as Exhibit B, as in boy. I'm also going to, at this time, swear in anyone who plans to testify or who may be called to testify today. Mr. Height?
Thank you, Madam Chair. Our client's Representative Taylor Henderson may have to testify today in any type of response to questions, and he is unable to get on. He's trying to create a hotspot. So you just may have to do him once he gets on, give him his swearing in.
Okay, and we'll have whoever is monitoring, I don't know if Anthony, if you're still monitoring, or if Paul is.
He just got on.
Oh, I see. I
Hey.
see.
Okay.
I apologize. I apologize about that. I had trouble. The internet was not letting me get.
Okay, I was just swearing in witnesses. That means anyone who plans to testify or who may testify. So Mr. Henderson, that would include you. If you would like to, please turn on your camera, raise your right hand. Do you swear or affirm under penalty of perjury that you will tell the truth, the whole truth, and nothing but the truth?
I do.
I do.
Thank you all very much.
I do.
Board members, I don't want to take too much time, but I do, because this is such a complicated matter, one that we do not usually hear as a hearing board. I do want to remind us what is the subject of today's hearing, and that we are very much limiting today's hearing to that subject matter. And that is right now, the one subpoena being sought by Booster Fuels, and that is for documents. And so, again, I want to just quickly share my screen. If I can find it. I think this is it. Are you seeing Hearing Board Rule 9? Okay. For subpoenas, again, it is Booster Fuels' burden to demonstrate 3 things with regard to the documents with which they seek. And that is, number 1, that the information sought is relevant and material to the subject matter involved, and that is involved in the appeal. I'll get to that in a second. The information is not privileged, and considering all the circumstances, including the return on the subpoena, complying with the subpoena will not impose an undue burden. So that is what we are looking at today. With regard to the first, that the information sought is relevant and material to the subject matter involved. I'm going to stop my share. I want to remind board members that we're looking at Health and Safety Code section 42302. And again, this is the standard of review on appeal. It's only relevant in terms of whether we are able to find enough evidence that what is being sought today, the documents being sought, are relevant to this standard of review. And it is an applicant for a permit that has been denied, or for which, in this case, they are appealing the conditions of the permit. The hearing board, the standard is whether that permit was properly denied by the executive officer. And when we're looking at that, we're looking at the rule under which and the standard under which the executive officer issued the current permits, which is Rule 441. And I just want to quickly share that so that we all see what that is. Okay, sorry, I have to wade through and find 441. Okay, you all see that? Rule 441 is research operations, and essentially what it says is the provisions of Regulation 4 shall not apply to experimental research operations when the following requirements are met. The purpose of the operation is to permit investigation, experiment, or research to advance the state of knowledge or state of the art, and the APCO, which is the executive officer, has given written prior approval, which shall include limitation of time. And the APCO shall not grant approval unless the operation is conducted in a manner to minimize emissions into the atmosphere to the maximum extent possible. So again, when granting the research permit that is at issue, this was the standard that was followed. And in particular, unlike normal permits, the provisions of Rule 461 with regard to prohibitions for gasoline dispensing facilities do not have to be followed if this can be met. So that is the standard that we're looking at. Again, I want to just be very clear, we're limiting to the subpoena for documents and whether those 3 findings are met, including relevance. With that, if there is no other preliminaries we should go through, I'm going to turn it back over to to Mr. Height to continue his direct examination of Mr. Akpaku. Were there any other preliminary matters we should discuss? Okay. Mr. Height, I'm going to turn it over to you then.
Thank you, Chair Prusek. I had one, I didn't want to interrupt you. The one preliminary comment we had is we received documents this morning that apparently might pertain to some testimony that AQMD employees are prepared to provide today. We wanted to be able to take a recess because we've been basically on hearings since those documents were sent to us. We haven't had a chance to confer with our client regarding those documents. So we will need an opportunity to meet with our client regarding that was sent, very recently, if that's okay. That
is fine. And would you prefer to have that time before you continue with Mr. Akpaku, or before those documents are introduced by the district?
Yeah, I think the best way to proceed is I will continue with Mr. Akpaku, and then when that's finished, maybe we can take some sort of brief recess, and then I think we'll be done from our end, and then it would be turned over to AQMD.
What we'll do is, why don't you go ahead? I think you had estimated about a half an hour. Is that correct?
Yes. Yes.
Okay. So why don't we complete your direct, then we'll go for lunch. And at that point, we'll give as much time additional as you may need to go over those. And I think the board also, I did not have an opportunity to really look at those documents either. So
okay.
We'll do it at that time. And you may proceed, Mr. Height.
Okay. And then just to summarize from our prior hearing, I had Joe, I'm going to refer to you as Joe. We had gone over the relevance of documents that we're seeking through the application of subpoena regarding the original purpose of the permits that Booster was seeking from AQMD. And then we also covered the scope of the permits that AQMD was proceeding. And the one question I didn't get to complete with you regarding the scope of the permits for Booster's research and development was that do you believe that the AQMD employees have records that are relevant and that will help show that the original scope of Booster's permit was really intended for more than 5 vehicles and up to at least 11 vehicles?
Yes, I do.
Okay. So now turning to Booster's specifically has been requesting these 6 additional permits for the 6 additional MFOD units. They've been requesting those 6 additional trucks can you let me know how long they've been requesting those 6 additional trucks?
Yeah, I believe the first time that we actually put in the request for the additional tankers was in late 2018 is my best recollection. So yeah, that's when I think that's when the subject of expanding the permits to include 6 additional tankers began, is in late 2018.
Okay, and who are you working with at AQMD regarding the 6 additional trucks that you were seeking?
So just to be clear, this was I was not directly involved in this aspect. I believe Mr. Henderson did testify to this. I was not directly involved in this engagement with the district at this particular time. But I'm aware who Mr. Henderson was engaged with, if that's helpful.
Okay, that's fine. When you did become involved regarding the 6 additional trucks, who were you working with at AQMD when you did become involved?
I had a lot of conversations and correspondence with Ms. Karen Manwaring about it. There were also conversations with Mr. Tassopoulos before he moved on to the Ventura Air District. There were conversations with Amir, and I apologize, I'm going to try my best, Deshbosh, I believe is.
Deshbosh, correct.
Yes, I apologize, that's a tricky one for me. I know that Mr. Matsuyama was involved in conversations. I mean, there were a lot of people on the district end who, we had conversations with that touched on this, including, members of the compliance team. Marianne Coleman was also involved. That's probably not a full list, but those were probably the primary people that I spoke with during this process.
No problem. Thank you. In regards to Ms. Manwaring, did you have direct conversations with her regarding the 6 additional trucks?
Yes, several.
Was it just you and her in those conversations at some times?
At times, yes.
Okay.
Well, let me, as far as I know, because there were phone calls, I believe they were just myself and her. So that was my understanding for several of the calls, correct.
Okay. When you were having those calls with her, what did you understand her role to be as far as Booster's permitting of the 6 additional trucks?
Yeah, so, Mr. Henderson did testify to this, and trying to make a very long story short, when we had, raised the issue of, following the conversations with Mr. Tassopoulos, that if we were, going to move to a rulemaking and to support that we would need to do a regional emission study. And in order to properly do that, we would need 6 additional tankers. We obviously had to get permission from CARB to do so, which we got. And then there were some questions that arose about some potential violations that resulted from our operations under the permit earlier. In no particular order, one of those violations, which I believe was resolved, and I have an email saying that it was resolved. One of those things was that we had opened a top hatch to inspect the tank. This was counter to Air District rules. When they notified us about it, we immediately came up with a process to make sure that that could not happen. We essentially locked the top hatches to all the tankers. So we believe that was resolved. And then there were some questions about our records with respect to our ORVR system that we developed. I believe I testified about that last week, about the accuracy of those records and some questions. So the way it was explained to us is that once we got, compliance satisfied with where we stood with those issues, that the matter was going to be transferred over to legal, and essentially legal would figure out the ultimate resolution so we can move on with the additional permits.
Okay, but just very succinctly, when you were interacting with Ms. Manwaring on the seeking the 6 additional trucks, how did you perceive her role at AQMD? Did you perceive it from a compliance perspective, or what do you believe? In what way did you perceive her role?
Well, that changed over time. And initially, I thought it was kind of more procedural, that she would, I guess, somehow confirm the fact that, as we had been told, that compliance was satisfied and ready to move on. So, maybe there'd be some documentation or something. Over time, it definitely changed. Ms. Manwaring began to weigh in a lot on issues of the, environmental bona fides of our operations, and had a lot of questions and comments about that, about the environmental impact of our operations, which, seemed odd to us, because those were conversations that we typically had with other departments. But we, continued engaging in those conversations in good faith. And then, it's kind of a long story to tell, but the nature of the communications with Ms. Manwaring definitely changed and became, I would say, progressively more adversarial over time.
Okay, but just to be clear, can you describe her role, if you had to, at various points? Either did you perceive her to be involved in more things than just handling the notices of violation, is what I'm asking?
Yes, eventually, yes.
Okay, and what areas was she working on other than handling the notices of violation?
Well, like I said, there were, I mentioned that she had thoughts and opinions and questions about what I would consider more technical, engineering related aspects of our operations, the environmental impact. She also had a lot of questions about the nature of our our permitting processes with fire departments, and that became a fairly complicated issue. I believe I may have touched on this briefly last week, but
that's okay, Joe. I'm just, and you did testify to that, so we already have covered that.
Okay.
I just wanted to clarify that you, from your perspective, you saw her in a role other than handling the notices of violation. Is that correct?
Yes.
Okay. Moving on, have you worked with anybody at CARB regarding Booster's efforts to obtain the 6 additional permits with AQMD?
Yes. Primarily with Brad Cole. That's been our main contact.
And just to clarify again, what is Brad Cole's role at CARB?
I may, oh goodness, I'm probably going to get his title incorrect, but he is involved with the, I believe the team that handles the certification of vapor recovery systems and or tank systems. But I apologize, I can't remember his exact title.
That's fine, no problem. But generally, from your perspective, I know that Mr. Henderson was working much more specifically, and he's already testified to all this, but I'm just trying to get your general perspective. Was it your understanding that CARB supports or in generally does not have any limitations to how many vehicles Booster can operate in the South Coast Basin?
Yes, when we originally approached the district about expanding the permits to include 6 additional vehicles, one of the first steps we had to do was get approval from CARB, and that involved a lot of work with Brad Cole and his team. And yes, they did sign off on the on expanding our permits to grant 6 additional tankers.
Okay. One more question on the, if you can just briefly describe to me, even in, just very, general terms, is there, has Booster provided explanations to AQMD as to why it needs the additional trucks for the purposes of what AQMD is trying to achieve through this research and development permit? And if so, can you briefly explain that information that you've provided to AQMD?
I will try to be as brief as possible, but it is kind of a long history. So yes, as I mentioned before, the initial conversation was, the purpose was to have a more accurate sample size of a market in the context of what real booster or mobile fueling operations would look like. And that was the original context of the conversation around these 6 additional permits. The district, had certain, steps that they wanted us to go through to get to that point. And we believed that we got through all of those steps. And that was confirmed to us when we received a voicemail that we still have recorded from Mr. Matsuyama that said, and I'm paraphrasing, but I do know that he said specifically, like, I have good news. We are ready to go ahead and accept your permit applications. He also said something along the lines of, we've discussed it with the higher ups, and something along the lines of, we are ready to proceed. So at that point, we submitted the permit applications, we submitted payment for them. And that's, again, when, we were told that we have to pause because there are some, compliance related questions. We believed that we had responded to all of those. And then again, that's when the case got, or however you want to put it, got, transferred over to Miss Manwaring, at which point a lot of different things were thrown at us as that were reasons why it seemed that the district was looking to, I guess, backtrack from its earlier commitment to expand the permits and to allow the additional tankers. And in no particular order, those conversations involved, what the scope of the original permit was and whether we had violated it. We had heard at times during this period that we had violated the permit by operating with fleet customers as well as campus customers. And for clarity on this, the way mobile fueling, the way we operate mobile fueling, there's basically two verticals of our business. One is the app-based model, where if you're at work and you park in your, your office parking lot, you can request a boost through the app, and we'll come by and fuel the vehicle. By the time you're ready to drive home, we have fueled your vehicle. But we also do fleet fueling, which is nothing really all that new. That's been going on for decades, where companies that have fleets of vehicles will request our services. And so at one point it was said to us that we never had permission, or that we were not supposed to be fueling fleet vehicles under our permits. That was incorrect. At one point we heard that we were not supposed to be operating outside of either Irvine or Orange County. I forget exactly which it was. And that was apparently a violation of the permit. That was incorrect. We heard that one of the things that was raised was the issues with our ORVR record provision of ORVR fueling records. And on that point, we conceded that, yes, when we first stood up this system, we were having a couple of errors that we had to work through, because, there's literally no system that I'm aware of that is developed without any sort of period of beta testing that is not likely to have some sort of bugs. The two most notable bugs in terms of the ORVR system, and again, remember that what we were doing and what we built from scratch was a system that could take a license plate, run it through a database, determine what the vehicle identification number is, run it through another database, determine what the year, make, model, and build of the vehicle was, and then determine whether that vehicle did or did not have ORVR built in to the vehicle, because we were supposed to only fuel ORVR vehicles. Two of the problems that we had with that right off the bat were with vanity plates, which would sometimes result in pulling a vehicle that was not actually a California, it was not actually the vehicle that we thought it was. It would ping a vehicle that was, maybe in Idaho or something. We fixed that. And the other issue was with dealer plates, temporary plates, and we were able to fix that as well. So we felt that once we had explained, again, that, well, obviously there were going to be some errors because we built the system from scratch and never had a chance to beta test it. And so we felt that we had resolved those questions. Apparently, I'm honestly not quite clear at the moment where we stand with respect to that. We've asked for clarification as to, whether they found our ORVR system to be, working properly, and we believe it does, but I'm still a little unclear as to where they stand. So that was a big issue. Going back to the fire permitting side. So on the fire side, fleet fueling is handled quite differently than this new idea of mobile fueling on demand that is the app-based service. And on the latter point, actually, for what it's worth, Booster actually worked with CAL FIRE to help them develop a regulatory framework for regulating mobile fueling on demand, which was ultimately taken to the International Code Council, adopted into the 2018 version of the International Fire Code, and then adopted in California. So for places that we were doing campus fueling, we were getting permits under 5707. But historically, for fleet fueling, a lot of fire departments do not require permits, and there were plenty of places where we would call and say, "Do you want a permit for fleet fueling?" And we would be told no. But we were told verbally, so we were not able to document it. And this led to a long back and forth about, I guess, a suspicion on Ms. Manwaring or the district's part that we were somehow trying to hide operations or were not properly getting fire approval. This led to an NOV from the district relating to fire approval specifically. Ironically, we haven't gotten any sort of pushback from any fire regulators, despite the district's outreach to a lot of our regulators. We're still in good standing with them. So that was an issue. It was raised at one point that we were essentially trying to hide the scope of our operations broadly, which struck us as very surprising because we were providing very detailed fueling records of all of our operations from day one under the permit. So the long story short is that, the reasons for no kept on changing, but the answer always seemed to be no, no matter whether we completely debunked the concern or responded to the concern, or whether the concern was just blatantly inaccurate on their part, but it didn't seem to change the result. The result always seemed to be no.
Okay, thank you, Joe. And I understand there's a long history. It's a very complicated matter. I appreciate you going through that. If you could just provide me a short statement, just a little bit more concise regarding AQMD's current request for research and development.
Sure.
Does that, can that be accomplished with 5 trucks only?
We don't believe so.
And why is that?
Yeah, so under the current permits, one of the conditions was that we install and maintain a GPS system on each of our tank vehicles to collect and study information about trips and routes and locations and times of when the engine starts and stops, et cetera, locations and, of times of, duration of any sort of idling events, et cetera. Essentially what we believe to get a better idea of what, again, what mobile fueling operations, under a normal circumstance and not geographically limited by virtue of the limitation on tankers would look like. So, we still believe, whether it's under the prior permits or under the current permits, that expansion of the R&D to include additional tankers is really the only way to get any sort of realistic view of what typical mobile fueling operations look like. So
may I interrupt? Mr. Hyde, I just want to be clear, we're not arguing the appeal, correct? I want, if your questions can be directed as to the request for subpoena and how that is relevant to the appeal and what you're seeking on appeal, more than whether or not the tankers are necessary or not.
Well, that's correct, Chair Prusak. We are limiting it, but the problem is that it's the records that we're seeking relate directly to Booster's continued request for 6 additional trucks. And what I'm demonstrating here through his testimony is that the AQMD has requested research through the current research and development permits that cannot be obtained without these 6 additional trucks. That's why this testimony is critical.
Understood, but the documents you're seeking in this current subpoena are from a long time ago, not from this current, like 2017 through 2019. So I just—
Well, with all due respect, they've been working very closely with AQMD and many employees at AQMD who come and go, but the continued theme, and it's not—
I just need to object. We're arguing the substance now. I feel like we're well beyond just addressing whether this is on topic or not.
That's right. Let's just I'll stop there. Let's just keep it on topic as much as we can. And if it does go to a foundation for your questions, let's try to get there quickly.
Yes, and I was just getting there. Thank you, Joe, for that regarding the need for the additional 6 trucks and the current research obligations that you're under. And what you just said was that the 6 additional trucks will achieve what AQMD is asking for. So do you believe that the records that AQMD has that we're seeking are relevant to what we're trying to demonstrate to the AQMD hearing board?
Yes, and here's why. And I remember from last week, there were a lot of questions about the relevance of some of the older documents, and if I can put that into a little bit of context, I will do so right now. So, and the only reason we're currently appealing on the second set of permits is because, from our perspective, essentially every action taken by staff made it impossible for us to continue with the first permits despite their initial commitment to work with us. And again, their apparent approval of our expanded original R&D permits, which is again what we believed was what happened when we got the message from Mr. Matsuyama saying, good news, we're ready to process your permits, and they accepted our payments for the permits. So as we've stated, as I've stated, as Mr. Henderson has stated, the original purpose of the original R&D permits was not about the eco-nozzle, despite staff's assertions to that point. The purpose of the original permits was to essentially study the nature of mobile fueling writ large, and specifically to take a look at our ability to meet the statutory emissions reductions requirements by virtue of a new method, essentially replacing our ORVR detection system in lieu of a phase 2 vapor recovery system, because at the time of these permits, and in fact, as of right now, there is no commercially available phase 2 system that can go onto a mobile fueler that is commercially available. And the easiest way I know how to explain this is that, you know, as Mr. Henderson stated, as I believe I stated last week, the first time that we heard from district staff that of their belief that the purpose of the original permits was the eco-nozzle was in that January 2020 meeting that we had at the district offices. Our attorneys were there, our environmental consultants from the Ramble firm were there, Mr. Henderson was there, I was there, and we were all completely shocked when we heard that assertion. It is the first time that we had ever heard the assertion. It was not our understanding. I already told everybody what our understanding was. But furthermore, it was not our consultant's understanding. It wasn't even CARB's understanding. And this was about 20 months after the original permits were issued and about 2 years after CARB approved the original R&D permits to study our MFOD system. So when we heard this in that January 2020 meeting, we, and actually myself specifically, at that time asked for any records to back that assertion that, you know, that the assertion that the original purpose of the original R&Ds was to study the eco-nozzle. We never got any records. We heard that assertion again in a subsequent meeting with staff and with Mr. Nastri. And again, we repeated that point. And again, we still heard nothing or saw nothing in terms of how they were supporting the fact that from our perspective, they had completely retroactively changed the purpose of the original R&D permits. So at this point, as far as we can tell, this is like some sort of secret R&D permit that no one else but district staff knew was for the eco-nozzle and not for studying, you know, mobile fueling and our ability to only fuel vehicles with ORVR. And on that point, if let's say if our belief is correct, the only way that I see that you can, I guess, quote unquote, justify not extending the permits was to A, change the purpose from studying our operations overall and studying the ORVR aspect of our operations to something that was essentially a moot point. And at that point, the eco-nozzle had been certified. So by changing the purpose of the R&D permits from what we believed it to be, from what CARB believed it to be, from what our environmental consultants believed it to be, to the eco-nozzle does satisfy the ability to make that a moot point, right? Which is why we would like to see some sort of documentation that shows that, you know, that there was confirmation of their assertion that that was their understanding at the time that the original permits were issued. The other aspect of that is, you know, in fact, the chair, I was listening carefully when the chair read the part about Rule 441 and the aspect of the, you know, innovation portion of that rule for an R&D permit. Well, I touched on this again last week, that the system that we have built from scratch for detecting ORVR is, I think, under any definition of the word innovative. Again, we built it from scratch to, you know, take it from a license plate and figure out whether it has ORVR on it. CARB has told us that they think that our system can actually be better than phase 2 systems at gas stations. The Placer Air District, where we're currently operating, has us using it in our operations there. We're in conversations with Ventura County Air District, and they are inquiring about whether we could implement it there if we operate in Ventura County. Not so long ago, we got a permit to operate up in the Seattle, Washington area, and the Puget Sound Clean Air Agency said, and I pulled it up because I wanted to make sure I got the quote right.
At the sake of cutting this, we are not going to get through this request for documents if we continue to argue and appeal that we are not hearing today.
But ma'am, I don't know how to explain the relevance of the documents without explaining what our theory of the case is.
But you're talking about things that are happening now, and you've talked about your theory of the case. Okay,
I actually haven't, ma'am.
I will allow it, but I urge you to tie this up in the ways that this board can understand the relevance to the requests that are at issue.
I promise I will. I ask for a little bit of I guess, leniency, because we are talking about literally years of back and forth, and I promise I'm trying to summarize it as best as I can.
Okay.
So again, in terms of the innovation piece, you know, the Puget Sound Clean Air Agency said that, you know, based on local regulations, including in South Coast, that the use of the eco-nozzle for fueling of ORVR-equipped vehicles constitutes VOC best available control technology. So literally every other air agency that we have spoken to is really interested and intrigued by this ORVR system. And yet we have been told, and it's actually, I believe, in writing and maybe in one of the letters that was just provided to us, that it is South Coast's view that is nothing more than a record-keeping system, which again, if you're looking for a way to justify moving off from the original purpose of the original R&Ds, number one, you make it about something that is a moot point, which is the eco-nozzle. And number two, I guess you try to downplay the actual innovative aspect of what we were actually studying. But more to the point, I do believe that the claim by district staff that this was only about the eco-nozzles is completely belied by the fact that the main documentation, the main thing that we were providing to district staff during the pendency of our original permits, all related to ORVR. We submitted over 100,000 lines of data to staff about our ORVR system. I don't believe we ever received any sort of request for data about the operation of the eco-nozzles, which is now apparently retroactively the alleged purpose of the original R&D permits. We were not asked about the spillage. We were not asked about, fueling speed. I honestly, under the original permits, the eco-nozzle seemed to be an afterthought at best. And everything that we were conversing about, everything that we submitted was almost entirely about the ORVR system. So, if the eco-nozzle was actually the purpose of the R&D as is now being asserted by the district, then, that's why we would like to see a single document that confirms this assertion, because literally nobody else involved in this R&D project believes that to be the case. And bringing it to your point, Madam Chair, Booster Fuels has no leverage in any of these situations with staff, right? We are, operating under an R&D in good faith. We've literally spent over $2 million in terms of either internal resources or external funding to try to give the district every single thing that they have ever asked for. And the only reason we're really on to additional permits is because we believe there's a lack of good faith in trying to work with us to continue the original R&D permits for reasons that we frankly don't really understand. So to, I guess, bifurcate this and just simply say that, oh, well, this is all, this has nothing to do with the relevancy of why we're here. The only reason why we're here is because there seemed to be a concerted effort by the district to retroactively change what the purpose and the scope of the original R&D permits were.
Thanks, Joe. Okay, so just to summarize very quickly, you believe that under all of your work, including Rule 441, which you're operating, the district has records that are relevant that we are seeking regarding the ongoing operations of the company that will help show this hearing board that the 6 additional trucks are necessary to operate.
Yes, I do.
Okay, thank you. All right, so that completes the issue regarding the 6 additional trucks. We covered in that testimony the compliance issues. Do you believe that the AQMD has records that are relevant regarding Booster's interactions with Ms. Manwaring on compliance relating to its need for 6 additional trucks? Do you believe there's records that are relevant that we can review that will help demonstrate to this hearing board that we need the 6 additional trucks?
Yes, I do.
Okay. All right. And then just briefly, Chair, the last issue I'm covering with Joe is the request for records from Ms. Manwaring herself. And then I'll be finished.
And do you have any idea for how long you think that will take?
No, because we've already covered Mr. Opaku's conversation. I just want the hearing board to understand it's a separate request, even though we've already covered his interactions with her. And I'm just going to kind of summarize those very briefly.
Okay, but you're talking about the request for documents.
Correct. Correct. Just the request for documents from Ms. Manwaring. Okay. Okay. Joe, you've already covered this, but I'm just going to go through 5 quick points regarding your interactions with Ms. Manwaring on this project. So when did you first get involved working on this permit request from AQMD with Booster?
I first got involved myself pretty literally the day I started with Booster Fuels, which was in April of 2019.
Okay. And who were you dealing with in April of 2000, if you can recall, at AQMD?
Initially, it was almost entirely Miss Manwaring. If I recall correctly, I believe she introduced herself, or she was introduced by Miss Melville via email in May of 2019.
Okay. And when she got involved, what did you perceive her role to be, in a very just short answer, because you've already covered this? What did you perceive her role to be?
Again, initially, I perceived her role to be to, wrap up whatever, procedural details we needed to wrap up to conclude, to, I guess, to reflect what we had heard from compliance, that we had resolved all their questions and that we can move ahead with the issuance of the 6 additional tanker permits.
Okay. And during this process, did you have one-on-one conversations with her?
Yes.
Okay. Did she advise you that you should have an attorney on the during these conversations, since she was counsel for AQMD?
No.
Okay. Did you discuss actual permit conditions with her?
We discussed a lot about the permit conditions in the context that I mentioned before. So, for example, it was Ms. Manwaring who initially raised that, to my recollection, that initially raised the fact that she believed we were out of compliance by operating outside of Orange County and Irvine, which was incorrect. It was
Okay,
Ms.
so
Manwaring.
I don't mean to interrupt you. That's fine. So in other words, she was weighing in on the scope of the permit.
Yes.
Okay, so that wasn't a permitting person who was telling you that. That was a AQMD counsel.
Correct.
Okay. I think that covers it, Barry, unless you have something to add to these conversations and dealings with Ms. Manwaring and Joe.
No, I think that you've covered pretty much everything that we want covered.
Okay. So finally, Joe, do you believe that Ms. Manwaring has documents that are relevant and important to show that Booster needs the 6 additional trucks to comply with AQMD's current requests for research?
I do.
Okay.
Ryan, can I just interrupt?
Yes.
Because you may have asked this, and I apologize if it's already been asked and answered. I want to make sure on the record that Joe confirms that the permitting fees were paid for those 6 additional trucks. You may have already gotten that in.
Yes, that is correct. And the permitting fees were paid. We actually relocated tankers at extreme cost to the region with the expectation that we were going to get the permits, and they sat there, I believe, for over a year while we tried to work this out with district staff, and were never able to. And I believe it took over a year, probably significantly more, over a year, before we ever even got those fees returned to us, after multiple times mentioning it.
Yeah. Well, and wasn't it I in a meeting with the district that asked about it, and only because I asked, they said, all right, we're just going to give it back to you all of a sudden.
Yes, they said they would get it back to us pretty promptly, and it still took, I believe, at least a few months after that meeting that you were in where you made that request.
And that was based upon a question that I asked, which is, why in the world?
I need to object. What is the relevance of when
Well,
these
let me
fees
ask
were
the question.
returned?
Can I ask the question?
We have on the record the dates the fees were returned.
Right, but my question was, this is my last question, was that not in response to a question that I asked, that why in the world do you have permitting fees for a year if in fact that's not in process?
Correct. You asked that question.
Thank you.
Okay. We're
Thanks,
going
Joe.
We're going to take that, since we have finished the direct of Mr. Okpaku, we're going to take our lunch break. And during the lunch break, the board and Mr. Height and the booster team are going to also review what we've marked as exhibits A and B. If we were to come back on the record. Yeah.
Madam Chair, the one thing I wanted to note is that Senator Holden's been politely asking, holding his hand up. I wanted to make sure he didn't have a question.
Okay, but we're going to hold hearing board questions. But yes, Senator, did you have something you wanted to say?
At the time that Mr. Puko was giving his testimony and he was being interrupted, and I was going to point out the fact that the request for some of these documents were relevant as appears in the petition. When I look and see where AQMD approved the 6 trucks, and it goes on and on, when they approved and they disapproved, then of course those documents are relevant. That's
We'll
why.
we'll have an opportunity to discuss the relevance of documents during deliberation. I merely wanted to keep this hearing on track to make sure that we're discussing the subpoena request for documents, and specifically the documents that are being requested. And of course, relevance is a major issue that we need to discuss. However, I wanted to keep it to the subpoena.
My statement relevant and on track.
Okay, great.
Document.
Any member in the chair, I was asking them to move it on. Okay, we're going to take our break. A question I have for Mr. Height, Mr. Groveman, how long, in addition to, I guess we would normally give about 45 minutes since most of us are remote for lunch. If we did an hour, trying to.
That's fine. An hour is perfect.
Then let's do it just a little bit. All right, it's about 25 after. Okay, let's take our break until 1:25 and promptly.
Around 1:15.
Would you mind, could you make that 1:30?
That's fine. We are going to lose a board. We're definitely going to have to be done by 4. We might not be done. So yes, 1:30 is fine. I want to make
Well,
sure.
if there is a problem, I guess we could try to do it at 1.
I had said 1:25, but we could do 1:30.
Okay, thank you.
All right, we are off the record until 1:30. Do not leave the Zoom meeting, please, but definitely mute your microphone. If you don't, I'll try to do it for you. We're back on at 1:30. We're off the record. Okay, the time is 1:30, so we'll start gathering back to complete our hearing, hopefully. Okay, I think we're still waiting for Senator Holden, and once we have, oh, and Mr. Groveman is not back. Mr. Height, are we waiting for Mr. Groveman?
I'm sure he's on.
I'm here.
Oh, okay. Thank you, Mr. Groveman, for letting me know
You're
that.
welcome.
So we're only missing the senator, and once we see the senator, we will proceed. And in the meantime, Ms. Verdugo Peralta, when you leave, if you believe, I want to try to, because we're going to be so cramped to try to get this finished today. So I want to try to head off issues with losing you from the hearing. It might make sense for you to call in as opposed to be traveling with the hearing, or.
Do you remember when I did it, when I had the doctor's appointment? I was on the laptop and it worked out fine.
There was a point where we were losing you, but maybe what we should do is do it on the laptop. If we lose you, the first time we lose, then we'll do the call in.
Yeah.
Okay, perfect. Okay, we are all back. And we're back on the record. And unless Mr. Height, after your review of the documents, you wish to continue to ask Mr. Opaku any direct questions, we were going to turn to the district for cross-examination.
No, that's fine.
Thank you. Okay, Ms. Chavez, Ms. Reichart, who will be asking questions of Mr. Opaku?
I will, Madam Chair.
Please proceed, Ms. Reichart.
Thank you. So I wanted to start with the research purpose for the expired permits. Mr. Henderson testified that it was to allow for the generation of data to support CARB certification of the MFOD systems. Do you agree with that statement? I'm sorry, you're muted.
Yeah, sorry, Mr.
Sorry, I do that seriously once a day. Yes, I do. Apologies.
All right, and then the research purpose for the current permit subject to this appeal, Mr. Henderson testified that the research purpose is to study pressure-driven losses from cargo tank vehicles used to transport gasoline, a part of which is the different colored tanks, the development of an inventory tracking and reconciliation system, automating that, and GPS tracking. Would you agree with that?
Yes.
Okay, thank you. Could you tell us, when you use the term ORVR system, what you mean?
Yes, so when I say ORVR system, I'm referring to what I guess is better described as what I will call an ORVR detection system. In other words, the ability to detect essentially with the input of only a vehicle license plate as to whether that vehicle is equipped with onboard vapor recovery or not.
Okay, so I just want to make sure I understand. So it's like a program that you input information into, or it's a scanner or something? Is it a physical piece of equipment or like software?
It is software,
Okay.
relying on other pieces of software or other databases.
Okay. And then is it your belief that the ORVR system was part of the expired research purpose?
Yes.
Or I should say, I prefer to say ORVR detection system, if that's okay.
That's fine.
Okay. Because I think of.
Can I ask a question? I'm sorry. I keep hearing this expired permit. So is it referring to which one is that?
The expired permits are the ones that have previously expired that are not subject to this appeal.
The 5 units?
The original one that was granted in 2018. That's what so there's been 2 sets. The The testimony has established that there were two sets of permits, ones that were granted in 2018 and the ones that were just granted in 2020. So when she says expired or original, board should take note that that means the 2018 permits.
Thank you. ORVR is a system. Oh, let me just ask you, what is ORVR?
ORVR is the acronym for onboard vapor recovery, and actually I'm blanking on what the final R is for at the moment. But onboard vapor recovery system. Refueling, I think, is the answer. And broadly speaking, essentially vehicles in the 2000s started getting constructed with the ability to capture the vapors that were normally attendant to a fueling of a vehicle within the vehicle itself, whereas vehicles prior to the 2000s, as a general rule, did not.
So this is a component of the consumer vehicle itself, cars, trucks, etc.
Yes.
Okay. And now how does the ORVR detection system relate to the current permits?
So again, I'll try to be as brief as I can, but the only reason we are on the current permits is because from our perspective, staff did everything they could to make sure that there was no continuation or extension of the original permits. And it's our argument, it's our very strong belief that I want to be, polite about it, but there is, I guess, a lack of good faith by staff in trying to retroactively, retroactively justify moving on from the extension of the original permits, and essentially, forcing us, because we have no leverage in this process, to just, to move on to the new permits, because we can't make staff agree with us or make good on their prior commitments.
Okay, but the ORVR detection system is not part of the research purpose for these permits that are subject to this appeal.
They are not part of the, I'm sorry, say that one more time.
The ORVR detection system is not a part of the research purpose for these current permits.
That is correct.
You had stated that you, in terms of supporting the documents going back in time to 2018, 2019, you stated you would like to see a document stating that the eco nozzle was the research purpose for the expired permits. Is that an accurate statement? I don't want to misquote you.
I don't remember exactly what I said, but if that's what I said, I would specify that, around the time of the issuance of the original 5 permits.
Okay. So how would that impact this current appeal with these current permits?
Again, I just don't know how else to say it, except to say that the only reason we are on these current permits is because it appeared that staff did pretty much everything they could to undermine the rationale and the basis of the original permits, forcing us to, if we were going to essentially not have the entire, investment into this project be a complete sunk cost, to take what staff gave us.
Okay. So is there anything having to do with the eco nozzle that's related to these current permits?
Is there anything where? I'm not sure what you mean.
Is there anything related to the eco nozzle that relates to anything about the eco nozzle that relates to the research purpose for these current permits?
I don't believe so.
Okay. Council had asked you, can the current research purpose be fulfilled with 5 trucks only? And I believe you answered no.
That's correct. That was my answer.
Okay. So based on the research purpose that we discussed, to study the pressure-driven losses, the development of the inventory tracking system, and the GPS tracking, why can't you fulfill those research purposes with 5 trucks?
Well, again, one of the aspects of the permits, and I am pulling it up because I want to make sure I get the language correctly, is, and I do believe I'm quoting, condition 43 to install and maintain a GPS system on each MFOD tank vehicle to collect and study the following information in real time. And then now I'll paraphrase: trips and routes, locations and times of engine start and stop, locations, times, and duration of any idling events over 60 seconds, et cetera, et cetera. And we're providing this data to South Coast currently on a monthly basis for evaluation of potential emissions associated with a typical MFOD operation as a whole. And how do you do that when we are essentially constrained by only having the 5 vehicles to do anything that actually comes close to mirroring what a typical mobile fueling operation would look like? So we contend that it's extremely relevant to collecting accurate data for that type of study, because again, based upon the current constraint, we are essentially not operating far beyond the city of Irvine or Orange County generally.
Okay. And now when in time were these current research purposes developed?
They were developed following or towards the end of or immediately after the discussions leading ultimately to the abatement order that ultimately was the subject of the last time we were before this hearing board. And if you give me a second, I can probably give you a more specific actual date. I just need to look at my notes if that's okay.
Sure.
Oh, actually, I don't have it in my notes. I have it somewhere. I just don't have the right notes up. But
was it in 2020?
Yes.
Sometimes say spring of 2020.
Yeah, that is accurate.
Okay. So what documents from December 2019 and earlier would assist you in making your case as to why you need the 6 additional trucks to fulfill the current research purpose that was developed in spring 2020?
Yeah, I apologize if I sound like a broken record on this, but again, it's our opinion, it's my opinion, that the only reason we are on these current permits is because staff did everything they could to make sure that our original permits would not continue despite an earlier commitment to do so, and a previous checklist of things that we needed to do so, and that we completed, and then again everything went completely sideways. So just being really frank and blunt about it, the only reason we're on the current permits is because we believe that there is, a lack of good faith dealing with what we thought was our research partner in this project to continue what the original permit purposes were.
You said that there was, I'm sorry, I don't want to misstate what you said, but something about a commitment from the district to continue the research permits?
Well, yes, when we approach, I'm sorry, was that the?
Yes, that's the end of the, I just wanted to know what commitment you're referring to.
Sure. So when we, initially approached the district about, what do we need, how can we help you with, with your rule development, with this project? And, it was discussed to us by Mr. Tassopoulos that, a regional emission study would need to be done. The only way we could effectively operationally do that was with more tankers. And in my opinion, when the district told us, okay, we'll get CARB approval, and we did it. And, to make sure that we have, resolved all the issues with, with ORBR compliance and verification, and we did it. To make sure that we had come up with a process about the dome hatch issue that we mentioned, and we did that. There were a couple of other matters that they wanted us to confirm. And then again, after waiting for quite a while, we get a message saying, and again, I'm pretty much quoting, "Good news, we are ready to accept your permit applications." To me, that is a commitment to, to work with us on expanding the permit for the purposes that South Coast staff told us that they needed in order to complete a rule change.
Okay. So when they said we're willing to accept your permit applications, did he say anything about extending the duration of your research permit?
I don't believe he said anything in that voicemail, no.
Okay. Was there another voicemail or email or other contact that said something about extending the duration of your research permit?
I don't recall off the top of my head whether it was or not, but I do know that CARB did request us to extend it as part of their approval of the additional 6 tankers.
Okay. Okay, so I want to go back to your the first request for 6 additional trucks. You said that that was in late 2018, is that correct?
I believe so, yes.
Okay. So I had submitted, I sent to council and to the board an item just when we went on the break. And this is a document that I understand was created by Booster, and it includes a December 27th, 2018 letter from Randy Matsuyama to Booster. Are you familiar
I'm
with
sorry,
this letter?
you broke up on the date. Can you say that date again?
I apologize. December 28th,
No,
2018.
Okay.
I understand you weren't there at the time, but are you familiar with this letter?
I'm sorry, there was another letter. There was another letter sent during lunch.
This was, yes, I sent this right as we went on lunch. The beginning of it is, it's got Booster at the very top. It's a 36-page document. Did you receive it?
Yes.
Okay, we need to mark it. I didn't even know we had it. Board members, do we all know? Am I the only one who doesn't know that we received this additional document?
Yeah, no, I just looked at it after I heard from Ms. Reichert.
Okay. I don't know if people are saying they didn't get it, but let's take a moment to look in our email. I want to download it.
I just heard about it just now. I didn't know that there was something else that we needed to review.
Okay, let me see if I can, would it be okay if I shared it? I have not had a chance to review it.
Madam Chair, it's a very long document. I don't think they're going to be able to process it that quickly.
I've only had questions about very specific parts of it. It's just that this is what's where this letter is contained that I had access to. So I'm specifically going to be discussing the letter that starts on page 8, I believe. Hold on.
Okay, well, first of all, let's mark this. Okay, so this is, even though it's on Booster letterhead, this is being submitted by the district. Is that correct?
Correct.
Okay.
And if I could just make a note, we're not objecting to it, but it's just not normal procedure to get a 36-page document, any of us, literally at the moment the question is being asked.
Okay, well, I that's not true. I did send it over an hour ago, and it was in response to testimony that was elicited during direct this morning. So that's why the late.
Let me shortcut any back and forth. We do, at the hearing board, we do accept evidence, and unfortunately, because we're remote, we tend to accept evidence very much on the fly. However, we need to all mark it and make sure that we are all familiar with it. And Mr. Groveman or Mr. Height, I assume since it's a Booster document, you are familiar with it, but if not, please let me know and we should take a few minutes off the record. Would you like?
We're okay with it. We like the document. We just want to make sure that the board members aren't jammed getting a 36-page relevant, good document. That's all.
Understood. And I'm going to see if I can share it. I might be able to. I was trying to see if I could share the other documents I downloaded before, and I was able to. Let me see if I can do that. But let's mark it, Madam Clerk, as Exhibit C as in Charlie. And let me try to see if I can share my screen.
Madam Clerk, Madam Chair, it should also be understood this is a timeline. So they're referencing one single document in the middle of a timeline. So that needs to be pointed out.
Okay, and you may have as much leeway as you want to question or to bring up other issues once we admit it. Again, it's not, I note that Mr. Groveman said he did not necessarily object to it being put in evidence, but right now we've only marked it. There's been no request to place it in evidence yet. But I am gonna try and share it. Okay, so let me see if I have.
Madam Chair, you want me to bring it up?
I think I can do it. If I can't, and you can, but is that it?
Yeah.
Yes.
Okay, and you're looking page,
For page 8 of the PDF. So,
Yes.
would that be this attachment C?
correct.
Okay.
Okay. So in this December 20, you're familiar with this December 27th, 2018 letter? Is that
I'm
correct?
familiar with it. As you noted, I was not with the company at that time, but yes, I have seen this letter before.
Okay. And so you're aware that it states at the beginning of the orange highlighted portion, we have concluded that your request will not be granted at this time for the following reasons. What request is this referring to?
I believe that is referring to the request to operate 6 additional mobile fueling on-demand vehicles, as noted in the first paragraph.
Okay. And so you had stated previously that you didn't believe that you had received any written confirmation that your request for, this was in your testimony last week, you hadn't received any written confirmation of your request being denied for 6 additional trucks. Do you recall that testimony?
No, I do. And if I said it exactly that way, then I was not as detailed as I should have been. I was referring to after my testimony at that point was after we received the voicemail from Randy Matsuyama, basically saying, good news, go ahead and submit your permit applications. And after that point, we submitted the applications, paid the fees, moved the tankers, and then, we repeatedly followed up verbally, in writing, in person, with staff, with Mr. Nastri.
Okay, yes, I'm sorry. I just want to keep moving. Yeah, we heard that testimony earlier, if I can just interject. Okay, so I am so sorry. Hold on one second, please.
No problem.
Sorry about that.
I'm not laughing at you.
No, you can laugh. It's okay.
We all feel for you, given.
Yeah, exactly.
It's the joys of everyone being at home at the same time. So, all right. So, when did you submit those applications you referred to that Randy had said that you could go ahead and submit?
We submitted them on, and again, let me double check my timeline.
And Madam Chair, you could. I'm done with this document for right now.
Oh, okay. Let me stop the share. Okay.
It was in February of 2019.
February 2019.
Yeah, basically immediately after we received that message. I think it was maybe literally the day after.
Okay. And okay, so February 2019, you submitted the permit applications. Okay, and then okay, now I'm going to, I apologize, I did not mark down which exhibit, was it A or B, the January 24th, 2020?
We're talking about the exhibit to the exhibit that we're currently.
No, I'm sorry, the other exhibit C,
A.
I'm done with. This morning, we marked 2 exhibits.
A is an apple, is the January.
Okay. A is an apple. Okay, so exhibit A. So are you familiar? This is the January 24th letter. Again, I understand you were not, or no, you were there by this time. That's right, because you were 2019. So this January 24th letter from Amir to Taylor Henderson.
Yes, I've seen this letter before.
Okay. And then the third paragraph in that letter, do you see that it states about 2/3 of the way into the third paragraph? On that date, during a meeting at district headquarters, Booster was informed that its pending permit applications were being canceled and the existing R&D permits would not be extended unless Booster could articulate a valid research purpose to justify an extension?
Yes.
Okay, so is that a written documentation alerting you that your the 6 additional permits were being canceled?
Yes.
Okay, thank you. So you've stated, and you've stated numerous times during your testimony that we're really only here because you felt like there was a lack of good faith from the district and trying to continue with the original R&D permits. Just so I can clarify, is there an expiration date on those R&D permits that are written into the permits themselves?
Yes.
Okay. Do you know what that date is?
I don't have them in front of me, but I know there is a date on them.
Okay. Do you know approximately when they expired?
I can, if you give me 30 seconds, I can quickly find out.
If I tell you the date, would you be able to know whether that's true or not?
I believe it was early in 2000, but I don't remember the exact date.
2020.
Correct. I'm sorry. What did I say? 2000?
2000.
Yes, 2020.
They're going, that's 20 years ago all of a sudden. How did that happen? 21 now. Okay, so early in 2020.
Correct.
And so then, and you further had stated the reason we're here is there seems to be a concerted effort by the district to retroactively change the scope of the original R&D permits.
Correct.
And then, correct? Okay. And you stated that you were made aware of this, the district believed the eco nozzle to be the original research purpose in January 2020.
I believe there was a meeting with staff in January 2020. I may have the date somewhat off, but yes, around that time, there was a meeting with staff, myself, our attorneys, our environmental consultants in the district offices.
Okay. And you filed an appeal of those permits. These are the previous expired permits in February 2020. Is that correct?
No.
Okay. When are you aware of an appeal to of those previous permits?
I mean, I guess it depends on your definition of appeal. If you mean a formal appeal, no. I guess we made the mistake of still trying to work out with staff, thinking that we could answer all of staff's questions. Well, I'm sorry. No, I did forget. No, we did file an appeal of the rejection to extend, and then I think we withdrew it. I'm sorry, I did forget about that fact.
Okay.
And that we withdrew it because, again, we thought that we could work through this in good faith with staff. We were wrong.
Okay, so would it be accurate to say that you filed the appeal in February and you withdrew it in March of 2020?
That sounds about right.
Are you aware of the arguments that were made or the bases for the appeal?
I don't recall them offhand, no.
Okay. Madam Chair, I do have a copy of that appeal readily available. I did want to ask a few questions about that. Since it is a document that they filed, I would hope that we could take official notice of this. I would be happy to send it to you, or you could bring it up in your own record since it's a hearing board document. This is the appeal filed in 6171-1.
I would want to have it in front of everyone. Yes, something that was publicly filed and we can take official notice of that appeal and that petition of what's in that petition. However, we need to see it.
Yes, I can send it to. I can send it
and so does Booster.
Yes, of course.
They were not prepared and do not have it in front of them.
Let me send it to everybody right now.
Does it make sense, given our timing, to move to other questions?
I can move on and come back to that.
Why don't you send it out, and then we'll take a break and we'll all take a look at it before you.
I have one question about that document just to confirm something. So I will move on, and then we can, when everyone's ready with that document, we can pull it up and I can ask that question. So I just wanted to find out, are you familiar generally with the permitting process?
Generally.
Like generally with the district specifically, or overall with your work with other districts?
I I don't know how to quantify it, but I'm generally familiar. I'm sure there are nuances of which I am not familiar.
Okay. So you understand that when you file an application, it has to be reviewed by an engineer? Do you understand that?
Yes.
And you understand that filing an application is not a guarantee of receiving the permit?
Yes.
Okay. And you stated in your testimony last week that you had been waiting for months or close to or over a year without any sort of final determination as to whether we were going to get the additional tankers. Is that an accurate statement?
I don't recall exactly what my testimony was word for word, but yes, we were waiting for quite a while before I think we got a completely definitive response on that. But again, during the process, we got a lot of no's throughout the process. So it kind of depends, how you want to look at it.
Okay. But so you were aware that submitting the permit applications was not a final determination by the district that you would be given 6 additional permits?
I would say that, I guess the way I would answer that is if the district was going to ask us to, jump through these hoops to get all these things done, to check off every single box and then wait and then say, okay, good news, we are ready to accept your permits. I don't think it's crazy for us to have assumed that that meant that they were going to approve the permits.
Is that consistent with your understanding with the permit process generally, though?
Honestly, I don't know I don't know how to describe the processes at the district anymore based upon our experience with the district over the last few years. Consistency does not seem to be something that has been in great abundance in our dealings with the district.
But you did testify that you were awaiting a final determination during that period of time, that pendency period after you'd submitted the applications.
Yes.
Okay. Okay, I want to move on to a question that I'd asked Mr. Henderson, and he stated that he wasn't as familiar with the application for the man-wearing subpoena.
Okay.
I just wanted to find out, and I know that's not technically an issue, but a statement made in there is relevant to these proceedings.
Yeah.
Mr. Hestefan, sorry. How long have we been here? Mr. Henderson testified last week that it was not accurate, this statement in this application, that the MFOD was certified in 2019.
Yeah, oh, sorry, go ahead.
Oh, it's okay. I was just going to say, do you agree with that, or can you provide clarification?
That's I don't know how I missed that. I reviewed that document, and then when it got brought up during Mr. Henderson's testimony, somehow I missed that. That is inaccurate. Obviously, as we've stated many times, we're still awaiting the EO, the executive order from CARB on our system, our tankers, and our operations.
Okay. Have you since been able to go back and review that application to determine if there's any other inaccuracies?
Let's see. I honestly just focused on that specific statement because as soon as you raised it, I was like, did I miss something? And clearly I did. I did not actually go back and review everything else, no.
Okay. All right.
But can I ask Mr. Rector, are you referring to the petition? I'm kind of lost. Which one are you? What document?
I apologize. This is the application for the subpoena for Karen Manwaring's testimony, and there was a statement in there about certification of the MFOD unit. I had asked Mr. Henderson about it, and he had stated that it was inaccurate. And I just wanted, he stated that he wasn't really familiar with it, and it was really I don't want to butcher.
It's okay. I'm used to it. It's Okpaku.
Okpaku.
Yes.
Okay. I've been avoiding it. I don't know if you noticed saying Okpaku. Okay, so I just wanted to clarify that statement is not.
Yeah, it should have referred to the eco nozzle, and I don't know why my eyes didn't catch it, but that was when the eco nozzle got certified. Not obviously we're awaiting the certification, and it actually should be coming in a matter of weeks.
Okay. I wanted to shift to your conversations with Ms. Manwaring.
Yes.
Is it your testimony that by May or June of 2019, you began having conversations with Ms. Manwaring, and that those conversations were initially about the open NOV alleging that Booster was fueling non-ORVR cars?
Not exactly.
Okay. How would you clarify that statement?
So, like I said, I know what our expectation was based upon the way that, we were connected to Miss Manwaring by, again, I believe it was Kirsten Melville. We expected that there had to be some process to wrap up the pending questions so we can move on with the issuance of the 6 additional permits. And so that was my initial expectation of the conversations with Miss Manwaring, was that it was to effectuate that purpose.
And when you say wrap up outstanding issues, what do you mean? What are those outstanding issues?
Well, as I understood it, again, you actually highlighted in that letter that there were, a few things that the district wanted to see done, and I'm trying to pull back up that letter again really quickly so I can see it again. So give me 1 second. But yeah, so the district wanted us to.
Joe.
Sorry?
Is that Mr. Height? Mr. Height, are you trying to speak? Because you're breaking up.
Take your time and review it before you answer. I just want to make sure he doesn't rush, is all I'm saying.
Oh, I won't.
I'm okay.
Okay, we did hear. We did
Oh,
hear.
sorry.
And at any time, I know we're remote. At any time, if you wish to interrupt because you want to counsel your client, please just let us know, okay? Raise your hand or something. Okay, Mr. Okaku, with that, and Mr. Height, you might be trying to tell us something, but you're frozen again, I believe.
Should I continue?
I believe Mr. Height was simply making sure that you review any document before you respond.
Yes.
That's correct.
Okay, yes, understood. So yes, as you know, there were some compliance related questions that we had to resolve about some of the things that I mentioned before, the dome hatch, the ORVR verification, some general inventory management procedures, some basic questions about just our standard operating procedures generally for emergency prevention, responding to a potential spill, things of that nature, and documenting the fact that the tanks on our MFOD units were being inspected and certified by CARB. So we did all those things. Sorry, we did all those things, and got informed by compliance, that we thought that those answers were satisfactory. And so our understanding was, when this case was transferred to Ms. Manwaring, that it was to, I don't know what, at the time I didn't know what wrap up that process looked like, but that's what we thought it was for, because we'd already gotten indication from compliance that we had satisfactorily answered all their questions.
And when you use the term wrap up, where did you get that term?
It's my term.
Oh, okay. So if I can just paraphrase based on the terms that we use, you had outstanding violations that you were looking to show that you were now in compliance with, so that permitting could move forward with processing your applications. Would that be accurate?
Not entirely. There were, we thought that the violation for the dome hatch had already been resolved. There was still a question about the ORVR, compliance and verification, but there were also some things that had nothing to do with violations, like, our procedures and whatnot, and confirming the testing of our MFODs by CARB. So it was not entirely related to, alleged violations.
So you believe, when you began having conversations with Ms. Manwaring, you believe it was not entirely about resolving the outstanding violations?
It was, I would put it more broadly, that it was, we thought we had answered all of compliance's questions or, concerns, what have you. And that, it needed to be finalized somehow with the district legal team. That was our understanding.
Okay. So how many notices of violation had Booster received when you first started communicating with Ms. Manwaring?
I know we had at least received two, one for the cargo hatch, and I believe we had received one for ORVR, I'll call it ORVR compliance. I may be missing something, but those are the ones that I recall.
Okay. And so those were issued in, do you remember when those were issued?
Not offhand, but I'm sure again, I could check my notes and find out.
Okay. If I told you that one was issued in October of 2018, regarding the cargo tank dome hatches, would that sound about accurate?
I can't speak to its accuracy, but I don't have any reason to doubt that that's the date.
Okay. And if I told you that the ORVR violation NOV was issued in March 2019, would you have any reason to doubt that accuracy?
I don't have any reason to doubt that.
Okay. If need be, I do have these NOVs were listed in the findings and decision in the order for abatement case. So I can present those if that would help your recollection.
No, I take your word for the dates.
Okay. So after you began speaking with Ms. Manwaring about these issues, did Booster receive any additional NOVs?
Oh, yes.
Okay. Can you tell us what those were?
I believe we received an NOV for the rather complex fire permitting issue that I mentioned. Again, ironically, that
Get my black purse. Need to get going.
Sorry. Ms. Verdugo Peralta, you are not muted. I'll mute you.
So
Okay. Sorry about that.
that's quite all right.
So you just unmute. Okay, go ahead.
Sorry. Where was I?
Just discuss.
Oh yeah. So so we received, I believe we received an NOV for some of the, fire approval issues, which, we've never actually had a chance to properly litigate or respond. We disagree with that. And, the bottom line is that we are still in good standing with every single fire, marshal or regulator where we operate in the South Coast area. So, I do find it ironic that literally the only, regulatory pushback we received for fire related issues is from agency that has nothing to do with fire regulation, but there you have it.
And you did receive a second notice of violation for additional ORVR violations, is that correct?
Yes, but we never had a chance to really fully flesh that out. We believed and we still believe that at that point we were in compliance, and there's never been an opportunity for us to really make that case. But we I would say still disagree with the second one on that front.
Okay. But you did receive the NOV during that time.
Yes.
So it was outstanding. Okay. And what about the NOV? It's P69856 in October of 2019 for failing to comply with the permit condition requiring that the eco nozzles be installed. Are you familiar with that notice of violation?
Yeah, we through an internal communication mishap, for some reason eco nozzles were not installed on all of our tankers, and somehow we missed it. And as soon as we realized that was not the case, we immediately installed the eco nozzles on those tankers. And to my earlier testimony, I believe that was literally the only inquiry we ever had about the eco nozzles during the pendency of our original permits, despite that now being ostensibly the purpose of those permits. So
I apologize. You said that the only discussion you had about the eco nozzles were?
The only inquiry that I can recall from staff about the eco nozzles was, did we actually install them on all of our tankers? And we had somehow, through an internal communication mishap with our operations team, I believe a couple had not been installed, and we immediately installed them. But I'm pointing out the fact that I believe that was the only subject of any conversation that I can recall with the district about eco nozzles, despite that now ostensibly being the purpose of the original R&Ds.
Okay. So regarding the concerns about the ORVR system, you had stated that the system was in beta testing. Is that correct?
Well, no, I said that we never really had a chance to do any beta testing before it went live. I mean, we built it and rolled it out. There was no time to, there was really no time for us to actually, I guess you could put it that as we launched it under this permit, that, that was our beta testing, because we had to get it up and running, but there was no time before we got it up and running that there was a chance to beta test it.
So you would say that the beta testing occurred while you were using it under the expired permits?
Yeah, I think that's fair.
Okay. So, and then the issues regarding the fire certification and some various others, which again, I may need to just ask that the board take official notice of the findings and decision in the order for abatement hearing board case number 6171-2, so that this can be clear. That was it. There was additional NOV for those issues issued in January of 2020.
I'm sorry, I didn't follow that question.
So I apologize, you're right. It was a all over the place question. Are you aware of the NOV that was issued in January 2020 regarding the fire authority concerns, as well as a number of other alleged issues?
Yes.
Okay. And then are you aware of an NOV issued in March 2020 for failing to submit monthly gasoline throughput data?
Yes.
Okay. And are you aware of any notices of violation that were issued subsequent to that point?
I mean, there may have been. At this point, from our perspective, it just seemed like, I honestly can't keep track at this point. So there may be something that I'm forgetting. Just, to kind of cut to the chase, on the fueling records, we've been submitting, literally hundreds of thousands of lines of data, ever since this got started. The work that we do with South Coast, we operate in, California, Washington State, Texas, in DC, Maryland, Tennessee. I may have forgotten a state or two. And literally just being able to comply with the record demands from South Coast probably takes up a good 70% of my team's work. And there were a couple of times where we were either late with something because it takes so much work to produce all the records that they were asking for. After we got into this point of engagement with the district, it seemed that there was no anytime there was a chance to send us an NOV about something, we were going to get an NOV about something, even if we didn't believe it was valid or fair.
I just need 30 seconds. I apologize.
Take 30 seconds.
Thank you. So are you aware of an NOV being issued for violating the order for abatement?
Yes, we missed a deadline on that, again, kind of for the reasons that I mentioned. It was so much data to try to compile, and it was like either we rush it out and try to get it in on a timely basis, or take a little time and make sure we get it correct. And we, essentially kind of knowingly made the choice, like, we know where this is going to be late, but let's just get it right. So yes, we did get something in late under the order of abatement.
How many deadlines were you late on? Do you know?
I don't recall.
You don't recall. Do you know who would know that?
Mr. Henderson may know that. I'm not sure for a fact.
Okay. So I wanted to go back to your discussions with Ms. Manwaring. Is it your testimony that you and Ms. Manwaring had at least 10 conversations and between, say, June and December 2019?
I'm a little uncomfortable putting an exact number on it. That seems about right.
That's fine. I'm just approximately 10 conversations, more or less.
Yeah, that seems about right. It could be more, it could be less, but I'm not, yeah, that's,
Okay. And is it true that you had a standing weekly call during that
Yeah.
time period? Yeah.
Sorry,
But
yeah.
it may get canceled on occasion, which is why it doesn't necessarily add up.
Correct.
Okay. So could you just clarify why you're seeking documents from February 2019 all the way to the present, if your conversations with Ms. Manwaring took place between April, May 2019 through December 2019?
I'm sorry, say that one more time?
I'm just curious about the timeline of the documents that you're seeking
Right.
for Ms. Manwaring. So you talked to her, say, April through December 2019, but you're seeking documents from February 2019 through to the present.
I guess we're making the assumption that, there may have been conversations with Ms. Manwaring and internally, or, before we were aware of her involvement with this matter. So, I think I believe that was the reasoning for the time frame, is that unless she had literally had no involvement in this matter until that date, then if she had been briefed on it beforehand, before we were put in contact with her, that seemed like an appropriate time frame.
Okay, and were you represented by counsel during that time period of April, May through December 2019?
Not towards the end. I'm trying to remember exactly when we retained Groveman Height. And frankly, maybe my attorneys can recall that, but not during the entire time. No, more towards the end of the year. I want to say somewhere in the fall of that year was when we retained counsel.
Okay, and did you request that you have an attorney present during these conversations with Ms. Manwaring?
No, again, initially, we didn't feel that we were going to need one. We thought that this was, part of our working together with district staff to resolve this and move on. And then as time went on, it became clear that that was not the case, and we made the decision to retain counsel.
And are you aware that notices of violation typically result in a monetary penalty?
I'm aware that it can. I wouldn't say that I'm aware whether it typically does.
Okay. And just to clarify, you are an attorney, correct?
I'm a retired attorney.
Retired attorney. Okay, but you were trained as an attorney and you have worked as an attorney.
Correct.
Okay. When you describe the violation relating to the cargo hatch this morning, that first NOV the district issued for opening to the atmosphere the cargo hatch on the MFODs, you indicated that Booster was not operating consistent with district rules. Did you mean a permit condition versus
maybe that was the better way of putting it. But yeah, honestly, we still felt that there was a valid reason to open the cargo hatch, and we discussed that with the district. The district disagreed, and we said, okay, well, we'll now rely on your requirements on that going forward, and that's why we resolved it.
If the MFODs had a phase 2 vapor recovery system, which I understand you testified is not available currently, is that correct?
Correct.
If the MFOD had a phase 2 vapor recovery system, would you qualify for a 203 permit under Rule 461?
I'm probably not the best to answer that question. That's probably better for Mr. Henderson. He is our expert on these matters.
Okay. In the application for the Manwaring subpoena, it states that the 6 additional trucks had been previously promised by AQMD.
I have to interrupt. I believe we lost Miss Verdugo Peralta. She's wanting to come back on. Okay, I don't know how long ago we lost her. If we have her. Miss Verdugo Peralta, are you okay? Did you miss? Oh, we cannot hear you. Oh, you're muted. Oh, no, you're not. We just don't hear you. You're frozen. I think if you can hear us, Ms. Verdugo Peralta, you should probably call in, please. I'm gonna take a second. Madam Clerk, would you be able to just take a second and call Ms. Verdugo Peralta? While we're taking a moment, if everyone could, I see that I received the petition for appeal from, that was date stamped February 21st, 2020. Everybody else can just make sure that they've received it so that when the time comes, Ms. Reichert can ask those questions.
Madam Chair, so I wanted to clarify. I thought we were only discussing the subpoena for the documents. We seem to be jumping for the subpoena for Ms. Manwaring.
This subpoena for documents includes subpoena for documents with regard to Ms. Manwaring. It's the last request in the document. It's
Right, I see that, yeah.
okay. So that, I think that's what the only question that was with regard to the actual subpoena of testimony for Karen Manwaring was the one statement that Ms. Reichert had read, asked Mr. Henderson about last week, and then asked Mr. Opaku about today. Is that clear, Mr. Balagopalan?
Yeah, I was wondering which one is that.
That is not before us today.
Oh, okay, all right, okay.
For us today, just while we're waiting for Ms. Verdugo Peralta, I see she's back on. We're on page 4 of the
Yeah, I can see everything, but can you?
Okay.
You guys hear me?
Yes, can you hear us?
Yes, and I didn't miss anything.
Oh, great. Okay, I'm gonna mute, or if you can mute yourself, and that way you can unmute yourself.
Okay.
Okay, wonderful. So she didn't miss anything, but I just in answer to Mr. Balagopalan's question of why it is relevant, Ms. Manwaring, all of this testimony with regard to Ms. Manwaring on page 4 of the application for subpoena and proposed subpoena for the AQMD custodian of record. So in other words, the document subpoena, which is the subject of today's hearing. On page 4, there is, the last request is Karen Manwaring. All emails and memos from and to Ms. Manwaring regarding her work related to Booster. The time frame for this request is from February 2019 to present. So that's what we're considering today as far as Ms. Manwaring. Okay, now that we have everyone, you may continue, Ms. Rucker.
Thank you very much. So regarding just your assertion that the AQMD had promised, committed to 6 additional trucks, is there anything you're relying on other than the voicemail communication from Mr. Matsuyama in 2019 inviting Booster to submit those applications?
I mean, I'm relying on that, the fact that they gave us a checklist of things to do, which we did, and we were told that we did. And I guess just essentially, I mean, not to put too fine a point on it, but like logic or common sense that if you were not intending to actually process them, why would you, after telling us, that we were not willing to, why would the district tell us that we're not willing to, issue the new permits unless you do A, B, C, D, and E? We do A, B, C, D, and E, confirm that with district staff, and they say, good news, go ahead and submit your permits and take our money. I mean, if there was no good faith intent to actually process issue the permits, then what was the purpose of that? Was it, I honestly can't understand it. So yes.
And at that point in time, Booster had only received 2 notices of violation, correct?
I believe that's correct.
Okay. And then during the time period you spoke with Ms. Manwaring between April and December 2019, Did Ms. Manwaring at any point tell you that circumstances have changed as a consequence of Booster's action, referring to the additional notices of violations that had been issued?
Ms. Manwaring told us, not word for word, that circumstances have changed, but yes, it was essentially, again, some things which may have had some validity to it, some things which were flat out false, but whatever the reason was, the answer was always no. But a lot of those things were things that, again, that Ms. Manwaring, I believe, was incorrect about what the permit required, that it didn't actually require. And then once we resolved that, it was always moving on to something else. And that's been kind of the entirety of this process, that the target keeps moving or the goal line keeps shifting. And every time we try to answer all the district's questions, there's a new question, there's a new issue. And then all of that culminating at the end with that, as I mentioned, I believe January 2020 meeting, when we first heard that, well, the purpose of the R&Ds was never about what you thought it was about anyway. It was only about the eco nozzles.
Well, but to be clear, it wasn't Ms. Manwaring issuing the notices of violation, correct?
I don't know. In terms of a person, I mean, the district issued the notices of violation.
Right, but it wasn't Ms. Manwaring. You said Ms. Manwaring was interpreting the permits or talking about things in the permits that weren't there, but it wasn't Ms. Manwaring that issued those NOVs, correct?
I do actually believe we received NOVs directly from Ms. Manwaring.
Okay,
I may be wrong about that, but
could you tell us which notices of violations those are?
I'm not sure. I'd have to go through my records, and maybe I'm wrong about whether we got them directly from her. But so I could be wrong about that. But I don't know if you're asking me like who signed off on them, I'm not sure. But I'd have to go through my email. But I felt we did receive at least one directly from Ms. Manwaring, but I could be wrong.
Okay, so I don't believe if the NOVs were attached to the order for abatement, but the district would like the board to take judicial notice of the order for abatement in case 6171-2, including the reference notices of violation, that none of those were signed by Ms. Manwaring.
I would like it if we can take notice. However, again, I would like it if there is a past. They're not easily accessible, and the board was not prepared because that hearing, the record was not incorporated in this hearing. And so that doesn't mean we can't take official notice. We can take official notice. It is an order of this board. In fact, I have it in front of me. However, can you please make sure we all have it? Yes. So that we are able to look at it, and then we can take official notice of it. And then all the both parties have seen it, board members have seen it.
It is being sent right now. I have no further questions about that. I just wanted to make reference to the fact that that will show, and the board already has it there.
Judicial notice that there were violations, but there's very good explanations that are not before the board. So it's irrelevant, no foundation, and I don't understand the point of it.
No foundation for what?
For why it's being introduced. What's the purpose of it being introduced?
Because
there's a whole hearing is about relevancy of documents. Well, how is this relevant to the issues before the board? We don't argue that there are notices of violation, but there's a lot of good explanations that aren't being presented. So it's being given, it's out of context.
Go ahead. Sorry, Madam
Chair. But my understanding was it was being offered in response to Mr. Okpaku's testimony that Ms. Manwaring had issued the notices of violation. So it's directly relevant because it's in response to a statement made by your witness. So.
Well, but even that, you see, you're actually providing some testimony. We don't know all that. Maybe she didn't sign it, but she was clearly behind it. We'll find out when she testifies. That's the whole point of us asking for her to testify.
Okay.
Because it's very relevant. So the
question was whether she issued it, and
can I just finish my statement? I'm only arguing relevance. In other words, the fact that you don't see her signature on it belies the point that we're making. And that's why she needs to be a witness, and her documents are relevant, because we believe behind the scenes, for whatever reasons we'll establish, she was precisely doing that.
Okay, but Mr. Groman, you are arguing a different matter. But also, if your witness states that a particular person issued an NOV and we have an order, which I don't know, again, all I see is the list. I didn't go back and review this because it's not in the record yet. However, if Ms. Reichart is saying that order, which was issued by this board last year, contains either the NOVs or who issued the NOVs, it's directly relevant to respond to your.
But you see, what I'm trying to say is, and I don't want to argue it. I mean, we want to just move forward. But the point is, those are all facts not in evidence, and this is supposed to be kept relevant. Our whole point here is to show what went on behind the scenes where there was interference with a permit that was expected to be issued. So the issue about the documents and her testimony are before you. We want the board to, excuse me for 1 second. I want to make a record.
Okay.
We want to present her testimony. We want to call her as a witness. She's clearly a precipient witness. That's what this hearing is about. But it comes. Can I please just finish?
Okay, but that's not what this hearing is about.
Oh, can I just finish? Can I just finish my point?
Arguing about a different subpoena than is.
Well, I want to just make my point respectfully, if I can. This is about the documents, some of which are Karen Manwaring's documents. Then the next part of the hearing is about whether she's a precipient witness. We just want the board to hear the facts. This whole thing is about not giving us documents and testimony. If the testimony belies what I say or what we argue, well, then they make their point. But why are we, just let us get all this in, because we think something nefarious has gone on here. That's our allegation.
Okay, Mr. Groman, I understand. Okay, I'm gonna rule on.
Wait a minute, I gotta say something too once in a while. My God.
I'm the chair and the attorney.
Show the chair. That means you gotta be honest.
Senator, I'm gonna advocate you. Please, you become the attorney member and the chair, and you rule on this.
I'm not the attorney, but I will say Mr. Opoku withdrew his statement regarding who signed the.
No, he didn't.
He did.
No, can I actually? So I wish there was a court reporter. If I said that Ms. Manwaring specifically issued the NOVs, that was not the intent. I was talking about my conversations with Ms. Manwaring that led to the issuance of NOVs. And if I wish there was a court reporter where I could play it back. If I said that, that was not my intent.
No.
I still believe that we received at least one from Ms. Manwaring, but I was not trying to make the point that she wrote out the NOV. That was never my intent.
Okay, so
Madam Chair, we lost board member Peralta.
Hopefully she'll call in this time. Okay, I need to just be clear that there was an objection, that it was not relevant. And I'm saying I overrule that objection so long as the statement by Mr. Okpaku was that he is testifying that at least one NOV was issued by Ms. Manwaring. If the document, which again, we can take official notice of, it's not some evidence we haven't seen, it's our own order. If that order somehow responds to that contention, which was just made by Mr. Okpaku, then we can take notice of it. Again, I'm not going to do that until we've all seen the document. So
I've argued it's also irrelevant and there's no context. But as far as Mr. Okpaku's statement, he made very clear he could be wrong. There's a difference between who signed it and who worked on it.
Okay.
Okay, so that's why we want the documents and we want the testimony, and then everybody will know the answer.
Okay, let's move on. We're not going to, how about, I don't know, Mr. Not going to refer to them. I'm
done with that. I'm done with that. I'm just going to move on.
For now, until it is submitted to the hearing board and there is an argument made for why it is relevant.
Okay.
Right now, it's not part of it.
Madam Chair?
Yes.
I believe that Ms. Dougal Peralta is on the phone, but it is not a phone number that I'm familiar with.
Okay.
and I have no way to promote her to panelist or anything like that, so.
You can't promote to panelists from a phone, but I have asked, asking her, okay, can you speak? Is that you, Ms. Verdugo Peralta?
Me, yes, I can hear everything. I haven't missed anything.
Okay, wonderful. Okay, so we're gonna continue on sustaining the objection right now because we don't even have the findings and decision in front of us. But let's move on.
Okay, thank you. I just have a few more questions. I wanted to circle back about your was someone else talking? I'm sorry.
Not that I heard.
Oh, okay. What was your understanding of why the expired permits were revised to add the eco nozzle equipment description?
I don't think that was my testimony.
Okay. Are you aware that the permit was revised to add the eco nozzle to the permits?
Yes.
Okay. So what is your understanding of why that occurred?
Well, that goes right to the heart of everything that we're saying. It's part of the retroactive, like, re-justification of what the original purpose of these permits were, which never had anything to do with the eco nozzle. And despite our verbal requests, this subpoena, I guess we've now submitted a PRA. We have never seen any document which at the time of the issuance of our original R&D permits say anything about it being about the eco nozzle. And that goes to the point that I've raised before. Like, apparently this was some secret R&D that even the company that was involved in the R&D never knew what the purpose of it was until like nearly 2 years later. We've been appealing this to staff. We've been appealing this to Mr. Nastri. No one seems to think that this is an important enough to, warrant any sort of inquiry. And it's kind of befuddling to us that a regulator can just retroactively change the entire purpose of the permit. And then everything that we're dealing with basically stems from that.
So I do want to circle back now. I believe the chair said that everyone's had a chance to pull up the petition for the permit appeal in case 6171-1.
Let me share the screen. That way everyone can see it. Hold on.
I am really sorry. I need to go address something. I don't know if somebody from my team wants to step in or if I could have a brief, 4-minute break.
Well, why don't we, it is now 2:45. Why don't we take this opportunity to take an afternoon break? 10-minute break be?
That's fine, yeah.
And that way, and also that way, we can all pull up the appeal. And if someone on the district's team wishes to send the findings and decision around, and we can make a determination if it comes up, whether it is relevant to this hearing, this would be a good time. Okay, so let's take a 10-minute break. We'll be back at 2:55. We are off.
Julie, can you hear me?
Thank you.
Who is that?
Julie?
Yeah, Cynthia.
Julie, this is me, Cynthia. I won't be able to view anything. That's the only thing. So
are you able to? We're all on break. Everyone should know. So go ahead, especially Madam Clerk, if you want to take a break. Cynthia, can you on your phone access your email? Is that something you can do?
Well, let me say why I cannot. You know what? I can. I can access my. The problem was that we have the directions on my phone through Waze, and I'll just switch phones and put the directions on his phone, and I'll look at my email. How's that?
You can also try that, but you can pull it up, and that way you can see it from your own.
Yeah, and then the other thing I wanted to tell you, I can unmute myself, but I can't remute myself.
Okay.
So just to let you know that.
Then would you like me to mute you, and then you'll just unmute yourself?
Yeah.
Talk.
Yeah.
Okay.
Yeah. Right.
I'm going to mute you now. Just let us know if you're having any trouble unmuting. Okay.
Okay. Great. Thank you.
Okay, Cynthia.
Okay. Bye.
Okay.
Hey, Alex. I mean, the food's out there. I heard you got.
It is 2:55, and so if we could start reassembling. Hopefully Ms. Reichart is great.
I'm back. Just some bribery and some promises of ice cream, and we're all set.
What we've been used to as parents is unbelievable during this. Okay, I'm waiting for, make sure Mr. Groveman is present. Senator Holden is present. Okay, Senator, if you're present, if you could turn back on your camera. And Mr. Groveman, is Mr. Groveman present?
Yes, I am.
Wonderful. Okay. All right. We took a break and we are resuming with Ms. Reichart asking questions of Mr. Okpaku.
Thank you. Mr. Okpaku?
Yes.
Thank you. I just wanted to turn your attention to the petition for the permit appeal in case number 6171-1. And this is on page 5, and it's item number 9. Let me know when you're ready.
One moment.
Is that it? Do you?
Sorry. Zoom just hijacked what I was looking at.
Oh, I'm so sorry.
That's quite all right. No, that's quite all right. Let's go ahead.
What page are we on? Can you remind me what page you just said?
Page 5.
Okay, let me just get there. Sorry. And Mr. Okpaku, take a moment. But wait,
Right there. Go. If you could just pull it down a little bit. Right there. Stop.
Okay.
Oh.
Yeah, Mr. Okpaku, definitely take, before you respond to any questions, make sure you review completely.
Yes. Can I have a moment?
Yeah, if I can I just draw your attention to what I want to ask about? It's in number 9, and then it's item number 1 in number 9.
Continuing to the next page or just on that page?
Well, it's mainly on this page, but for the context, yes. Let's continue to the next page. So we have
So where should I stop reading?
At the end of number 1. So at Rule 461 amendment,
Okay.
that will be the end.
Okay, one moment, please. Okay, I've read it.
Okay, thank you. So is it true that Booster did file this permit appeal in February 2020, asserting that they disagreed with the research purpose that the district was asserting as to be the certification of the eco nozzle?
Yes.
Okay. Okay, that was the only question I had on that. So I apologize that it took that long and that much to get there. And that is all the questions I have for this witness at this time.
Okay, sorry, I couldn't unmute myself. Okay, thank you. Board members, questions for Mr. Okpaku, who would like to?
Madam Chair?
Mr. Height, did you want to redirect?
Yeah, are we able to do that?
You are able to do that.
Okay. Thanks, Joe. Real quick, I just wanted to clarify a few things that you testified to. Number one, are you, when you're working through these issues with the AQMD, are all of these things that you're working on new technologies for, and you're basically undertaking a research project as far as your operations in the South Bay? Is that correct?
Yes, that's exactly correct. This is, mobile fueling on demand is a new industry. It involves, new technology, or at least a new combination of technology. And, our understanding was that we were going to be working with South Coast together to, to explore, the value proposition of being able to do mobile fueling in a way that was on par, if not better, and we believe it is better than fueling at a gas station. That's correct.
Okay. And so through all this process, all these notices of violations that were being issued for new technology that was being researched. Is that correct?
Yeah, and that's, that was kind of, I believe I did raise this at least on one occasion to district staff, and I also believe I raised it to Ms. Manwaring specifically, that one of the things that really surprised us, and honestly continues to surprise us throughout this entire process, is apparently the lack of understanding that this is something wholly new. Again, I think the ORVR development of the ORVR detection system is really emblematic of that, we're getting notices of violations for something that everybody involved, including all district staff, knows is brand new technology, brand new systems. And, I would think that if the purpose is really research and development, there would be an understanding that, that we are going to find a way to work together to, to address things that come up during the research and development process and improve upon them. But that became fairly clear during this process that did not seem to be the case on the district's part.
Okay. Did they, when they were issuing all these NOVs, are these NOVs things for which there was major impacts to the environment, or are these technical paperwork type of violations? What's the sum and substance of what is actually going on here?
So, I do not believe that any of the NOVs have any real bearing on any sort of substantial harm to the environment. And again, actually, if I recall, I think it was Senator Holden, mentioned the potential for how mobile fueling can actually be really helpful for the environment, and we 100% agree. That's one of the reasons that we're all excited about the work that we're doing, and that we've gotten, really interesting responses from other air districts outside of this particular district because of that. So, for example, and I think Mr. Henderson can, again, give a better answer about the whole dome hatch issue. But, again, we thought that our reason for opening the dome hatch was valid to inspect the interior, and, and they disagreed. So in a desire to be cooperative, we're like, fine, tell us what you want us to do. They think they told us to install locks on the dome hatches, and we did. The ORVR records, even in the early days, and again, Mr. Henderson probably has more exact testimony on this, but even in the very early days of deploying this brand new system, we were still getting, I believe, in the 90% of accuracy with everything we were doing right off the jump. And then we worked very hard to get that up to 100% accuracy. I've already testified at length about the fact that we believe that the NOVs issued with respect to fire permitting are just flat out incorrect and invalid and wrong, but we've never had a chance to really, litigate that. So yeah, it is frankly frustrating to us that, we entered into good faith into what we thought was a partnership to actually legitimately explore this new technology and to examine the potential benefit of it. And then essentially the fact that this was research and development never seemed to enter into the equation on the district side once things became clearly more antagonistic with the district.
Okay, thank you. When the NOVs were issued, were there, before they were issued, were there notices to comply issued for all these, or did you just get hit with NOVs?
I believe with the dome hatch, it was initially a notice to comply, and that got converted subsequently to a NOV. Again, Mr. Henderson, I think, would have a better answer to that because he was directly involved in it.
That's okay.
Yeah, I don't think anything else was a notice to comply except for the dome hatch, but I could be wrong. And again, Mr. Henderson would probably have a better knowledge about that.
Okay, but for the most part, you were just hit with NOVs rather than warnings and NTCs.
That's correct.
Okay. You are also concurrently with all these other agencies, you're also being regulated by other government agencies, correct?
That's correct. Do you mean in South Coast specifically or more generally?
Just in California generally.
Yeah, broadly speaking, there are two categories of regulators that we typically deal with. One on the fire side, obviously, and then on the air district side. But in terms of the work that we've done leading up to the expected issuance of the CARB executive order, we've also engaged with Cal OSHA. We engaged with, I believe, the California Water Board, I believe is the correct term.
You don't need to name them all. You can just let me know that there's other agencies that are regulating you.
Yes, that's correct.
Okay. Do you have a whole bunch of NOVs from any other agencies, or is it limited to AQMD only?
There's no place where we operate in California or elsewhere where we have, I would say that combined for all of our operations throughout the entire country, we have not received as many, notices of violations combined for the whole country as we received from South Coast.
Okay, thank you. With respect to California in particular, you're operating 5 trucks in South Bay currently, correct?
Correct.
And in the Bay Area, San Francisco, how many trucks are you operating?
Oh, at least 50, maybe more.
Okay. And how long you've been operating 50 trucks in the Bay Area?
I just have to object. I don't know the relevance of this.
Yeah, I'm not sure I understand it either.
It's directly responding to Ms. Reichert's almost hour-long questioning about compliance issues. So we're responding to those. It won't take long, but I have a few items to just address.
That's fine, but I do want to point out that Ms. Reichert's questions were in response to questions that were asked and answered on direct with regard to NOV and compliance, because you are seeking documents with regard to a compliance history.
Correct.
So Ms. Reichert did not bring it up. I see very questionable relevance in this entire line of questioning with regard to NOVs. However, I definitely do not see the relevance of other jurisdictions that are not the district, whether they have or have not given NOVs for, we don't know what their operations are or what the rules are in those separate districts. So I would sustain the objection. I don't see the relevance.
The relevance, Madam Chair, is that we are seeking records from the AQMD, and many of those records we don't have, and they relate to boosters operations in the South Bay. And we know that AQMD coordinates with CARB at the very least, and we want to know if they're coordinating with other agencies that have similar operations in California, or AQMD may be interacting with them. And those are all public records.
But how are questions with regard to whether or not Booster received NOVs in another jurisdiction under a different permit relevant to what you're stating right now.
Because we want the hearing board to understand the breadth of operations and the breadth of potential interactions with other agencies.
I see this as very prejudicial. I do not, weighing probative value of what you're trying to get versus prejudice, I would outweigh it in terms of prejudice. I'm going to sustain the objection. I do not think we should be bringing this in. It's nothing but prejudicial.
So we cannot ask any more questions?
No. Not any other questions, but questions with regard to NOVs or other actions taken by other jurisdictions that are not the South Coast under other permits that may or may not be of the same scope. I don't see the relevance.
Madam Chair, may I don't know when you can unmute me and when you can't, so
you are.
I can't even raise my hand.
Okay, but we're not in questions. Right now I am ruling on an objection to.
Okay, well, it's kind of relevant to that objection.
Okay, that's fine. I just want to make it clear for the board that we're going to have a lot of objections from different attorneys, both in the appeal and throughout all of these pre-hearing matters. If we all debate every single objection, we will be hearing this matter from now till forever. As the attorney member and as the chair, historically, I have always ruled on objections, and we do not open it for debate. But is there something very relevant?
Well, in the sense that I have been involved in the technology advancement part of the AQMD when new technologies were coming forward and when other agencies were involved, whether it was CARB and or other districts. That's my only comment that I wanted to make. That there have been, when it's a one technology and they're looking at that technology from different districts, there are things that are very much alike from district to district in the reference to the technology.
Okay, thank you for that, Ms. Verdugo Peralta. I'm going to continue to sustain the objection that it is not relevant to this document request at all, whether NOVs issued from another jurisdiction under a different permit. So let's move on because it's going to take a very long time to finish this hearing.
Madam Chair, I don't think that's a fair comment that you just stated, though. You just made an assumption that there's other NOVs in other jurisdictions.
No,
that's not what the testimony was going to be. It was actually contrary to that there's hardly any NOVs.
Whether they're, okay, sorry, let me restate it so that we don't have objections over what I'm saying. Whether there are or are not NOVs in other jurisdictions, other permits, it is not relevant. And it is highly prejudicial, I believe. That's what we do when we determine whether or not something is relevant. But you may proceed with other questions, just not with regard to what we just ruled on.
All of Ms. Reichert's questioning was on the lines of compliance. So I've just been ordered not to ask questions in response to her questions.
That is not what happened. Booster put on the record compliance issues, and in particular NOVs. And
correct.
Ms. Reichert then asked cross-examination with regard to the NOVs and the history of NOVs. The questions that I have just ruled on are only with regard to other jurisdictions. I do not see the relevance.
Does that include CARB? Does that include CARB?
Whether CARB issued any NOVs or not?
No, whether I can ask him questions about CARB and its review of its permitting operations, of its permitted operations.
I think we've had some testimony with regard to CARB, and if you want to ask, and if there's an objection, we'll take it from there. But
all right, Joe, in your experience, based on everything you saw, do you believe that the records that are being sought will demonstrate that there was some other agenda on AQMD's behalf because these NOVs were issued during the research process? Do you believe that the records will show that AQMD was making decisions that they weren't fully disclosing to you?
Yes.
Okay, thank you. And with respect to CARB, does CARB support what Booster's doing in California generally?
Yes.
Objection, hearsay.
Thank you, Mr. Okpaku.
But and the hearsay is sustained, however, we can accept hearsay.
Thank you. That's all on the cross.
Okay, thank you. Okay, I'm going to open it up for board member questions. I just wanted to ask a few clarifying questions if I could.
Sure.
I just want to make sure that, Mr. Okpaku, that you understand that the district's process with regard to granting or determining whether to grant a 441 research permit is a separate process from CARB's certification process.
Yes.
Okay. And you also understand that.
Well, I mean, I think there's an interplay, but so it's not. But there is an interplay that we've testified to. But I understand that process-wise, they are separate. Yes.
And okay, then do you understand that the district has its own ability to make its own determination, or do you believe it's hinged to whatever CARB's determination is?
I understand that the district has the ability to make its own determination.
Okay. And similarly, you understand that the decision that the district makes with regard to whether to grant a 441 R&D permit is also separate from other districts in California and other districts throughout the country.
Yes.
Okay. I just want to make sure because there's a lot of blurring, I think. A lot of my questions were answered. Let's see.
That's not relevant.
I'm sorry?
That's not relevant.
Okay.
Based on your ruling.
Okay. Thank you, Senator. Is there any other questions by the board? Mr. Balagopal.
I have questions.
Okay. Could you we'll let Cynthia ask first. Yes, Ms. Verdugo Peralta.
Thank you, Madam Chair. Sir, you just testified that when answering the question that you thought that there were other possible motives for not going forward with this project. What do you think that they were?
I'm not entirely sure, and I would say that's part of the reason why I think that what the subpoena we're looking for is so critical to this, because, I mean, I'll just be really direct. It's kind of astonishing to me that no one seems to be very troubled by anything that we've raised here. To have the entire purpose of the R&D permit be 2 years after the fact, kind of retroactively changed. So we believe that there must be some explanation in the documents that we're seeking that will explain and will confirm what our fears are, that there's something happened, but as to exactly what it is, I can't be certain.
Okay, are there any other competitors in your field that are trying to produce the same type of, whether it's software or equipment?
No, and that's actually one of the, I'm really glad you asked that question, board member, because one of the frustrations that we've had during this entire process, and we've expressed this numerous times to the district in writing and in letters and emails, is the fact that broadly speaking, there are kind of two different types of companies that do mobile fueling. You have the companies like us that spend easily around $100,000 to $150,000 on each of our tankers to make sure that they are DOT certified, to make sure that they are CARB certified in terms of their componentry, to make sure that they are like fire resistant, they are crash resistant, etc. which is frankly why we've had such good relationships with all the fire marshals that we deal with, because the other half of the industry are companies that are doing this in like pickup trucks or vans. And quickly, from a fire perspective, their concern is huge because, number one, if there is an accident with one of those things, you'd have hundreds of gallons of gasoline on the ground. Number two, and we know this, the fire departments know this, the companies that are not even trying to be regulated like we are just operating wherever they want to. They're going inside buildings or into underground garages, which is a huge fire issue. But from an air district perspective, the really truly ironic thing is that the companies, maybe one of the few things that Booster and the district wholly agree upon, I believe, is the fact that the companies that are doing this with pickup trucks or vans are far worse for the environment, not only than just the way we're doing this, but far worse than the gas station, because they cannot go to a terminal like we can and load with phase one vapor. They're just going to the gas station and spending probably at least a half an hour filling up a 250-gallon tank with gas from the gas station. And my understanding is that those tanks do not have the ability to properly capture the vapor when being filled. So bottom line, if you see one of these pickup trucks at a gas station, you'll know it because you will smell it. And they are operating freely throughout the South Coast District, while we, the company that has been trying to work with the regulator are essentially being treated like, a nail gets treated like by a hammer.
I understand what you're saying, sir. I dealt a lot with the mobile refueling of hydrogen for the fuel cells and developing that technology and watching it from birth to the actual fruition. So I understand what you're talking about and the process. My other question goes to, did you ever speak with the people, and I may have already asked you this, did you ever speak with the people in the technology department that actually deal with the nuts and bolts of this, if you will?
I do remember you mentioning that point last week, Board Member Verdugo Peralta. I'm not aware of that. I would want to run that by Taylor Henderson to see if that may have happened before I joined. And actually, if I recall correctly, you would ask the question of Mr. Henderson about whether the district had paid for anything. And I actually did want to, I think he forgot one little thing. As a result of the most recent permit, or actually as a result of the abatement order leading to the most recent permits, the district asked for the ability to put on, at its own cost, GPS units onto our tankers. So the district was paying for the GPS units on our tankers for a brief period of time, and then they reached out to us and essentially asked us to take over payment for them, which we've done and continue to do. So I remember you mentioning that last week, and I wanted to correct the record on that.
Okay, thank you. For the moment, those are all my questions. Thank you, Madam Chair.
Thank you. And I just want to, I know I'm very concerned. We have so many subpoena hearings and so many pre-hearings to get to. I want us to be very careful again about meandering off into the merits of the appeal itself. So let's just be careful of that so we can try to get this hearing done. Mr. Balagopalan, you had questions. I'm going to turn to you now.
Yes, Mr. Paku.
Yes.
Around 12:30, we got some data that was sent by Ms. Reichert. It's part of some of that information there. I don't know if you had a chance to look at it. Is what you're seeking?
I'm sorry. Are you saying that the productions that they've made today, is that encompassed in? Not really. Again, I don't believe we've been anything. Well, number one of the things they shared with us was something that we shared with them. So obviously we weren't seeking that. And then the other two things, I believe were both from 2020, which post-date the period of time, or at least the majority of the period of time that we're looking for. Because again, we're really focusing on, the fact that we want to, either prove, or if there are documents, disprove our assertion that the eco nozzle was never the original purpose of the R&D. So those documents go back to the earlier dates. So I guess technically, I'm trying to pull up the subpoena right now. So I guess technically it may fall into the latter part of the time period, but no, they really don't go to what we are seeking by the subpoena.
I did see a 2018 letter from Randy Matsuma to you guys. So anyway, so the other question I had is, I think you mentioned a few times that the fees were refunded and took a while to get it. Did you get a correspondent letter with the fee refund, citing the reasons for the refund?
I don't recall. Mr. Henderson may recall. Honestly, I don't remember. I don't think we did, but I don't want to say that with 100% certainty. I think we just got a check, but well, let me take a step back. I'm sure there was a letter enclosing the check. I don't think the letter spoke to anything of substance, is my recollection.
It did not give the reasons for the cancellation and the refund?
I don't believe so.
Okay. All right, that's all I had. Thank you very much.
Thank you.
What's in there?
Oh, sorry, I have to mute Ms. Verdugo Peralta. With regard to Ms. Manwaring and the documents from Ms. Manwaring, do you have any reason at all to believe that when Ms. Manwaring was speaking with you that she was not representing the district?
I mean, she worked for the district, so I knew she represented the district. I did not take it to mean that, I did not think that she was, I guess, if you will, acting in kind of a prosecutorial role at that point.
Right. So did you have any, I don't remember if it was you or Mr. Henderson, when asked about Ms. Manwaring originally, had said that when you first met her, that she introduced herself, or she was introduced as counsel for the district. Do you have any reason to believe that she was not acting as counsel for the district at any time?
I knew she was from the legal team. Yes. Again, we did not think or presume that she was, contacting us, I guess. Well, how do I put this? I guess I'll just rely on my last statement. Yes, I knew she was an attorney for the district, but again, we thought that at that point, based on the communications that we had with compliance, that it was to, yes.
Anthony? Let's all mute ourselves very I don't know what that is.
I don't either, and I don't know where it's coming from. It's not directing me. Let me try.
I was going to say the only one not muted is Mr. Groffman. I wonder.
Ah,
there we go.
Yeah.
It was Mr. Groffman.
Mr. Groveman, yeah.
Mr. Groveman. There's an issue on Mr. Groveman's end. Okay. Groveman, every time you unmute yourself. Perhaps Mr. Groveman needs to leave the hearing and come back. Can you hear us, Mr. Groveman? Mr. Groveman, if you can hear us, perhaps you need to leave and come back in, because it seems to be on your end. We'll wait for you. You are muted still. Did you want to try that one more time? Hold on. Mr. Groveman, are you able to hear us? I don't know if he hears us. If you hear us and you'd like to leave the meeting, please just indicate that you'll leave the meeting and come back in.
Chair Prusak, I just spoke with Barry. I told him the issue that he needs to close down and restart, but he does need to he wanted to say something. So I think he's going to try and do that.
Okay.
Sorry about that.
We'll look for him to come back. I'm looking out for Mr. Groman. I still do not see him yet. Sounds like he's back. I'm gonna mute. Mr. Groman, perhaps you need to call in if this is continuing to be an issue. One of those very unfortunate issues of having to have Zoom hearings.
Chair Prusek, I will call him and just let him know that he has to call in. Do we have the phone number easily accessible?
It should be on the agenda. Is that correct? Okay.
Okay.
So if he doesn't have the agenda handy, let me know and I will give it to him. Then
All right. Just a minute.
It looks like he's dialing something right now, so maybe he's calling in.
I think he's talking to Mr.
Oh, maybe.
Hold on.
Is that the number 714?
No, that's Cynthia Verdugo Peralta.
What's the issue?
Do you want,
She's unmuted.
Julie, you want me?
No, we're trying. Mr. Groveman had a glitch. Mr.
Yeah, I heard that there was a message that came across verbally that said they wanted me to unmute.
All right, Madam Chair, he's going to stay on mute. Can you hear me okay?
You can go ahead.
He's gonna stay on mute. Okay, so how will he address the board? Did he want to address the board? Is that?
What's the process here? He had a follow-up question to one of your questions.
Oh, he wanted to redirect.
Yeah.
You can, I mean, we're pretty much informal if, when we're on questions, once we're up to questions.
I'll just ask Joe the question. Joe, in regards to your communications with Ms. Manwaring, do you believe that she, without going into any detail, do you believe that she had some sort of personal perspective over your company's operations, as you've testified earlier?
I do. I've heard Ms. Manwaring say that, she doesn't want our operations anywhere near, let's say, like a school where one of her kids are. So that statement was made in a meeting. I actually believe that you may have been in that meeting, Mr. Height. But then also just generally speaking, just I'll give a quick example. There was a conversation that we had about, again, somehow we got into some of more the environmental characteristics of mobile fueling. One of the things that we had mentioned that where we thought that mobile fueling had a clear advantage over the gas station was the fact that we used, we use trained personnel in the actual fueling. It's essentially a full service station with people who are trained with how to properly fuel, meaning, you keep the nozzle inside the tank for an extra 2 seconds after you're done fueling to make sure that there's not any drips. We use special hydrophobic mats on the ground to catch any drips that may actually fall out of the nozzle, again, using, and then using a similar pad in their hand. So, we were just making the point that, well, clearly that's a, clear advantage over the gas station. And I don't want to specifically quote her, but she said something along the lines of that she did not think that that was a huge distinction over the gas station, which struck me as just kind of contrary to common sense and logic. So nothing that I would say that we heard or that I heard from Ms. Manwaring seemed to express any sort of, potential, like, frankly, open-mindedness to the potential value of our type of operation. And everything that we heard seemed honestly to kind of support the negative.
Okay, but yes, I was in the meeting, but she specifically said that she was worried that your operations would be harmful to her own children at a school where you might be operating near.
Correct.
Okay, all right, thank you. That was it, Chair Poussa.
Okay, and my question, thank you for that. My question was more along the lines of, in order to have this board issue a subpoena for documents that you've requested, emails, memos that were sent to and from Ms. Manwaring, one of the 3 things you have to prove is that they're not privileged. So I'm trying to understand if you understood that Ms. Manwaring was acting in a capacity as counsel for the district. What is your argument for why those are not privileged documents?
I feel that during our engagement with Ms. Manwaring, yes, I knew that she was an attorney. But if it was going to be adversarial, we were never notified of that fact. We were never instructed to procure counsel. And the nature of our engagement with Ms. Manwaring went so far beyond things that are specifically legal, again, into like the environmental, qualities of our operation and whatnot, that it felt that, I'm sorry, can I finish?
Because I have it's more direct. Okay, so your request that we're considering today is for Karen Manwaring on page 4 of your application for the subpoenas, all emails and memos from and to Ms. Manwaring regarding her work related to Booster and a particular time frame. And I'm trying to understand why. I'm not asking whether you should have been represented by counsel. That's a wholly different issue. My question is, why are emails and memos from an attorney to an attorney not privileged? If it was your...
Who's the other attorney in this equation that you're coming up with?
Ms. Manwaring is the only...
No, you said from an attorney to an attorney, so Ms. Manwaring and whom?
Meaning you're asking emails and memos from and to Ms. Manwaring. So I'm reading your language. It says, all emails and memos from and to Ms. Manwaring regarding her work related to Booster. So my question is, so that's why I'm saying from and to an attorney. How, if your testimony was that you have no reason to believe she was not acting in a role representing the district, why is that not privileged? What you're asking for, not your conversations.
Well, I'll leave it to our attorneys to ultimately make the legal argument, but my legal experience does tell me that that attorney-client privilege is not a complete bar, especially if what it's designed to prevent the release of may actually be some evidence of misconduct, and clearly we think that there's some misconduct going on here.
All right, so that's okay. So, okay, thank you. I just wanted to understand because that's something that that you are required to prove as well for that. Senator, you have questions regarding the subpoena. Okay, I've taken care of that, but Senator, you are muted.
Mr. Obuko.
Yes, sir.
The type of R&D that your company is involved in, you mentioned there are other vehicles distributing fuel in the area that were not certified. Were they bandits? Would they be classified as a bandit?
I mean, the term that we tend to use internally are wildcatters. I think bandits works as well, sir. But the bottom line is that, you know, whether from a fire perspective or from an air quality perspective, our experience is that they are not trying at all to work with regulators and are essentially trying to operate under or, you know, under the regulatory radar, if you will.
Are you aware whether or not AQMD is certified, cited these individuals?
I'm not aware of any citations issued by AQMD to any of these companies.
Again, please, let's keep to what we're hearing about, which is the documents and
I understand that. I'm just saying,
their relevance.
you know, give you some background information. When the Air Resources Board was created, I was there and voted for it. Tom Quinn, I know you cover your face now, Tony. Tom Quinn was the first chair. But he was not autocratic. I mean, the fact of the matter is that we had nice meetings. But let me just ask you another question, sir.
Yes, sir.
Air Resources Board is supporting the continuation of the R&D that you're performing in this area.
Correct.
You have 5 vehicles ahead, at least, that are operating in Orange County.
Correct.
Do you have any such vehicles dispensing gasoline operating in LA County?
No, not at the moment. We are, well, I'm sorry, do you say LA County?
Yeah, LA County, Orange County, LA County.
I don't, we may have a count or two in the southernmost part of LA County. LA City specifically, no, because we have been waiting for the city of LA to issue, I believe, what will be its first ever mobile fueling permit. And, you know, for what it's worth, you know, in a conversation that I had with one of the fire marshals there the other day, they repeatedly expressed gratitude for the fact that we were, you know, waiting for them to actually issue a permit instead of just going out and operating like all the other companies are doing.
Somewhere I read where they were requesting 6 additional vehicles for the study.
Right.
Because it would give them more complete data. Is that correct?
Yeah, so that's correct. And I wanted to be super careful because it's possible that there may be an account or two that is on the, like, basically right over the Orange County line. But for the most part, you're exactly right. We are constrained from operating in the greater LA County area due to the lack of vehicles that we currently have. So that is accurate.
And based on what I read here, that at some point in time, AQMD did approve the additional 6 vehicles. Is that correct?
I mean, that's what we thought.
And they brought, therefore you brought, you gave them, they paid for the permit, did you?
Correct. Also, we paid for all.
What you thought what they thought, and they took the money and you gave it to them, correct?
That's correct.
And somewhere I read where you brought an additional personnel to operate these vehicles.
Absolutely. We did not have, we call them service professionals, the people who, you know, have hazmat licenses and commercial licenses to drive these tankers as required by law. You know, we had to basically double the amount of personnel that we needed to drive them. And then I believe, and I'll double check this, that we ultimately probably had to let them go because of this issue that we're talking about here. And those 6 tankers sat in our yard, essentially gathering dust for more than a year.
And it was sometime after the district said no, they were not going to certify or permit these additional vehicles, even the 5, that they, maybe a year or 2 before they give you your money back, correct?
That's correct.
In your mind, question, is that disingenuous?
I think that's an excellent word for it, frankly, sir. I think that sums up a lot of our dealings and I don't say that lightly. I say as the chair pointed out, or someone pointed out, I guess it was counsel for the district, I am a former attorney. I've actually worked as a regulator for 6 years. I do understand the difficulty of, trying to get old laws and regulations to wrap around new models and innovation, but, I've never experienced anything quite like this.
So it was February 14, 2018, CARB issued a booster letter proving
That's correct. Yes.
the R&D.
I just want to double check the date, but that sounds right. Yes.
Which clearly indicate to you, your company, and also I hope to AQMD that they're supporting this program. Is that correct?
Yes, and based on our very regular conversations with CARB, I believe that we are expecting the executive order for, essentially, I don't want to say it's for our company specifically, but it's definitely modeled like pretty much 100% on our tanker builds, our equipment, our operations. We are expecting that executive order to issue within a matter of possibly, 3 to 4 weeks, maybe even sooner.
Executive order from CARB?
Correct.
Is it your opinion that CARB is supporting this R&D process to improve the emission?
My apologies, Senator. I didn't want to cut you off.
Could have an effect on the emission levels in this area. That's why they're supporting this project.
Yes, and if I'm paraphrasing here, but in a conversation with CARB staff, one of them said that they actually felt that this could even be, better than phase 2 in terms of the environmental impact. So yes, they are supportive.
Is CARB aware? Have your company reported to CARB the difficulty you're having for cooperation, or the spirit of cooperation in the AQMD area?
I believe they're aware at a high level. I don't know how many details they have, but yes, they are aware that there is a conflict.
Well, whatever it takes to clean up this air.
Yeah, and not on the appeal, but we'll get there, maybe. I do want to point out the time is now 2:45. Sorry, 3:45. It's very clear, once again, we will not be finishing this hearing. This will be the last admonition I will make, requesting that both the parties and our board members, please simply focus on the subpoena request and questions having to do with the documents that are being requested, not on the appeal, or we will be arguing this appeal for the next year. So board members, let's see if we can at least finish Mr. Opaku. I don't want to argue this. Are there any other questions for Mr. Opaku with regard to the subpoena request? Okay, Senator.
No, okay, thank you. Mr. Opaku,
yes, sir.
Why do you need these documents?
We don't, I think that we need these documents to shed some light on what really happened, what led to the district trying to claim far after the fact that the purpose of the R&D permits was something other than it clearly was. Literally, the district is the only party that is claiming that it was about the eco nozzles. We've requested verbally over a year ago for any sort of documentation that would support this. It seems to me it could be quite easily put to bed if there is some clear memo saying that, oh yes, the original purpose of the R&D permit was in fact the eco nozzle, but we've never seen it. And yeah, I don't know how else to say it. Something is going on that we don't have visibility into.
If you get these documents, what do you do going forward with them?
Well, I guess it's our expectation that these documents will confirm our assertion that the original permits were never intended to study the eco nozzle, And if that's correct, then I think it's a kind of like a game of dominoes. Everything about the district's arguments stems from that original purpose of the R&Ds. And if they are not being forthright about what the purpose is, then I think everything that has happened subsequently must be looked at with a bit of a, I guess, skeptical view.
We're going to look at it. How can you convince them?
I don't know.
Okay.
Okay, one final question, ma'am.
Any other questions with regard to the relevance of documents? Go on.
Mr. Opuku, when I heard him testify, that those NOVs were given to him. He did correct himself in saying they were not initiated, not generated by the attorney for the district, but they were given to him from the attorney for the district. So that clears the record, I think, in my mind.
Yes, sir. That's what I thought I said. If I play this back and realize that I said something different, then my apologies, but I was not intending to imply that it was Ms. Manwaring specifically who was like drafting and signing off on the NOVs. Frankly, from our perspective, that doesn't even, like, to us, that's frankly not even relevant.
Okay, thank you. Any other questions, board members, with regard to the subpoena for Mr. Okpaku? Yes, Mr. Height, you.
I just wanted to clarify an issue. You were talking about Ms. Manwaring's documents that we've requested. In the normal course of events, all documents are produced, and if there are, and put them on a privilege log, and those issues would be resolved after that. We don't intend to seek documents that are wholly privileged communications between a client and their attorney, but they do, or they are required to produce a privilege log.
If the subpoena, okay, if the subpoena issues. I was merely, again, I wanted to share my screen. I was merely referring to Hearing Board Rule 9 with regard to the 3 findings we need to make, one being that the information is not privileged before we issue a subpoena for it. But
we're not seeking privileged documents, but they would be required to prepare a privilege log.
okay. Oh, sorry, let me stop the share. Try to stop the share. Okay. Okay, board members, any other questions for Mr. Okpaku? Okay, thank you, Mr. Okpaku, for your testimony today and also on the 27th. Mr. Height, I know Mr. Groveman is having that glitch, but did you have any other witnesses that you wished to present?
The only other issue we were going to address was to have Mr. Henderson clarify some issues about the notices of violations, but I am not sure if that is permitted under your sustaining an objection regarding NOVs.
The only objection that was sustained was the question as to whether other jurisdictions were or were not issuing NOVs with regard to other permits that Booster may or may not have. But questions with regard to NOVs, you may ask with regard to the NOVs from the district, and in particular, since you're asking for compliance records. So if you want to clarify any of that.
You want to start that today?
Sure, we have 10 more minutes. Let's.
Okay. Hi, and Mr. Henderson, I'll refer to you as Taylor just for purposes of ease of reference. In regards to your activities at Booster, were you familiar with the NOVs that were being issued to the company by AQMD?
Yes, familiar and directly involved with each.
Okay. With respect to all of these NOVs that were issued, did they all pertain to Booster's operation petitions
You cut
under
out.
a research and development permit?
Oh, you cut out there, Ryan. Is that, I don't know if that's on my end or your end.
No,
I did
it-
not catch.
It's on Mr. Height, on your end.
Okay, we're all. Can you hear me now?
Now, but we didn't hear it if you repeat the question because we didn't hear it.
Okay. I don't know why I'm having the issue suddenly. Were all of the NOVs issued while the company was operating under a research and development permit?
Yes. Or,
Okay.
excuse me, one of them was issued while operating under stipulated order of abatement.
Okay.
You're cutting out again, Ryan.
Just
You are glitching.
fast forward.
Can I turn off the video?
Mr. Height, do you want to try turning off your video?
In October 2020.
Try that again. Can you
Can
try?
someone just read me the, can someone?
Mr. Height, I'm
Yeah.
sorry.
Does that help?
Yeah.
Does that
Yes.
help? It does? Okay. Fast forwarding to the future. In October 2020, Booster Fuels was issued 5 permits by the AQMD, correct?
Correct.
Were all of these NOVs still outstanding when the permits were issued?
Yes, all but the dome hatch and NOV for the dome hatch and the NOV for eco nozzles.
Okay. Do you believe that these NOVs were of such significance that they wouldn't issue you permits to continue to operate?
You kind of cut out there again. It was, can you repeat that? I'm sorry, Ryan. It's still doing that.
I have no idea. Hang on a sec. Hold on, please. Now?
Yes.
Can you hear me?
We're still having trouble. So
Okay.
No,
the phone.
You may need to maybe
perhaps given the time, I would say by leaving, coming back in, but we're really very close to the 4 o'clock hour. So perhaps we should do as you had suggested, which is to wait and continue this hearing to Thursday. And we already discussed this during our pre-hearing, but just to be clear, Madam Clerk, we only have one matter. Is that correct on Thursday?
That's correct.
Okay, and I'm not sure, that is not an interpreter, is that correct?
That is correct.
Okay. Then what I'd like to do is place this on the calendar for 10:30. I will hope that we'll get to it by 10:30. It may be a little bit longer, but today we were very close. And we did have an interpreter at 11. So let's do that. And we'll take up the redirect of Mr. Henderson and any additional questions for Mr. Henderson. And then we'll then take it from there. I know that the district has 2 witnesses that they wish to introduce with regard to the subpoena request. In addition, we had set, just in case we finished today, both this hearing and the one of the Karen Manwaring subpoena. We had a pre-hearing conference for 4. Let's continue that to 4 o'clock on the 4th as well. Okay? All right. Hoping everyone is hearing that. I know that Mr. Height was having issues. Mr. Groman, did you get all of that and agree? Perhaps he could shake his head up and down. No? Okay. Mr. Height,
Madam Chair, if you can hear me, I got all the dates and times.
excellent. Okay. All right. Okay, board members, is there any other business then before we adjourn for the day? Okay, seeing none, we are adjourned. Oh, Senator, you had other business? You're muted.
Yes. Madam Chair and members, on the back of the notice for the meeting, there are board members' comment per section code 54954.2. I'm sure you're familiar with it.
Where are we looking? Hearing board or public comment?
This is the district puts this up. It's in the back of each of the notices for each meeting.
Are you referring to public comment?
It's underneath public comment.
Are you wishing to make public comment?
No. A board member can request the district staff to report back at any subsequent meeting concerning any matter, or may take action to direct the clerk of the board to place a matter of business in a future agenda, Government Code 54954.2. Is that right, Madam Clerk?
Yes.
Okay, so I'm officially requesting that Mark, I can't think of his last name, who's been investigating all of those cleaners in the area, come back and give us a status report.
I'm sorry, let me look at, what is the government code section? Madam Clerk.
54954.2.
549, please say this again slowly.
54954.2.
It's of the government code.
Yeah, that's the government code. Hold on.
Did I say government?
Yes, you did say that. Oops, hold on. While we figure this out, by the way, I'm closing the hearing that we were, I don't know if the parties are still present, but the hearing is continued to Thursday at 10:30. Can you, I'm just looking, I don't have that language. Is that on the bottom of our hearing board agenda that we get every day?
Every
Yes.
day.
All of them?
Yeah, it's right below the public comments where it says board member comments before closed session. That's the blurb that he's referring to.
I don't seem to have it handy. I have all the hearing board agendas, but not the back.
Madam Clerk, will you read it to her, please?
It is just as he said. It's any member of the hearing board may make a brief announcement or report on his or her own activities, provide a reference to the hearing board regarding factual information, request South Coast AQMD staff to report back at a subsequent meeting concerning any matter.
Use the word any matter.
Okay.
or may take action to direct the clerk of the board to place a matter of business on a future agenda.
Okay. Okay, so you would like under that to request that, what specifically would you like to request? And I
Mr. I can't think, Mr. Can't
know,
think,
I'm sorry, I just want to say, I know we have several members of district council present. So what is your request?
requested. Did you know the name Mark, who does all the investigation?
Mark Vonderow?
Right, for the cleaners, to appear before the board and give a status report on outstanding.
Status report on outstanding on, is your question a status report on those who still have outstanding permits for perk machines?
If outstanding permit, we have about 2,000. So what about the ones that, I want a status report on all cleaners. Some of them do not have permits, obviously. Let him tell it. I want to hear from him.
But what are you, okay, but we have to be specific. What are we asking him to report back on?
On the status of all the cleaners that he has access to.
What do you mean? Does he have to go through every single cleaner in the South Coast and tell you whether they have a hydrocarbon machine or a perk machine or a this machine? What exactly are you looking for?
Well, when he come here, I'll ask him.
Well, he needs to know.
Sorry, can I interrupt? This is Sherry Hani-Zavara, attorney for the General Counsel's Office. A similar request was made last week by Ms. Verdugo Peralta, and we've elevated that request to our supervisor, and they're currently considering it. I hope that answers the question, but
I don't
should be.
That doesn't answer the question.
Does
The
that
fact that per this section code,
Mhm.
a board member can make this request and the district cannot deny it
Doesn't say that.
by law.
That's not what it says.
I don't believe that it says that we can't deny it.
Can you again, I'm sorry, I'm gonna have Miss sorry, Teresa, can you just read that one more time, that relevant portion?
Okay, the relevant portion that he's talking to, it says that they want to request the South Coast AQMD staff to report back at a subsequent meeting concerning any matter. It doesn't say that district staff has to comply with that, or it doesn't give a time frame.
Okay.
But the board members can make that request.
Okay. And
By what purpose? By what government code can they make that request?
Well, the government code section is 54954.2, but it does not state in that the district staff has to comply with that request. The hearing board has no sanctioning power, so there's no way you can make the district, unfortunately, do anything. We can make a request and they can choose to comply or not comply with our request.
That government code section is with regard to the agenda and what needs to be posted, and the timing of posting. It does not say anything about having authority over district staff.
Exactly.
So you're making the request. I would just like it if you could make it as specific as possible so that the district hears your request.
Well, I want them to report on the number of cleaners that were permitted and the ones that he's aware of that are not permitted. The report he gives is that roughly 2,200 operating in the district. That being the case, I need an explanation. I'd like to have an explanation on the ones that are not permitted compared to the ones that are permitted.
Okay. And Ms. Hani-Zavara, you said that Ms. Verdugo Peralta made that request. Was that during a hearing? I don't recall that.
Yes, it was at the end of hearing last week. She made a similar request, and we did elevate it at that time. So it's the decision is currently under consideration, but we don't have a definitive answer for that yet.
I do not recall Ms. making that request.
Yeah, I think she did. I remember that at the last. But I think, Senator, the one thing I want to mention is the district is not able, at coring its database, to find out who hasn't applied for a permit. There may be quite a lot of cleaners out there operating without a permit or didn't apply for a permit. They will not be able to query that from the system.
Let the district, I will remind you, let the district make the statement, number one. And number two, Mark did mention there are 22 cleaners out there in operation. He gave us that number in the report. Did he not?
Yeah, that number came from the staff report, I believe. That mentioned that.
Mark, he's the staff. It came from him.
No, I meant the staff report, right? The staff report for that supported the rule adoption, or a rule amendment, I should say, in 2002. So you've made that request, and so has Ms. Verdugo-Peralta, and the board hopes that we will receive a response as the district is able to. Thank you for that.
She's not listening to the copy.
Okay. Board members, any other business before we adjourn for today? Yeah.
Hi, Madam Chair. I had a question regarding one of the petitions that we'll be reviewing tomorrow, the Bonded Boys, Inc. Do we have that? Was that petition sent to us? Or, I can't find it right now.
Yes, we received that petition in a packet of the February petitions, the bigger packet that had the agenda for February and all of the petitions for February.
Okay.
And if you don't have it, then you can get it off fine.
You got it. Thank you.
And there are a lot of, right, the Bonded Boys, that's one of the two that had a lot of documents attached to the petition.
And additionally, the clerk sent some more documentation within the last hour.
Oh, okay. Thank you. That's good to know. Board members, make sure we're checking email before tomorrow.
But for both cases, for tomorrow.
Okay. Okay, we'll be back tomorrow. I'm glad we raised that. Any other business we should discuss, board members, before we adjourn? All right, wonderful. Okay, let's rinse and repeat tomorrow, and we're on for 9 o'clock. See you all then. Thank you, Madam Clerk. And thank you, whoever's on, Anthony or Paul. Thank you very much. All right. Thank you. Thank you, Mark.
You're welcome.